hello. You guys are doing good. Hope y'all are doing well. Happy Tuesday. Come on in. Come on in. Let's see who we have in the building. I hope you guys are all starting your Tuesday off really, really well. Let's see who we have. We have Kathleen, who was first today. Good to see you, Kathleen. Hello to Lauren. Look at Superwoman, who's in here. Seven, is that how I say your name? Seven is in the chat. Supermom is in here. So good to see you guys. Annette is on here. Yes, we're going to have, I think, some TiVo time, Annette. And so here's our plan. So we're going to have a nice chat with a forensic data expert. I've been waiting all week. I'm so excited for that. So we're going to have a little chat with him. And then, of course, we will jump into the feed. Now, court's not going to be starting for a little while. I believe they said 12:30, so we have plenty of time to hang out here, do our little pregame show, and then go from there. Shout out to Dee. Dee says, where's Brian Steele's opening statement? Well, we've got some time to kill. Lead and I actually went through that. So if you guys want to go into our archives and check out our reactions, we totally have time to do that. Dirtwork says, AV acted like the state yesterday. Well, sorry guys, I needed to make sure I had my coffee, all of that stuff. So I made an extra cup because this was running low. So I'm like, all right, let me make sure I have everything I need. And of course, sound checks, mic checks, all of that. Some of y'all complain about this mic all the time. So I had to balance it, all of those things. This is a production. This is a director, a producer, an editor, all of it, and a talent. That is a lot of work. So yes, I apologize for being a few minutes late, but I'm so happy that you guys are here, stuck around, and stuck with me. Shout out to Jason. He says, AV is always late straightening her hair. Well, I just went with some water and conditioner today because sometimes that can be easier. Hey to Bayron says, I don't recall AV being late. Yeah, y'all don't like it. Micah says, AV did these crimes. Y'all are so funny. Yes, I'm super excited. Here comes the drama. This is going to be really informative. We're going to talk about all things forensics today. And really, I was thinking about this last night and really how I wanted to approach it for y'all to not only learn something, but take something away. A lot of the times you'll see our court reactions where we are reacting to what we're seeing in the trial. But I think sometimes there are parts of the law that are super important. So for example, when I was in law school, one thing that I found very valuable was trial team. Okay. Being on a trial team. What does that mean? That means that you are learning how to become an attorney by actually being in a courtroom and going against other law schools and thinking on your feet. And they had us act out everything. They had me as a prosecutor for a little bit. Then they put you on the defense side. Then you're a defense attorney for a little bit. Then they even had you on as an expert witness. So that was a lot of fun. The case that we did, I think it was mock trial, was the Aaron Hernandez case. And I played all of those roles, but one of my favorite roles to play was the role of an expert witness. Why? Because I had to memorize everything. So much about expert witnesses is they're almost bulletproof witnesses because they know their stuff. They're qualified. They have the necessary requisites. They have the education, the training, the experience. When you hear an expert witness, you'll usually hear us qualify them. And when it comes to the federal rules of evidence, that's one of the things that we need to do is qualify your expert before they get on the stand. And when it comes to experts on the stand, it's really interesting because even if you try to cross-examine them, what are you going to cross-examine them on? Mistakes in their analysis. So it's really, really amazing to be able to talk to an expert today. Let me go into some super chats real quick, and then I will bring our expert up. Oh my gosh, it is green in here today. Wow. Apparently YouTube must have fixed the join button because I see nothing but members. Shout out to Edgar, who became a member. Welcome, Edgar. New brother to this channel. Really, really happy to have you here. Shout out to, and this is weird. I don't know if these are from yesterday. Did you guys become members yesterday? Some of y'all have become members today because Edgar, I remember you becoming a member yesterday. Jeremy became a member yesterday. Here comes the drama. I definitely remember her becoming a member yesterday because she gifted 5. Weird. Shout out to Gigi, who became a member. This looks like after I was streaming yesterday. LaShawn became a member. Rocket Queen. I remember her becoming a member too. This is strange. Shout out to John. Oh, you know what it is? It's because I had both streams scheduled at the same time. Huh, that's what it is. Shout out to John, who became a member today. Welcome, John. Welcome to the community. Shout out to Shirley, who became a member this morning at 6 a.m. Welcome to the community, Shirley. And then My Journey, My Experience, SDR. I feel like you might have sent me an email or something that I've seen, but of course, I'm getting up to speed and starting in the morning. Thank you so much. My Journey, My Experience, SDR. Really, really appreciate you. Okay, I think I see my expert in the back. Spencer, if you're back there, can I see your camera? Can you try the camera? There you are. There you are. All right, guys, listen. So I'm going to bring our expert up. I'm going to allow him to introduce himself. I met him in the lead attorney community, had a really amazing conversation with him yesterday. I'm going to go ahead and bring him up and allow him to introduce himself. Welcome.
Hey, V, how are you?
I'm great. Tell people a little bit more about you.
Yeah. So digital forensic expert. I deal with cell phones mainly, a lot of location evidence, cell phones in general. So anything we can gather from the device and from those records. So we're looking at locations, we're looking at content, any of that. So that's what I do day to day is look at cell phones.
That is awesome. What made you want to get into the field?
I was previously in law enforcement. So in that role, we use cell phones for everything. Cell phones were, as common as surveillance video or DNA or anything like that. It's in every case, really, just because everyone pretty much has a phone now. So these items are, they carry a ton of evidence.
Interesting. So tell us a little bit more about your journey. So you said you were in law enforcement. Were you a police officer, detective? How long were you in law enforcement? And tell us a little bit more about that. Not an easy job.
Did just about everything at our sheriff's office. So started out, I did nearly 10 years. Started out in corrections all the way up until working on a violent crime task force. So dealing with murders, robberies, all of the things that you've been hearing in trial. So throughout that journey, learning, everything about investigations and then rolling that into learning digital forensics and applying that to our investigations.
Okay, got it. So you're in the South, right? Is that right?
I am. I'm in North Carolina.
Awesome. And what's interesting is you have a little bit of experience with Fulton County court system. Do you know?
I do. I've worked both prosecution and defense cases in Georgia, civil cases, criminal cases, pretty much everything in Georgia. They're very close to us, so we do quite a bit of work down there. And so yeah, I've had experiences on both sides in Georgia.
Awesome. Well, I'm so interested to dive in, because I think some of the things that we see when we're watching the trial is we're not really realizing how much work goes into it. And I don't think that a lot of people have really an understanding of what an expert witness does, what the preparation is to go into something like that. You guys are paid fairly well from what I see. So we know Spencer is getting that money. But what's it like being an expert witness? Like, what is the day-to-day like? And tell us more about your company, because you run a company doing this. Is that right?
I run a team of examiners. We are a very large company. So I have a team of examiners. I work on a great team. We have some of the best experts in the nation.
Wow.
I was brought on and mentored by 2 of the best, and we've grown our team. So, but yeah, expert witness work. Day to day, my job is just like you, when you were an attorney, your job is to counsel your client through this complex process, get them to understand how to make decisions, what are good decisions, help them understand what it is they're doing. That same thing applies to what I'm helping you do. So these cell phones, all this data is very complicated. I help you understand that data so that you can better advise your client, as well as navigate, the various technical issues. It's my job to keep up with, emerging technologies, cases that are currently happening, so I understand how this data gets applied in various cases. And then how it's commonly presented, kind of the way that this, you and I came to speak about this was from as they started to speak about cell phone records
Yes.
in the YSL case, and some of the things that, I immediately hear when they start talking about it, and lights start turning on, and I'm going like, I don't know, that doesn't sound completely right. And I'm sure we'll dig into that part,
Oh
but
my goodness. Yeah.
that's the part of it that we take care of, is consulting you guys through understanding this data. And then ultimately, if we get to the end and it's in the middle of trial and you need testimony, that's what we come in and provide that information, that understanding, and education to the court as well. So whether that's in, an evidentiary hearing outside of the jury, providing that information to the judge so they can make a decision, or transferring that over, going into a jury trial and getting them to understand so that they can make their ultimate decision.
Yeah, that's such a good point, because what it reminds me of, and I'm not sure if you've followed the Fonnie Willis Nathan Wade situation at the start of the year. I remember cell phone analytics coming up, and this is when they were looking at cell hawk data. And so when you reached out, I was like super pumped to have you on the show, because it just reminded me of cell hawk data, and just kind of thinking about the triangulation where a person is, because there's cell phone towers, right? Because the big debate was Nathan Wade at Fonnie Willis's house at 4 o'clock in the morning? And we used cell hawk data to do that. I remember Steve Sadow, Donald Trump's
Yep.
attorney, hiring an expert, an expert. I think he had provided an affidavit, but that affidavit had to talk about how cell hawk data how it's used, but it's commonly used. And I
All the
saw,
time.
at least like the state or Fonnie Willis's team say, "Oh, it's not that accurate," but you use it all the time. So I don't know.
So I'll
tell-
give you
Go
the
ahead.
background. So when you're looking at cell site records, one of the things that they are good for is talking about consistencies. All right. So
Mhm.
when we're talking about where towers are located, towers essentially, I guess we'll step back just a second. So in these records, what they provide us is when we make transactions on the cell network. So not over Wi-Fi, but when we're actually using, say, Verizon or AT&T's network, our phone is contacting the towers to make these transactions. And when that happens, the carriers are recording this information. It provides a tower location, and it provides other details about the transaction as well. So what we generally know from these records is where the tower is positioned and what direction the portion of the tower that you use faces. With that understanding, based on the other towers around it and other information that we have, we can understand the approximate location of a device. And so when we're looking at, for example, if we were to look at towers surrounding a particular home or a particular address, what one would be able to say is that it is consistent with a device being at that location if the transaction is using this tower. What you're unable to say is that this phone is at this address. All right. So there's some, it's helpful data. It can help us understand if someone says, "Hey, I was over here, not over there." We can look at the data to understand, is that true or not? Is that consistent with the alibi or the information that's being given? Whereas, the state will commonly use this information to say, "Hey, we have a crime that happens here at this time. At this same time, we have a phone call that originates from this tower. That tower provides service to the area of this location." That means it's consistent with that. Whereas if it was across the state at the time or on the other side of town, they would say it's inconsistent. It could not be there. So that's how those towers are used. So when we get into the accuracy of this information, the data itself is accurate data. Its application is generally where someone like me and someone else like me are going to argue, where you guys are going to argue with the defense or the plaintiff, the prosecution. Where that fight occurs is commonly within the interpretation or the story that is generated around these records.
Gotcha.
So the data itself, there are pieces of data that we have to look at for accuracy issues. There's information we have to validate. We have to go through and do certain processes to ensure this data is good. But in general, yes, historical cell site location information has been used everywhere all the time. It's been deemed reliable and a reasonable piece of evidence in everywhere.
Gotcha.
So,
And has that, just out of curiosity, has that changed over time? Because we're going to talk about the cell phone data here and the YSL data.
yep.
I know you guys are like ask him. And I do see questions in the chat. So as I, if you have any questions
Okay.
for myself or Spencer, guys, just know that I'm going to be starring them, and we'll ask those questions and get them answered towards the end. But one thing that came to mind, because we would be looking at cell phone records from 2015. Now, the data that's recoverable from 2015 versus 2024, is that the same? And what types of data is recoverable from these cell phones?
Generally, yes. And let's step back one more time. All right. So we're going to look at cell phones in two ways. All right. The cell phone itself, and then the records that we get from other places generated by those phones. All right. So it's a common thing that gets kind of twisted up. People don't quite understand. But there's data that we can retrieve directly from the device. And then there's data that we can retrieve from, say, Google, Facebook, AT&T, Verizon, those. So while they're all generated from, say, that device and the use of it, it's stored in different places, and it can often provide us different information. All right. So from the device, what we're generally going to see is content of messages, the actions of the user on the device, like what are they searching for? What are they doing on the device? If you recall I don't know if you kept up with the Murdaugh trial in South Carolina.
Yes. Oh yeah.
A lot of talk about phones. When they were talking about the iPhone specifically, there are logs within the iPhone that talk about when the device is unlocked, when the screen turns on, when it turns back off, what the orientation of the device is, tons of information. All right, so
so when the phone goes from this way to like this.
Portrait the landscape, yep.
Right, because in the Murdaugh trial, we were talking a little bit about, there was a few pieces of evidence that was super key in that trial. So the Snapchat information that came from, I think, the Sun, right? Yep. When a phone was tossed, because you guys were able to look at the portrait to landscape, which is super, super interesting. But what I think would be relevant in this case is the social posts as well. Yep. Yesterday was absurd. Like, I could not believe that a meme was coming in as evidence. Like, like we were all watching, like, are you serious? So what are some of those intricate things that you think the state will try to bring in the YSL case? And what type of pieces do you think will be recoverable from 2015?
Sure. So I would assume that they have gathered a lot of information over the years. I don't think they developed this case in a short amount of time. The thing is they would have had to gather call detail records like we were talking about earlier with those records from the carrier, Verizon, AT&T, any of those. That information has to be collected pretty close in time to when you want it. So if there's incidents in 2013, 14, 15, generally you have about a year to get those records. So if you wanted 2015 now, you're not getting it. In most instances. So if you did not gather it then, you don't have it. Whereas things like social media, things like that can live much longer. Google records, all of that. It just is dependent on if the user maintains that information. Did they delete that account? Did they delete some of the data? Did they delete posts? Things like that. So I would see they are going to look at whatever records they have. We clearly know that they have wiretaps, Title III wiretaps. I would assume that along with that, if they have wiretaps, they're going to have PIN register data, which is like the live version of historical records. So we're getting to see who they're talking to, where they are, all of that information essentially live on the computer. What is happening right then. So that information gets gathered as well. Obviously, there's a ton of social media. We've heard that for days now about different posts, the issues with hovering over to get dates. We can touch on all the issues with that.
Yeah, the hovering thing, that was, because there was two things that just came to mind that I wanted to ask you about. Let's start with the hovering thing, because I know that this audience saw a little bit of that yesterday, and we saw that on Friday as well. And just for those that are unfamiliar, what we're talking about is DA Love was trying to get a piece of evidence in, and what it was a social media post. For some reason, she had two versions of it. One was a straight social media post with the date of the posting. The second thing she was trying to get in is a copy of that, but it had somebody's mouse like hovering over. I think it was Mr. Sprinkle. I like saying that. Sprinkle's a funny last name. But Sprinkle had, it was either him or someone else in the office had hovered over the photo, and it showed a different date from the posting date. I don't understand why they would want to bring that in, but what's your take on that, Spencer?
All right. So what is happening is they are looking at social media posts on the computer, and then they are screenshotting those posts to use as evidence.
Okay.
I can't say it any clearer than this. Screenshots are not evidence, and this is a perfect reason why. When you see that they have to explain why there's a different date on it, why you have to explain why it looks a certain way, why this is different, and why we're going to present this to the jury versus this because it may confuse them. All of these things, there's a reason that they're not evidence, and it's for this reason. It's because they can't be validated. It takes someone to explain. It takes a prosecutor to explain how they came about the information or how it was generated. The proper way to gather this evidence is to look at the screen name and you say, hey, this is, whoever, YSL, whoever.
Yep.
Go to Instagram, go to Facebook, whoever this is, and serve them with legal process and get the data for that account. It will be returned from that carrier with all of the information, who logged in, IP addresses, the posting dates, which is what they're so interested in, and the content. That way you can present it in court and you don't have Sharp jumping up every time you post one on the Elmo or whatever you're using,
right?
And screaming about what is this? They shouldn't have to ask what it is. It should be clear. All right. So if they would have gathered this data properly and not sat on the computer and taken screenshots, you would have not heard any of this. If anything, they'd be arguing about the search warrant they used to go get it or whatever legal process, if they were going to, or they might just accept like, hey, this is what it is. I'll just argue about the content. The prosecution's essentially opened the door for them to argue that, as you guys have talked about before, this kind of prejudicial versus probative kind of value here, that's where that argument goes. Is if it's going to confuse the jury more than it's going to help them make a decision, we've got to look at whether or not we need to present that information.
I know.
And that's up to the attorneys. But from my point of view, that's the issue with the data, is how it was collected. Had it been collected properly, we wouldn't have an issue.
Right. It is interesting. And I love that you reiterated that screenshots are not evidence, right? Because even some of the pieces she was bringing in yesterday, I couldn't understand how it was relevant at all. But at the same time, it's like, we're trying to prepare, for witnesses to come in, and we have to use it to recollect their recollection to see if they remember posting it. But it's just very, very interesting to me. So thank you for answering the question about the hovering. The other thing that came to mind for me is that a lot of some of the data that's coming in are FaceTime calls. Particularly, I think there was one scenario where they were at a skating rink and it was Shell Kell, an issue with Shell Kell, and another one of the defendants. And there was a FaceTime call that either was initiated by or came to Young Thug. How does FaceTime work in these data collection processes? And what are we likely to see in the trial when it comes to FaceTime calls?
Sure. So FaceTime and iMessage don't go over. They use the outside networks like Verizon or whoever to make the transaction, but they don't get recorded like your regular calls and text messages do. They go through as a data transaction rather than an SMS or a phone call. So they don't show up in those records. So when we're talking about where someone is, you're not seeing this FaceTime call. You don't know that it happens in the records. You have to get that information directly from the device. So what they're going to do is when they do an extraction of someone's iPhone, that stays within the call log, even though it doesn't go across the network in the same way. But so you will see that transaction, who called who, in the call log of the device. Interesting thing about iPhones is that calls, like regular phone calls, they only keep so many in the call log, or historically back in this time, they only kept so many. FaceTimes would always remain. So you could get a very deep history of FaceTimes, whereas with phone calls, you would not. Of course, on the other side of that, you don't get any location information in the records from that, but you may from the device.
Yeah, because I'm curious, like with that particular phone call, how they plan on bringing it in and what supporting evidence they have that the call took place other than word of mouth, So that's an.
So I would say that they would have someone like me who did the extraction of that device. That's going to be about the only way I could see, unless someone's going to say I made that phone call. If it came from someone's device who can actually testify to that. If not, It would be someone like me who would say, I extracted this device, I did an analysis. Here's the information that I found, and here's the phone call, here's the FaceTime. It happened at this time between these two parties.
Okay, got it, got it. Now, I did plan on asking you, and I think you answered this question already, is what cell phone, hang on, I think it's the interpretation of cell tower data, right? We talked
Yep.
about that a smidge, but if you can walk us through the steps on how that works, I think that would be great.
Yep.
And then a follow-up question after you walk us through the steps is how would the cell phone records that DA Love in particular, because I know we talked about that, what are some potential issues that we have? So let's walk through the steps, and then what are some issues that we have with the cell phone data that DA Love is trying to bring in?
Yeah. So for example, I have a phone. I use
Mhm.
AT&T. When I
Mhm.
make phone calls or send text messages, again, outside of like iMessage and FaceTime, when I initiate or receive those transactions, that information is recorded in what are called call detail records. And that information is simply a spreadsheet of your data, date and time that it occurred, the numbers that are in contact. So if you and I call each other, it would have your phone number and my phone number showing that we contacted each other and what those roles were within those records. Further down the list, there will be what's called the cell site location information. That's actually going to give us the position of the tower and then the face of the tower that we use. Commonly, they're going to have three sides. If you end up seeing some of this later on in the trial, you'll see shapes like this that point out into an area to show the direction in which that sector faces. And so from those records, what we're doing is taking those dates and times and translating that information over to a map so that you can visually understand it. Because the records themselves, unless we're looking at just who's talking to who and at one time, they're very hard to understand from that point about where it is, because it's providing commonly just a latitude and longitude of the tower. And when you look at that, obviously, unless you look at them a lot, you may not even know what area that's in. So it doesn't translate. So you have to put it on a map to begin to understand. And what you do is on the map is you're starting to understand the timeline. So you were talking about CellHawk earlier.
Yeah.
That's a tool that allows us to map call detail records and visualize that data. So the data itself comes from different carriers. CellHawk is a tool to visualize that information. So then we can build that timeline and understand where someone travels. Did they go from Macon to Atlanta? Did they travel from Atlanta to LA, and how they made that travel? We can generally understand that. So going into that next piece of how that applies here is that Love brought up that there is going to be, or I believe Brian Steele brought up that there is a new report they just received from the FBI.
Yes.
Right.
Yeah.
That report purports to tell them that there is another person who was in a vehicle with other people that are known in the case at the same time of an incident. The issue with how it was, I guess, the way it was portrayed that day in court is that from that report, that the prosecution will be able to tell them about this other person being in a car at the same time as three other people, I believe, maybe four, through a period of time. And so obviously Brian's challenge wasn't so much to the content of the report. It was actually due to the the tardiness or this report showing up now. And so I'm assuming there will be challenges to the report itself, the content later, but right now it's just a challenge of will it come in or not. But that report is using those call detail records. So like in that example that I gave you earlier, when we talked about showing, is it consistent at a home or a specific location?
Right.
Again, you heard the words consistent with, all right? With what you heard DA Love providing in court was, we can show that another person was in this car. Well, if you recall earlier, I told you we couldn't use these records to provide you with an address. I can't use your records and say AV lives at this home. She was at this address when this happened. All right. It's because that these records just don't go to that level of accuracy. They're providing an area that the tower covers, not a specific address of the phone. All right. So when they're talking about we can show that this person was in the car, maybe the proper way that would have been said in court was that it was consistent with the others who were in the car, this path of travel. Let's say if someone left, north Atlanta and traveled through down towards the ATL airport. All right. That's a good long travel. You would see the towers that gets used as they travel down south through the city. And yes, you could look at those records and possibly say that they're consistent with one another. But there's no way, how would we not know that this person's not in a car following behind them? Or two cars behind them, or, just so happen to be traveling to the airport at the same time, anything like that. So when you say this person's in the car, there has to be other information other than just these cell phone records. Now, if there are text messages that corroborate some of that, and then you put together that the location seems to be consistent going with each other, completely different story. It starts to corroborate each other, provides us more information. But just at face value, call detail records are not going to tell the prosecutor or the court that these people are in the same car with one another.
Okay, got it. That is interesting because I was wondering about that, particularly because we have a scene where they keep bringing it up in court, and that is the scene at the McDonald's where everyone was in different vehicles. They all met up there. So I suspect that they're going to try to place all these cell phones in that location at the same time. But to your point, it needs to be consistent with everyone else and with that time. So it is interesting. And like you said, with this new FBI report, the fact that it's showing up now, and the trial's been on for almost 7 months. When would an appropriate time for something like that to show up? When would that have been?
So I guess it depends on a few factors. It depends on what time frame are we looking at. When did these records come from? I don't know if you're aware. Do we know what year they're referring to when this
2015,
2015 time frame?
Yeah.
If it was 2015 time frame for this, they're together in the car thing.
Mm-hmm.
I feel like that Brian probably has a pretty good argument as to why this is late, because again, like I said earlier, you have to have those. You would have had to gotten those records, received those records from the carrier within a year or so of that happening. So that means you've had these records for a really long time.
Mm-hmm.
Did you just not have someone look at them? Did you just now provide them to the FBI to look at? Did they just not notice that this person was, consistent with the others? So yeah, I feel like it's probably a little late.
Yeah.
If it's 2015,
yeah.
If they were talking about, hey, this happened, 6 months before we started trial and we just received those records, we got these records in middle 2023, or we received them during the middle of the trial occurring, there may be a little more, room there. But if these are old records, I feel like Brian's got a pretty good reason to argue why it's pretty late. It's common for these reports to show up late, but not typically in the middle of trial.
Yeah.
The eve of trial, they get away with it a lot. They'll drop this on you and you go, oh yeah, by the way, we've got these. They'll have given you the records in discovery, but not the report.
Gotcha.
And so we'll end up with these. I just received a call from an attorney yesterday. Hey, starting trial next Wednesday. Just got this report from the government.
Right.
And can you help? So one of my guys one of my team members is helping those guys out because of the quick turnaround. But that's what we get, is those reports sometimes kind of late, not, maybe 8 months into trial late, but.
Gotcha. So sometimes it could be like, at the 11th hour, and that's okay.
Yes.
But I think for something like this, where they've had months and months and months worth of time to prepare for this, and there have been several discovery issues, so this is not the only one that we've seen, but it's super, super interesting. Guys, can y'all do me a huge favor and type Spencer in the chat? He's doing such a great job. Thank you guys for hitting the like button as well. I really try to think about this legal content a little bit differently, and I try to bring other opinions on here. We had Doug Weinstein on, we have Spencer on today, and he is really giving us the benefit of his time and teaching us a little bit about how this stuff works. I am going to go to one viewer question,
cool.
And then we're going to go to some of the other pre-planned topics that we were talking about, Spencer. Let me go to, I think Carl had a really good one. Carl says, question, can it be determined from data that a specific individual was using a cell phone? My premise is, what if someone else used your phone with or without your knowledge?
So these are common questions that we get. These are common defenses that are seen. Hey, yes, it's my phone. I let someone use it, or, they did borrow that phone and now we're showing why it's this person. One of the things we're going to look at is, obviously, phones you can lock your phone,
yep,
or it's unlocked. it doesn't require any sort of passcode. So we'll look at that sort of information. Also look at the complexity of that. I always laugh, if you ever recall, a few years ago, Kanye was on TV and he showing his phone and he punches in a bunch of zeros for his passcode, and everybody's like, oh, his passcode is just 6 zeros, and everybody laughed about that. So how complex is it? Is it, something that someone's going to know? Is it just a couple of numbers that are the same? That sort of thing. So we're also going to look at the content. What are the people doing? Are they, talking to their mom, their girlfriend, and their grandmother on the phone? All right. Who's going to do that? If you borrow my phone, are you going to talk to my mom and everybody else? And then, when they go to speak to her, are they going to go, hey, did you talk to Spencer? Like, no, some lady answered the phone, or no, I was talking to my son. Like, how weird would it be for just some random person to talk to all the people that you talk to, versus is there a change in that behavior? Did they log into certain applications with different usernames? So did you borrow my phone and then log into all your AV7 accounts? Right. Whereas it was previously logged in all of my accounts, things like that. So there are ways to determine that. And then sometimes it's kind of up in the air. You can't really tell.
Yeah. And there's just so much that is tethered to these, it's beyond phone calls and text messages now. Now it's social media accounts. Now it's email accounts. Now it's so much. We're using Face ID to log into things. We're using, we're using the ability to pay for transactions digitally. So that's why I was so curious about 2015 and now. Carl, thank you so much for the question. That was a good one. I'll hit one more and then we'll go back to our regular flow. Shout out to Angie. Angie says, why are burner phones so hard to track?
They're actually not. All right. So burner phones commonly get the rap of like, oh, you can't track them. They're hard to find, things like that. They all have a phone number and they all use the same networks that all of your normal postpaid accounts that have contracts use. So if you go to Walgreens right now and go buy a phone in a box, I don't care what name it has on it. It doesn't matter. It's still going to use Verizon, AT&T, or T-Mobile for the network. They are the networks. All they're doing is leasing space or renting space on those towers to sell you that service. So, again, if I go buy a burner phone and you and I contact each other and then you give up my phone number to the police, or they look at your records and they see my phone number, all they have to do is go look that phone number up and see who owns the phone number. So not do I own the phone number, but does Verizon, AT&T, or T-Mobile own that phone number? Send a legal process and you get all the same records that you would if you just gave them my name. So really no difference. The burner phone it's not so much of a burner. There are ways you can use burner phones to help mask things. But that would, require a lot of effort, and most people just don't do it. They just go get these phones and use them all the time, just like regular phones.
So it's like a myth. And I think a lot of people, people have probably seen these in TV shows and movies, and they're thinking that burner phones are safe. Right. But it sounds like they're not, because we saw little Woody giving phone numbers in his, while he was being in his interrogation footage, he was giving out people's phone numbers.
Yeah, it would be different if you did go buy that phone in the box. You go set it up on a Wi-Fi network somewhere other than your home that you can't be tracked to. And then you use that phone not logged into any of your accounts, use it a few times and then get rid of it. It may be hard to track that back to you. Right? But most people go buy a burner phone and then just continually use it just like a regular phone. And then, like you said, a co-conspirator, a witness, whoever that is, gives up that phone number, and then, it's all the same at that point.
Gotcha. All right. Thank you so much for the question, Angie. And if you guys, I do have some preset topics and I want to be respectful of Spencer's time. So we're going to walk through those. If y'all have questions, so I could see it in the chat, put a Q and then your question. And I'm starring them as they come in. But going back to our outline here, Spencer, the other thing I wanted to talk about is the challenges in analyzing complex cases like YSL. I think we've started to uncover some of that, but what do you think are some of the biggest challenges? Like if you were the expert witness in this case, like what do you think some of the biggest challenges would be?
It's the amount of data. All right. You're going to need, the state will need multiple experts. Typically, when you have this much work, this much data, you're going to have groups of people working on subsets of data. So you will have, like they're talking about the FBI agent who made the report. We call it a CAST report, cellular analysis survey team. That's what they do. They look at call detail records for a living, just like I do. They will deal with the location information. Then you will have other guys who deal directly with the cell phone. So the evidence that came off of the phone itself, the physical device. Now, some of that may get merged together through different witnesses, but for the most part, those witnesses or those experts are going to be working separately on their data sets to help answer questions for, say, the prosecutor. The same thing could occur for the defense team, using multiple experts to answer questions that come across. So it's the volume of data in something like this, not only over the years, but the amount. I mean, there were 28 people indicted.
Yeah.
You're going to have, 3 times that in, associated people maybe, as well as people that they have gathered records for and didn't indict, or may indict later. So it's years worth of data, and it's also just the amount of people involved. So, some of these people may have multiple phone numbers, multiple phones, and then you have multiple people. So that's where the challenge comes in, is just the amount. The work is pretty much the same, whether it's 1 phone or 10. It's just the time that it takes to get through it.
Yeah, because you mentioned a really good point. There are several unindicted co-conspirators, right? So if we're getting those records on top of the others, this, it just really makes me think about the tax dollars that came out of my pocket as a former Fulton County resident. And I'm sure a lot of others are thinking the same. Like, this trial it has probably had to cost upwards of, in the millions at this point.
Well, think about Woody himself. If you look at all of the statements that he provided, all these recorded statements, to then go back and think about, there's also digital evidence that goes along with that. Going back to take that statement and compare it to the digital evidence to try and corroborate his statements. Just the work that it would take to keep up, like you feel the work that it takes just to listen to all of the tapes.
Yeah.
Think about listening to that, and then also taking that information and looking, where was he at these times? Was he even in the right place for that to occur? For him to see what he's telling you. Did he have any conversations with these people, prior to this time? So there's so many pieces to that. If you just think about that one witness and his information to try and merge together, how much work that would be.
Yeah, that's so interesting. And thinking about Woody himself, right? He did say on the stand that he's never been honest a day in his life, and that he's lying, and that he himself is full of shit. He said that. He's made those statements. So to your point, if you have to go and then prove everything that this guy is saying, if it's accurate, just the accuracy, that in itself is a job. And that's just one person.
Yes.
Yeah. And it's particularly for his situation, because he's going rogue. You have to really, really see what is a truth and what is a lie. Woody has talked about his strategy, where he tells the police whatever they want to hear. Half of it is truth, half of it is lies, and he mixes it together. So you don't know what he's saying that's truth and accurate. I didn't even think that an expert would have to go in to validate what Woody is saying.
Well, they don't have to.
Yeah.
It would obviously be worth doing. It would add a lot of, it would either tell you that it's worth putting that statement up, or not believing it. It would also, think about it from the defense side as well. They have to go do that.
Yeah.
They have to have someone look at Woody's statements versus any digital evidence that they have, or any other evidence that is from anywhere else, whether that's a witness statement, anything. Try to corroborate or disprove that information, so that when it comes time finally for cross-examination, which, we've seen Woody on the stand for quite a while. I would assume cross-exam is going to be much longer than direct.
Yeah, I think it's going to.
It has to be.
I think it's
even if it was only one. Even if this was one defendant, one attorney. I mean, there's so much to unpack. Even if you took out issues with the judge, any of that, there's just so much information that has to come out through his testimony that it's going to take a while.
Yeah, and I think it could be all of next week. He's scheduled, like they wanted him ready to go first thing Monday morning, but we
Yep.
still haven't finished some of the things that are coming in on direct. So I think Simone has like an hour or two left with him, and then we're gonna see the defense attorneys have at it. And I wonder if each of them gets a day or how that's gonna work. But there are so many of them.
Yeah, there are.
Yeah, yeah, interesting. Okay, let's go here. Next on our list is overcoming encryption barriers. And I know a
Yep.
lot of people have submitted questions about VPN, so I'll bring
Okay.
some of those up. But what are some encryption barriers that you see when it comes to analyzing this data?
So it is mainly the devices is one of the biggest hurdles that we in law enforcement jump through to get data. Because of the strength of the encryption of the devices now, it is increasingly more difficult to get device data from the device without consent. So they
Mhm.
seize this device, they don't have the passcode. That passcode has to be brute forced in some way with software, and that software is always keeping up with the new phone, the new iPhone, the new operating system, so that we can gather that information. All right, so if the brand new phone comes out tomorrow and people start to use it, it's going to take a while before that phone can be unlocked.
Gotcha.
That's the problem that we run into now, is that there's a lot of phones that just can't be unlocked, due to just the complexity of them. So
Yeah.
that's probably one of the biggest things. One of the things that we run into with it, is we have the ability to unlock phones, with my team. And one of the applications that we use that for is for families who have lost loved ones. They contact us to unlock devices, due to whether that's an overdose, a tragic accident, whatever that is, or just someone unexpectedly passing, and they want the pictures from the device, or they, for example, a spouse needs to get into banking information or anything like that. So there's different applications for that. But so that those same limitations or hurdles that we have to jump through for, say, a criminal case is the same thing we would do in that. We try to get into those devices when we can, but oftentimes it makes it difficult, or it takes a lot of time to get into the device. So
Okay.
that does play a big role in these sorts of cases. There are probably phones in this case that span back over the years that are just sitting on a shelf, with no support to get unlocked. So there's evidence that the prosecution might like to have on those devices. They're not going to get it, for any period of time.
Gotcha, gotcha, gotcha. I think I was gonna go to show me the money. He says, "Why are iPhones so hard to get in if you don't know the password?" I think you've kind of answered that one a little
It's
bit.
kind of like a safe. It's not supposed to be easy to get into.
Yeah,
It does protect a lot of critical information. You wouldn't just open your phone up and hand it to anyone.
right.
So obviously that's why the passcodes are there. It holds sensitive information. So yes, they are very difficult. It's just because they're built to be that way.
Gotcha, gotcha. While we're on the topic, let's go to Tremaine here. He says, "Do VPNs help mask locations on your phone?"
Yes and no. All right. So think about, going back to the call detail records that we were talking about.
Hmm.
You can turn on a VPN all you want. You can use whatever you'd like to. As soon as you make that phone call, you're going to use that tower, and it's going to be recorded, no matter what. The VPN doesn't protect that. So if you're on your, say your home Wi-Fi and you're using a VPN, while you're searching, your search history may be masked as it goes out. It's essentially putting it into a pipe and sending it out and keeping it closed so that it can't be seen while it's traveling. Your search, your request, your IP address. But in terms of, does it mask your location? No, it doesn't really help from that standpoint. It can in certain instances, but in other instances, it does not.
Gotcha, gotcha. Thanks, Tremaine. I'm going to go to another one that I saw, and a few people asked this question. Lynn asked, "Does airplane mode affect any of the data?"
So airplane mode is, it turns off the radios for the device. So it
Mhm,
can't send and receive information. So obviously you could still do things on the device,
mhm.
absent, reaching out to the internet in some way. So you can still create information on the device. If you played a game or something similar, look through your pictures. You could take pictures. You could do all of that. What it does do, though, is it limits the information that reaches out. So you can't create those call detail records. You can't, search the internet and create those kind of records. So it does it does affect the data. It's one of the critical first steps in a phone being retrieved as evidence is you isolate it from the network, so new information doesn't come to that device, or you can't wipe that device remotely, things like that. So airplane mode prohibits those sorts of things. So it does have an effect, but it's not it doesn't just stop everything.
Gotcha. Yeah, thanks for that question, Lynn. That was a good one. Going back to our outline here, we were talking. I always joke with Lead, like I always bring up this book because I feel like this has just been downloaded in his head. Cross-examination, science, and techniques. When it comes to experts, I like to call them like bulletproof witnesses sometimes, because it's like
It depends.
Exactly. It
It
depends.
depends.
Totally depends. But what are some strategies, that you can, because there's a lot of legal people that watch this channel,
Sure.
lots of paralegals, lots of attorneys that are a part of our community. What are some cross-examination tips you would say when
Sure.
it comes to experts?
So educating yourself, that is where it comes in. It is, cross-exam is while you're going to write a script and you're going to go back and forth, you still don't know what that person's going to say. You know what you think they should say based on the information, maybe based on some of the case details, you might think you know what they're going to say, but you never really know what's going to be said. So you have to educate yourself in this area, whatever area it is, if this is called detail records or cell phones, to understand when you get that answer and it makes you, I don't know about that.
Yeah.
It gives you the ability to fire back with another question that maybe you didn't know you needed. It wasn't in your script. So educating yourself in that area, that commonly takes, you having to apply yourself outside of, just the case and, watching some YouTube videos or, reading some books, or also consulting with your expert to better understand the data. I was always taught that when we're looking at this complex information, our job is to simplify it into a way that, if my grandmother's on the jury, that I can explain it to her and she can understand it, even though she has no idea how to work her phone. So I have to be able to give you examples of how this works, break it down, tell it to you like you're 5 kind of explanation. But you also need to ask questions that break it down that way. So when you're cross-examining someone, you have to ask the questions in a way that actually bring out what you're trying to get the jury to understand, because you can get that aha, I got you. But if the jury doesn't understand why you got them, then it doesn't help them in their fact finding mission here, that trying to understand how that data applies. So cross-examination comes down to being able to ask the right questions, targeting the path that you're trying to go down. And then if you've got something really good and you're trying to pull that information out, that's like I said with Woody, they're going to go forever. I know he's not an expert, but they've got a lot to unpack, and they know that they have lots of places to attack him for his credibility and things like that. Whereas sometimes when you have an expert, that might be true. You might have issues with credibility or mistakes that they've made, and you attack those. Sometimes you might end up with an expert on the stand and you want them to get off the stand as quickly as possible. You don't want to just keep asking them the same information over and over and hammering home, and then put up your own expert and do the same thing and rehash all of those issues, because you're just going to start educating the jury maybe the way you don't want them to. So cross-exam, it just takes a lot of education and planning to ensure that you have covered what you need to, really.
Yeah. No, I think those are excellent tips. I definitely co-sign those. A lot of the rationale behind cross-examination is to challenge what the witness said on direct. But like Spencer said, if you ask the right questions, but you have to do it in a way where the jury is going to understand. So next week is going to be an excellent example of that. I'm going to come back to a viewer question, and thank you guys for hitting the like button. You're still not at 50%. I'm sad. Me and Spencer spent some time
working hard
for this. I would love it if y'all could get me to 1.5. Shout out to Brad, who has a question here. Brad says, AV, ask Spencer if it's possible to spoof phone number and ESIN.
Yes, it is possible. All right. So there are applications that allow you to do that. I want to say they brought up like one of the applications that is commonly used to do this. There are applications that allow you to choose a phone number, things like that. So yes, you can spoof them, and hide phone numbers and things. Commonly what I've found over the years is that often that leads to what they call bad facts in the case.
Okay.
You just end up with showing that someone downloaded an application, created a new fake phone number, and then say harass someone, contacted them, lured them in for a robbery, whatever that is. So yes, it can be done. It commonly results in poor results come along with that generally.
Gotcha. Interesting. It's so good to have these conversations because we don't think about them day to day, but it is interesting. And Brad, thank you so much for the question, and thank you so much for the super chat. Really appreciate you. Moving along, I think the next topic we wanted to cover was the impact of new technologies in the field, and we talked about that a little bit briefly when we were talking about iPhones. And iPhones usually have a new release every 2 years, right? What's the impact of technology when it comes to that?
So again, being able to get into devices, but then also once you get into that device, the level of information that comes from it. There historically, if you went back to 2015, the deep dive into the Apple devices wasn't as prevalent as it is now. All right, so there's the level of information they're getting from those devices is going to be, incredible. Versus over the years, as that progresses, that can change and then it catches up. So it's always kind of this cat and mouse back and forth with the software and the devices. But so it's the accuracy of the information. So location information that we receive can often start to get much more accurate than just towers and sectors. We get GPS information from various places. There can be tons of information. So that really, as you progress, there's always that, the devices take one step and then the forensics catch up. And then, so it's always that kind of step-by-step process, but it creates problems and barriers, but it also comes with solutions that give you more and more sometimes. So that's really the kind of process or how things occur just constantly, really.
Yeah. Awesome. It looks like we have another viewer question, and What the F sends a $2 super chat. Thank you so much, What the F. What the F says, can Google Voice or app calls be tracked?
Yes. So again, with the device itself, it's almost going to be very similar to those iMessages, FaceTimes from the device. If that device becomes unlocked and extracted, yes, you're going to see those phone calls and things as they occur. So they're not going to occur over the, AT&T and Verizon and whoever. You're going to see them on the device itself.
Gotcha. I'm going to go to another one because this is pretty good. We have a lot of Instagram posts in this case. Okay. So I'm going to go to Philly. She has a question here. She says, nowadays people call over Instagram. Can those calls be traced the same way FaceTime can be traced as well?
Yep. So again, straight from the device or from Instagram themselves. So again, going back to Google, I meant to mention that portion too, is that search warrants to Google, to Instagram, all of that information could be gathered. If you kind of think back to when we were talking about screenshots and the proper way to gather that information. If you send over a legal process to Instagram, you would see those posts, you could see those calls, you could see those DMs, you could see friend requests, all of that information.
Wow.
So Google, same thing. Any of those applications, you could see phone calls or messages being sent, or you get it directly from the device. So yes, they can be traced in one way or another.
Interesting. Thank you so much for the question, Philly Chica. Very, very sweet of you. And I see you guys gifting out memberships. Mimi's over here giving out memberships. Thank you so much, Mimi. I did see another one come in, and I know we are just about at time. Do you have a few more minutes, Spencer?
Yeah, I'm good.
Okay, perfect. Dan has a question here. Dan says, everyone in the chat, is Brian Steele? Okay, Dan. I believe Brian Steele might be live right now. But as far as law and crime, I see that they are scheduled to set up at 12. So I thought that was a question for you, Spencer. My bad. Sorry about that.
I don't know if Brian is here or not.
Okay, there we go. Chat sometimes can, get a little disjointed there. What I have on my outline next is insights from similar high-profile cases.
Yes.
Have you ever seen anything like this before? I know we've seen some really popular cases over the years, like the Johnny Depp Amber Heard thing was huge, and then the OJ trial was huge. Insights that you have when it comes to forensics and high-profile cases.
The forensics happens in everything. It happens in all of the cases, whether they're high profile and huge cases. This one's obviously a high profile case, and it's a huge RICO case. You know, even if it wasn't a high profile, rapper or anyone else, these sorts of cases happen every day, as far as these RICOs and things like that in different areas, gang cases. So in terms of the high profile cases, yes, this stuff occurs all the time. These people have phones too. They text each other, so we see those records. I believe it was, what was the Rush shooting?
Yes.
Baldwin.
Baldwin. Yeah.
Alec Baldwin. There was mention right before the case was dismissed that there was information about cell phones, text messages, things like that. So I believe Amber Heard, that case, they had a ton of it. You mentioned Aaron Hernandez earlier.
Yes.
My colleague actually testified in Aaron Hernandez, the last trial. So he's talking about searches on phones, just all of that information. So this data is prevalent in every case, but especially in high profile cases. There's always phones being used to corroborate the evidence that has been found.
Gotcha. Moving on to our next topic. I think we wanted to talk about the ethical considerations for data handling. How do you guys preserve the ethics when it comes to that? This trial has seen a lot of ethical issues, right? Whether it comes from the defense team, whether it comes from the prosecution team, whether it's coming from the judge. But as far as like experts, how do you guys ethically handle the cases that you cover and the evidence that you're handling?
Sure. So the data is what it is. Brian Steele can hire you. Love can hire you. It doesn't matter.
Yeah.
The data is what it is. They have a story they're trying to tell. The data may or may not support that story. It's not my job or any other expert's job to corroborate their story for them. The data either does or does not help them. And it's not my job to make it help them. We have plenty of tough conversations any day of the week to let you know that, the data is what it is, simply not good. You should not put me on the stand. And here's how you should mitigate issues that come up from that. So that really is what it is that having the fortitude to say like exactly that. Hey, I can't help you. No, I will not testify to that.
Right.
No, I don't need you to write me an affidavit. I can write my own affidavit.
Right.
That sort of thing.
Interesting. All right. I did see another question come in, vetted this time. I'm reading them. Shout out to Jennifer, who has a question. She says, since our phone apps always seem to be listening to us, are there any lists and apps saved that can be used?
Let me read that again. I don't know if she's talking about the recordings themselves. There are applications that do track voice. If you use Google searches with voice, you can go into your account and actually listen to your own voice, ask Google certain questions. I'm not sure about the apps. I'm not sure about that last portion of it. Are there apps saved that can be used? I'm not sure about that, but yes, there are applications that do listen to you and record your voice as you speak to it.
Gotcha. Yeah. And, I worked in banking for a really long time. And a few years ago, I was baffled because our marketing team showed us this new software where, if a customer just logged off of their banking app, we would be able to send them marketing because if they walked by one of our branch locations and let's say they Googled possibly wanting to open a bank account, we could send them an advertisement to try to change their minds. So we can see how just technology is really, it's changing. It's changing. So thank you so much for the question, Jennifer. I hope that answered it. Coming back to our outline, and this might be the last topic we are going to hit because I want to be respectful of your time, Spencer, and then maybe we'll grab some more viewer questions. But any advice for legal professionals on utilizing forensic evidence? We talked about cross-exam, but just utilizing evidence in general, like forensic evidence, because your team offers so many different services. Even just the, getting into a loved one's device if they pass, I think that's huge. But what advice do you have for our legal folks?
Use your experts. Allow them to assist you. Their job is to help you understand the data that you're dealing with, but also just don't settle for what's in discovery. There can be oftentimes, let's say they never went, I gave you all the ways that we could corroborate Woody's testimony. What if they didn't go gather that information? All right, let's go gather it ourselves, so that we can compare our data that we gathered to his statements, so that when they get up there and say, well, did you check this? And they go, oh, we don't have that data. All right, well, we went and got it. So here's what it says. He wasn't even in the area of Club Crucial when he said he had this conversation.
Right.
So there's ways to break that apart. So, just don't settle for what's in discovery. Go get, you can gather data too. We do it all the time. That's one of the things that we kind of pride ourselves on, is that ability to help guide the attorneys in the way that how to obtain the data, because that's what all of our team did in law enforcement. Was we were searching for this data, gathering this information to do our analysis. We do the same thing now. We just obviously don't write search warrants and do court orders. We use attorneys to go get that information. So they can do those same processes and combat the story that's being told too through the gathering of digital evidence.
Got it. Okay, there's a few more. One I see is really important. That comes from the best moderator on YouTube. That's Miss Gail at Night. Her question is, does Spencer have a social media account he would like for us to follow or subscribe to?
I have a business Instagram account that I've started and started to try and share information. And it is just, it's on Instagram, and it is my first and last name. So you should be able to find it pretty easily. I think it's at the bottom of the screen here, my name. And if you'd like to follow me there, I've been trying to start posting and giving content there, so you can kind of see what it is we do.
Okay, perfect. I'm going to your profile and sharing.
Thank you, Gail.
Yeah, Gail this is why Gail is amazing. All right, I am sending this to me. I'm going to pop it in here, and then we will make sure that you guys can follow Spencer, because I do think even checking out his business website is a huge opportunity for those that are interested in his services. So I'm sending that over to myself right now. Boom. Gail, I'll drop it for you because I know that she is likely going to want to post your link as well. And what is your website? It's
InvistaForensics.com. Yep.
Okay.
We have experts that do just about everything.
Okay. Invista Forensics. And you guys do webinars, speaking engagements, all of these things.
Do a lot of education for the legal professionals specifically, because that's who we work with, obviously. But we help them understand, kind of do what we've done today, answer questions, educate them on technologies, and then kind of go through, a real deep dive on cross-exam challenges, things like that. So we, obviously, like I said, keeping up with, relevant cases, and kind of breaking those down so that they understand how the digital evidence applies in those cases.
Absolutely. Awesome. Well, now people know where to find you. Let's grab one more before we go. Shout out to Paulette, who has a question. She says, what about the cleaners? Are those apps actually cleaning or storing the info? Also, the AI situation cleaning, and what's Meta?
All right. So in terms of, there are applications to clean things up. There are ones on computer, if you've ever seen C Cleaner, anything like that. They help you remove data from your hard drives on your device. So one thing that people don't understand is that when you click and delete something, let's say it's on your phone, it doesn't actually, just completely go away. You've removed it. You're removing that from your view, but then you're also telling the device that it can store information in that place. It's almost like in your device, you obviously only have so much room. It's like a desk drawer. If you want to fit more things in this drawer, you may have put too much in there. You need to get rid of a few things first. So it gives you a new place to put information. Once that new information comes in, it begins to write over that old information, and that's when it starts to become really gone. All right. So deleted doesn't always mean deleted. So those cleaning applications often help you better clean up those places where that information used to be stored. As far as the AI, in terms of that, I'm sure there are applications using AI to help you do that. I think we have we're starting to get applications that use AI for everything at this point. And then Meta as a company, they just about dabble in everything. They're turning into Google, essentially. We have applications, services, they're advertising. They do it really, they do it all. It's almost hard to explain what it is they are. They're a gigantic company that can just about do whatever they want now. It's like Amazon. They don't just deliver packages to your door. They have a million other services and technologies that they're starting. So these big companies, they have a lot of reach.
Interesting. I'm going to grab one more,
Okay.
and then let's go to For Always, Forever, for Life. One of my members, super engaged in the chat. She says, tell Spencer, thank you so much for being here. And her question is, can my phone be tracked even if I don't have the location turned on?
So this is a common question. There are different forms of location tracking that are available on your device. So you have advertising tracking, which also provides locations, as you were kind of alluding to earlier. If you're on an iPhone or an Android, you can go into your settings and search advertising ID. Those are trackable identifiers that provide location information. They're going to start being used in criminal cases. In the background, they are in many instances. So that location data can be tracked. It's kind of it's something that comes up fairly often now. So that's one way, and you can turn that off, all right, or you can change it. Then there is things like, so Google location history is one of the bigger topics that I deal with lately. So Google geofence warrants is where it searches for your location history without actually specifying that we're searching for you specifically. That's probably the most interesting search that there is. But if you actually go to Google Maps on your phone, you'll see the icon at the top. It has like your initial, or it may have your avatar, your picture there. If you click there and go to your timeline, you will see if you have location history turned on. If you do, then you can go jump down the rabbit hole of reading about geofence warrants. And be freaked out about all the big collection of data that's occurring all the time. But actually, I guess I'll ask for a chat, AV.
Yeah.
If you will, go look at your timeline, just like I described. Go to Google Maps, go to your avatar, and then look for timeline or your timeline and click it. If you have a bunch of data there, throw that in the chat and say that you have it. It's always interesting to see the ratio of people when we do this in a class to see who inside the room actually has this turned on, who didn't know it was turned on, things like that. So that's an interesting one. And like I said, if you have it turned on, you can go jump down the geofence rabbit hole.
So how does that work again? So they would go to Google Maps.
Go to Google Maps.
Yeah. And they would do this from their phone or from
from your phone.
From your phone. Okay.
Yep. And then here, I'll look on my.
Would they do the app, or can they
do Google Maps on that? It has to be the app.
Oh yeah. See, I don't even have that one downloaded, but that's interesting. But a lot of people use it.
Yes. And so when you go there, you will see, like I said, your little avatar at the top gives you the menu. When you hit your timeline or just timeline, you will either see all of the data from all the places that you have been, or you won't. So you either have as we see them popping up, the yes crowd and the no crowd. But it's interesting to see who has it turned on. Yep. So Jeremy has it on, and it says.
Demalise has it on.
They're called geofence warrants, where law enforcement is able to draw a fence around a particular area and ask Google to search through all of the data that they have to find whether or not you were there or not. And so it's pretty interesting. But yeah, geofence warrants are a big thing. There's a lot of them in the Court of Appeals across the nation right now. As they're going through, there's some pretty big cases, a lot of litigation going on. Pretty cool. So.
Wow, that is actually a pretty cool social experiment. What do y'all think?
It is.
Some of you guys are like, wow, I didn't even know mine's is on.
Yeah, you see the back and forth though.
Yeah.
Of how many have it, how many don't, and then who doesn't know that it was on.
Right. Some people have it on for safety reasons. Yeah, because there's other things like Find My Friends with iPhones. Like a lot of people keep it on for safety purposes.
Yeah. So the thing about iOS location data is that it stores it to the device versus with Google. So there's the differences there. Google is making a change currently, but I don't know that it has completely taken effect yet. But so for that same location information to be found for a particular person, you need to get the phone.
People are getting freaked out. They're like, is my car tracking me? That is a good question too.
That's another rabbit hole to jump down is vehicles for sure. I guess I'll finish the phones. Yes, there are many different ways to track devices through different applications for sure. We get off on a tangent with Google, but yes. But yes, your car is, depending on the make and model. Yes, when you connect your phone to like CarPlay or Android Auto, you wouldn't believe the amount of data that is transferred over to the vehicle. It keeps up with a ton of stuff. My team that does, the guys on my team that do vehicle forensics, they were actually on Inside Edition and did a full workup. They went and rented a car with Inside Edition. They drove around, did a bunch of stuff, and then downloaded the vehicle. There's a whole thing about it. You can search it on Inside Edition. But pretty cool to see how much information is gathered from your vehicle or from a vehicle that you rent from, Enterprise.
Wow. Spencer, this is probably one of my favorite interviews I've ever done on this channel. This is just so cool. And I really like that the audience was able to learn something too. If you guys learned something today, can you put a 1 in the chat just so I know? And if you're like, it was all right, be honest, we like feedback here. Put a 2 in the chat. But Spencer, thank you so much for your time. I was really excited for this interview, and you definitely knocked it out of the park. Look at all the ones. I mean, this is fantastic. And it looks like the audience really enjoyed this as well. So again, if people are looking for you on Instagram, I have it pinned. You guys are looking to follow Spencer on Instagram, you could follow him by finding his name below. And then we are going to definitely share InvistaForensics.com. That's where they can find you, right? And just tell us a little bit more about the services you and your team provides.
Yeah, so as far as the team that I'm on, we do digital forensics. So computers, cell phones, location information. If it's digital, plugs in, has a battery, stores data, we probably deal with it. And then there's other services that the rest of the company deals with in terms of all sorts of engineering services for forensic engineering. So we do a ton. So phone unlocks are a big one as far as, kind of the everyday person. And then the other services are directly to litigation attorneys dealing with trucking accidents, criminal incident, pretty much anything you can come up with in the legal realm as well. So,
and you deal with folks nationwide, right? Is that right?
Yeah, I've testified in 20 different states, I believe. So I've been just about everywhere.
Gotcha. Spencer, thank you so much. This has been fantastic. I definitely want to have you back. I would love to have you back the week that Brian is discussing this FBI report. I think your insight after that comes up would be fantastic. So if I heard on
the witness list, I think that person's coming up fairly soon. I believe it's Agent Bernie is who they're talking about. So
Agent Bernie, yes. They did go through the witness list yesterday. I do remember hearing that name, and it is coming up fairly soon. I would say probably end of the month, or they're taking Labor Day week off. So if anything, we'll circle back early September. But Chad loves you, and I would love to have you back.
Great. Thank you.
Awesome. Thank you so much, Spencer.
Yeah, absolutely.
Enjoy the rest of your day. You too.
Yeah, thanks.
Bye now. Guys, wow, what do y'all think? This was super amazing. I want to start doing more streams like this. I have so many friends that I went to law school with that are really successful attorneys. I have friends that are even DAs, right? Or ADAs. So I would love to start bringing in fresh perspectives, different perspectives, so that way y'all could learn along with everyone else. And really, while we're looking at the trial on our breaks, we could do something productive and bring more folks in. So super cool interview. I hope y'all really enjoyed it. And thank y'all for getting the likes up too, because that is going to get this information out to more people. And again, like I know you could watch a stream anywhere, but it's so much better when you have a stream with community, a stream with experts, I want to start bringing more attorneys on. Lyin and I always work together, but definitely want to start giving you guys fresh perspectives with professionals that know what they're doing. That was the first time I've ever really sat down with a forensic expert and was able to ask questions and go from there. Spencer and I have been planning that for a few days. And of course, here's the thing, like, how we do these like recap videos and stuff. This is all content that will come in handy later. So when we start looking at things further along in the trial, it's going to be great. So some of you guys are telling me that Brian is arguing in the Supreme Court today. It's happening. I cannot find the feed. If you, because we have a few minutes before trial starts, if you guys could find me the feed, I will play it right now. Okay. So we'll do that until the court feed starts at 12, but we've got some time to kill. I do have the original indictment up as well, so we can do that. Yesterday, a few of you guys have sent me some options of things that we could do during our breaks. There was a spat between the judge and, of course, DA Love on Friday that I did not get a chance to cover yet. So we have that one as well. Thugger posted the link. All right. Thank you, Jory. Let me go to Twitter. Thugger Daily. I'm going to link the live stream for it. Here it is. Shout out to Jordy who found it. It is live. It's about 2 hours long. Let me stream it. We're going to, let me put it over here. I'm going to put it over on this side. And thank you guys so much for being patient. This was definitely pre-planned between Spencer and I, so did not plan for it to. Why does it say that the link is not safe? Okay, back to safety. I hope it's safe. Y'all about to break my laptop. Your connection is not private. Why does it say that? Weird. All right, we're just going to do this. Full screen, home over here, present, share screen, this side, boom.
Crime charged. Rather, there has to be a motive in the prior and then a motive in the particular. Motive has to be specifically tied. Here, when you don't have the motive to control present in the particular charged offense, that motive that was specifically linked in SMART does not exist. Furthermore, this court in Strong v. State, which I respectfully believe why this court is taking up this case, in footnote, I believe 19 of Strong v. State, this court acknowledges its opinion from 2016, Smart v. State, where they talk about how, or the court talks about how domestic violence may be present in a domestic violence relationship. The state's argument in this case assumes that that dynamic of control is always present, not may be present. And that footnote's important because the evidence, when the opinion says it may be present, that puts the burden on the state to prove that that evidence is present in this.
Okay, guys, listen, I know you wanted to watch it, but they're showing a live feed. It looks like Harris v. State, or is it State v. Riley? It's the State v. Riley. This is the case that Brian was arguing on. I'll give you some background on it. It says the state represented in this case by the Atlanta Judicial Circuit District Attorney's Office is now appealing a Fulton County trial court's decision to grant criminal defendant Brendan Riley a new trial. Riley was indicted for murder and other crimes stemming from the shooting death of Gentis Wheeler. In 2015, Riley was found guilty by a jury and sentenced to life in prison. The trial court granted in part this motion for a new trial in 2024, determining that the indictment against Riley was defective because it stated that the district attorney and not the grand jury charged and accused Riley of the alleged crimes. On appeal, the state argues that the trial court erred by holding that the indictment was fatally defective and that it therefore lacked jurisdiction to try Riley on 5 of 6 counts charged. The state further argues, therefore, that the trial court erred in finding that Riley's trial counsel was ineffective for failing to challenge the indictment against him. Attorneys for the appellate, so Fonnie Willis was there. It looks like Kevin Armstrong was there. Charles Jones was there. Chris Carr was there. Beth Burton was there. Megan Hill was there. And it looks like Clint Malcolm was there. And the attorney for Riley was Brian Steele. So we did miss it. I'm sorry, y'all. I just tried to go to their feed. Unfortunately, they are not using YouTube. They are using Vimeo. Vimeo does not give me the ability to go back and rewind, unfortunately. If I can find a YouTube link, that would be much better and ideal, right? But that is why we are starting court later today, because Brian was arguing on behalf of Riley this morning. Would have been nice to watch. Really, really sorry about that. Craving Spirit, I cannot go back. That's what I was just explaining. It does not give us the ability to rewind because it's a live feed. And they are doing that through Vimeo, which does not give you the ability to rewind.
It could be consistent with the defendant's theory as opposed to.
Yeah, and they're arguing a whole nother case right now. Harris versus State is up. Their schedule was to look at it, about 6 of them. But we can't bring me back, come rewind. I wish we could. I wish we could. All right, guys. So I'm just going to read a few supers and then I'll bring you back to that fight between the judge and DA Love on Friday. And then I'll bring you up to speed with where we are today. We will not have TiVo time, so we will be live. We will be live and go from there. Sue validates that Fani was not there, only Brian. Thank you so much, Sue, for keeping us informed. Also, thank you guys for the great questions. I'm going to unpin them right now. There were some really, really great questions for Spencer. For those that ask your question in a super chat, you didn't have to do that. Whenever I bring experts on, just know that your questions are fine. Like the experts are here for you, you know, so you don't have to ask questions in a super chat. Okay. Let us come to the top. Shout out to Paint and Sound, who says, morning to the incredible Miss AV. We love you. Love you too, Paint and Sound. Thank you so much. Hope you're having a great day. Shout out to D, who says AV7 for analysis in the morning, right? Like I wanted to start you guys off and do something fun in the morning before we got to the stream. Shout out to Full Drinking and Half Thinking, who sends 10 AV7 memberships. If you got one, please say thank you to him. Super, super sweet of him. Shout out to Zach with $9.99, says in Harbor Point, guys use burner phones for 7 to 10 days. Then buy a new one. Love the content and the interview. Thank you for giving your time to educate some of my friends. Yeah, listen, how many of you thought that burner phones were safe? Apparently they're not. They are not, because if you could still use the same phone number, and if somebody ends up sharing that phone number, you're still at risk, you know, so it's not going to be hard to find you. Thank you so much for Brad asking the question to Spencer. We did get that one. Mimi gifted 5 memberships. Thank you so much, Mimi. Very, very sweet of you. Supporting the Chatterhood. Shout out to What the F. We did get your question as well. What the F? Jeff says, how do they keep bringing in alleged crimes after 2015? Jeff, this is a good one. I was so irritated yesterday when she tried to bring that meme in. Because here's the thing, she wanted to tack on additional crimes. And when I say she, I'm talking about DA Love. Do y'all remember they were talking about the things that happened in the jail, meaning, you know, stabbings that happened in the jail, you know, having a shank, having a weapon, drugs that were in jail, all of these additional crimes that took place well after 2015. But at the same time, a lot of the argument that we saw yesterday was to stop that from happening. It does not have to do with RICO. In a way, it's really not relevant. It's just the way they're able to get around it is using the RICO conspiracy. When you're doing that, you're saying that all of these overt acts are going to be tacked on. And that's what we're about to jump into, Jeff, because the fight between DA Love and Whitaker on Friday had to do with, you're going to love watching this. Love tried to add additional overt acts or retry some of the overt acts. What the hell are overt acts? You guys are like, what are those? Now, some of you were calling them overt acts. It's overt, O-V-E-R-T, right? Now, where does that come from? That comes from the indictment, okay? When you indict someone, you're indicting for particular crimes. I think I showed you guys this yesterday. This is the original indictment. An indictment is a choice by a grand jury to bring charges against a defendant, in this case, a group of defendants. On the right-hand side of your screen, these are all of the charges. These are all of the crimes. And I think I showed you guys yesterday, some people, like if we look at Duwop, for example, Duwop is only being charged with 1 and 2. So RICO and murder. If you look at Duke is only has RICO. If you look at Briss has gotten like almost all of these, right? If you look at Quay, yeah, Marcavius Huey, and he's one of the biggest defendants. He has almost all of them. If you look at Yacht Gotti only has 2. If you look at Sergio Kitchens, who's also who's out right now, Gunna only had 1. And the one that they had Gunna on was just the RICO one. This is a conspiracy to violate the RICO Act. That's it. Some of these guys are in these streets. Like look at Briss, look at Demekion, Scarface, right? Lil D. I don't know if it's the same D. Look at Stunna. Some of these, like Moontunk only has 2. But guess what? Now Moontunk is severed and he is an unindicted co-conspirator and now a witness, right? So super, super interesting. But I wanted to at least explain that to you guys there. Let me finish 2 more of these and then we'll jump into Friday's piece. Shout out to Scotty, who is coming to us from across the pond. Did you see the King Arthur reference yesterday, Scotty? Did you see it? It was crazy. I couldn't believe we were talking about Knights at the Round Table. We were talking about Excalibur. All of that took place in the courtroom. It was crazy. Scotty says, Siri backwards is Iris as your phone's always watching. Oh my God. I never realized that. Did y'all? Wow. Iris like your eyes? Your phone's always watching. That's creepy. Shout out to Carl, who says, this is why I drive an old truck. Pre-technology, they can't shut my vehicle down digitally like newer vehicles. That did scare me. I have a Lincoln, guys. I like my Lincoln. It's newer. It's new-ish, but yeah, they could probably turn it off. And now a lot of these new cars, like I was looking, they send me stuff for Lincoln all the time, right? Their new dashboard for the 2024 version of my car, the entire joint, the whole dashboard is digital. The whole thing. The whole thing. Imagine having a big screen like that across the dashboard. Crazy. Crazy, crazy, crazy. All right, let's go to Law and Crime. We're going to bring up this feed and we're going to watch Crazy Love Shenanigans. Again, we've been balancing and mixing my soundboard, guys. So I am going to be making some adjustments. Don't be shy. If you do think it's loud, it's all right to tell me. Please try to do it in a nice way, though. Because some of y'all are mean. They're like, you're screeching into the microphone. It's like, word. Who's screeching? Who's screeching? Okay, so let's see where we left off. It was right around here. And this is Little Woody's final day in court last week. And they wanted to be productive. Let us present, share screen. 66. Here we go. Let's watch this fight go down. It's about an hour.
Okay, while we wait, why don't we get a jump on our next week's work? Who's ready on anything? Y'all should be ready on something by now. Okay. All right. On the PowerPoint, we should have states either written or ready to have oral response by now.
Well, actually, Judge, I had not finalized that. I know before giving me a deadline, I was going.
Okay. Well, one side's ready, but I don't know how y'all are ready when you haven't given them your.
The final, no.
Okay, so we're not ready on that. And I know that we haven't filed. Okay, let me ask you this. How about the issue of the Ryan motion to suppress his statement because of the incomplete Miranda warnings? Allegedly incomplete Miranda warnings.
So if we need, I don't know if the court is addressing us, but if the court is, we need to have a Jackson general hearing, because again, that is not where I placed my focus. We were trying to make certain that other things the court instructed were done by today.
Okay, well, what was it that you were supposed to be doing by today? That,
We were working on exhibits with the accompanying exhibits for the next 30.
so when were you gonna get all of this 3 pages worth of things we're gonna tackle next week to the court and to the defense for their consideration?
Between
Sunday
now
at
and Monday.
midnight?
No, because I don't know.
All right, well, let me ask you this. On the Ryan motion to suppress, have you looked at it? Do you believe that the Miranda is complete? That the Miranda warnings are complete?
Your Honor, my position on that is that Mr. Ryan, and his ability at this point to move to exclude that evidence,
Uh-huh.
would be untimely, number one. He has been convicted of it. And I believe that having heard it, there's an argument to be made on both sides, frankly. I hear what the officer is saying. And I think that there's just an argument to be made on both sides, to be fair. So,
Do you think that the law supports that if an incomplete Miranda is given, that the statement can nonetheless be used against the defendant?
not in the state's case in chief.
And y'all didn't use it in the case in chief, did you?
Not in the previous trial.
All right. And yet you think that you have some law that would permit you to use it in some later trial against the same defendant?
That's not what I was saying.
Okay. Well, I guess I will just wait eagerly to see what it is that your argument is going to be on that. Just trying to think of some of the really
And I am willing to speak.
easy things.
I am willing to speak with Mr. Williams more after we get a couple of other things situated. If
Which Mr. Williams?
Miss D. Williams.
Oh, Miss D. Williams.
D. Williams.
Okay.
Yes.
I thought you said Mr. Williams. Apparently I'm hard of hearing too.
No, so I will communicate with her, and if our position changes to such that it becomes a moot issue, she'll know and the court will know before Monday.
Okay. All righty. Well, I know that I haven't, Mr. Weinstein, gotten your promised motion to exclude Mr. Kendrick's first couple of hours of his statement. But the teaser was that y'all had just found out that he was represented by an attorney in an unrelated matter. And therefore, law enforcement should have reached out to that attorney before questioning him in this matter. Am I right about what the basic theory is?
That's the basic theory, but
Okay.
I am not prepared to argue that today, and I am
Okay.
still working on the motion. And
Okay.
I think that Mr. Apt maybe clarified that would be filed tomorrow.
Yeah, he did. That just pretty much seems like black letter law to me as well. And I don't know, maybe there's some US Supreme Court cases that have come out recently or since I took criminal law in law school that answer that question differently than how I was taught it. But so I will also eagerly await whatever your legal theory is.
Oh,
Thank
So-
you, Your Honor.
Okay, great.
we missed this on Friday, y'all. So you guys have been picking up on the shade. You've been picking up on the shade she's throwing at Love. She's just like, oh, you're still not ready yet? Oh, surprise. When are you going to be ready? Sunday at midnight? When are you going to be ready? What are we doing? What are we doing, Love? So this, again, guys, this happened at the tail end of Friday. I did have to duck out. Lyin and I were supposed to cover it yesterday, but we didn't work together. So I'm showing it to you now. But again, she is not prepared. never prepared, never ready, right? The suit actually does look nice, but what she just said was extremely insulting. You learn this in criminal law and law school, right? You learn how criminal procedure works. You learn it in law school. How come you're not ready, love? Tell me. And she's still not able to answer this question.
Perhaps that's why I'm still working on it.
Perhaps that's why. Okay. All right. Well, let's see. I mean, I don't know if there's any point in going back over the list that I have reviewed with y'all almost every day this week, because there may be nothing that both sides are ready on. And I realize that I'm a few days ahead of where I thought we would be, or when I thought we would be taking these things up, but just thought those two might be easy ones. Oh, do we have the ability yet to identify, other than whatever was in the wiretaps, any other co-conspirator statements that y'all on the defense maintain are late identified?
Your Honor, we maintain that all statements beside the 3 statements provided.
And I understand that, and y'all told me that before, but I don't know not the 3 that were identified before, not anything from the wiretaps. Are there others? And if so, what are they?
Okay, so the state, I thought that where we left it, and I wasn't even here that day, but I watched the video, that where we left it is that the state has provided hundreds of wiretaps and jail calls and still have not identified statements within those hundreds. So for us on our side to go through the hundreds, guess the statements that the state is going to may use, and then give them that list would take a significantly long time, when what the state could do, because I'm sure they have their case lined up by now, is to give us the statements that they've identified. And then if we have a legal argument against them, we can make that argument. And just for the record, Judge Glanville not only told them to provide all of the statements back in December of 2022, but after that, he told them to not only identify statements, but any evidence that they've identified, transcripts, any of the case, videos, that if they know that something is inadmissible, they need to go ahead and redact it, tell us, hey, I'm going to introduce this. I've already redacted things that I know as an experienced litigator. It's probably not admissible. And then if we have any further redactions, to let them know. So that is the way this was supposed to move timely, not be a trial by ambush, not have the jury sitting outside waiting on us to get through the issues. These are the orders from Glanville. And Your Honor, respectfully, none of them get followed.
I'm noticing that. How about,
Did y'all hear that? I'm noticing that. That means that, and shout out to Westmoreland. She said this on Friday. She's just like this, and you could hear the passion in her voice. This is extremely frustrating. And Love was sitting there, I thought she was scrambling and scraping, but it turns out she didn't have a mic. The judge is saying, I'm noticing that they're not following directions. Okay, but what are you going to do about it? What are we going to do to stop the delay? Because every defendant has a right to a fair trial and a timely trial, in addition to a fair trial, a timely trial, right? Let's listen to the debate.
I had asked about the January 10th.
The blurb at the beginning
That
of the
was,
day?
and you, Ms. Love, weren't here at the time, and we wondered if maybe you knew the
I heard.
origin of that.
I heard, and I do know the origin
Okay.
of that. So if I'm not mistaken, the court was inquiring, and there was a motion of sorts regarding the date at the top of the picture of Mr. Stillwell looking out of Mr. Williams' condo, contemplating. So that photograph, Ms. Hilton was correct in that Mr. Zachary told the police that he took the photograph a few days earlier or in the latter part of 2014. However, the date on the photograph comes from, as it was placed on the social media page, the same way that the date of a posting appears on any Instagram or Twitter or whatever, the date of the posting is under the picture that is posted. So I didn't, unless I misinterpreted what the question was, the answer is that it was screen grabbed from Mr. Stillwell's account.
Mhm.
And the date of the posting as shown on his social media page was January 10th, 2015.
Okay, well, it didn't, if it's a screen grab, is this the screen grab?
I'd have to see the one.
Well, it's what's filed in the motion in limine regarding admissibility of social media posts and alleged date of posting that was filed 8/15.
If you're on the.
Sure. Ms. Percival, can you hand that to her, please? See that little,
Oh,
So now she's talking about the hovering piece, and it's actually good that we had Spencer here this morning. This is one of the first questions that I asked Spencer about. This is the hovering where they took screenshots. And remember what Spencer said, a forensic expert. Screenshots are not evidence. They are not. So let's listen to her talk about how there's two versions of social media posts. One that's a regular screenshot, and the other is a screenshot that has a hovering over it. It's just such a waste of time. And how many social media posts did y'all do this to? So if you went and did that and wasted time to do all of that and have two versions of all of this, I mean, it's a little bit of a waste of time, love. Not even a little bit.
hand it back to me.
What that is, Your Honor, is that when a person is looking on the social media page and they want to know the date of a posting and they hover, it'll pop up or pop out in that manner.
Are you gonna have somebody that is gonna be able to testify to that?
We sure are.
And
Because it was done
so
on more than one.
somebody hovered, that date appeared, and then y'all took the screen shot or whatever, screen grab?
Two things. We, in not just instance, in other instances as well, we not only captured it as it was shown, like if it with January the 10th, 2015 on the picture itself, but we also went back, the person who was looking at the social media page and hovered just to get that pop out that the court is looking at on that exhibit. So in multiple cases, we have a screenshot of a social media page with the date on it, and then a corresponding screenshot with the hovering where the date pops
Okay.
out.
So will you then intend to admit it as, or offer it as, are you gonna have those things available?
Both, yes, I mean, yes, in terms of what we intended to proffer.
It would be the screenshot as you look at it, or the screen grab as you look at it.
Yes.
That has it the way we normally see it, and then also the hover, and then also somebody that is going to be able to say, when we see these dates, we have a reasonable degree of confidence that they actually mean what they say.
Yes,
and why?
we would have the person who first saw it and pulled it from the page, one, talk about what's on the screen grab, what's on the exhibit, and two, what the date means on the exhibit based on their understanding and knowledge of that particular social media platform. And three, we would ask, because I wouldn't see a need to admit both the original posting and the posting where it's popped out. But just as a next layer of confirmation as to the date that it was posted, we would ask, hey, how do you know? And then that person would say, well, you can also hover over the picture or the posting and the date pops out. And if the question becomes, well, did you do that? Yes, here's that exhibit with that pop out date.
All right. And is there any objection to, I know this shows like some comments also, is there objection to that?
There is, and in my, as I was preparing an exhibit, we, in accordance with what usually has occurred is we take out all the extra comments, and my prepared exhibit has that all taken out. So I just wanted to put I didn't want anyone to say I did anything to the one that I was putting in my motion. But can I inquire about that? Because just so the court understands, in this discovery dump 1 to 2, that's where this picture is, to my understanding. I know it's there. It may be other places.
I love that Max keeps calling their Max keeps calling the state's pieces of evidence. He keeps calling it the discovery dump. I don't know why that's so funny to me, but he's calling it the discovery dump because the way that they're doing it is just, it's messy and there are terabytes of information. Here's why that's wrong. When the defense attorneys have to go through the information, because if you are the other side, if I'm the prosecutor and you're the defense, you dear viewer, I have to tell you what evidence I have because you need to prepare to respond to it, right? But he keeps calling it the discovery dump. Shout out to Max. Let's go back in.
And it just says, it's a folder, says social media, and then there's a bunch of pictures. I don't know at this point, unless I missed it, I don't know who hovered over what picture, who collected this or anything like that. So I'm just trying to understand who's going to authenticate how this was collected and what date it was and how they hovered over the picture.
Have we gotten to the production of that information yet?
Your Honor, we have that in, we've turned over, actually they turned over attorney work product. So that information is contained within a report that was authored by, I believe, Mr. Sprinkle in our office. So and that actual picture is addressed directly.
Okay.
So in as much as we turn that report over,
All right. Sounds like it's Mr. Sprinkle.
he's one of the people who addresses that report, that social media posting,
Okay.
and what is contained and what it shows.
The person who collected this photo and hovered, or is he just making reports saying, I've got a pile of papers that are in a file and one of them happens to be a picture of Mr. Stillwell?
The way that we got the photo or knowledge that we should be looking there is from one of the investigators, the gang investigator, Gaither, who was working on the case, looking through social media files. Mr. Sprinkle, as I understand his report and as I understand my conversations with him, and I will make certain that what I'm saying is absolutely correct. Mr. Sprinkle addresses in his report social media posting, and then he talks about the date that it was posted. My memory is that he talks about the popping out, but I have to look at that. But I know that it is definitely Mike Sprinkle and investigator Gaither that, and as with the rest of them, he addresses quite a number of social media postings, both he and other investigators that have worked on the case.
All right. All right. So at least we've got that answered. Or not.
It's been answered respectfully, Your Honor, but I guess this is just my way of saying this evidence did show up in their list of exhibits that they plan to introduce in the near future, and I am flagging my objection for the reasons I stated, and I guess we'll see how things
Okay. Well, I mean,
transpire.
sounds like a maybe authentication objection, maybe.
Absolutely.
Okay. All right. So you're going to be put to the task of
As we are.
establishing that. Okay. How far away is the Mondo board? Okay, so Mr. Steele had brought a challenge to, and I may be misstating this, but I think to including, for the jury's consideration, I guess, overt acts that occurred prior in time to the RICO statute. Is that right?
Okay, so this is the big explosive part from Friday, right? We had a huge debate on overt acts. And remember what I told you guys those were, right? Remember the indictment? Those are all the counts in the indictment. That's what an overt act is. So Brian Steele has an objection to that. Let's see what he says and how Love responds.
Right. Or is it not? It could be not right.
I think it's right
Okay.
for verdict. So the example that, the obvious example that I use in my mind is there's 191 overt acts.
Right.
And let's say overt act, the rental of the Infinity happens on January 7th of 2015. That's the only overt act that's proven. Every other 190 are not proven. There would not be a conspiracy because the overt act is not within 5 years. So my point is, I understand that the conspiracy allegedly continues and the state of Georgia can put in, if the court permits, different examples of predicate acts and overt acts.
And do you agree that they can put in for consideration overt acts that occurred further back in time than the 5 years?
Yes, the case law says
Okay.
that that's
So-
appropriate.
Is your argument just that unless at least one of the overt acts that the jury finds, I'm going to have to start over because I can't remember how I started that. Unless at least one of them is within that 5-year statute, then they can't be convicted. That's your argument. Yeah.
Perfect.
I mean, I think y'all agree with that.
It's-
That it didn't sound like, that isn't what I understood your argument to be before, but if that's what your argument is, then yes, I agree. That appears to be the law.
So I'm not hearing that he's asking that 190, that there's a form for, that includes 190 overt acts on verdict form because, and this is the reason I'm asking about that, because any relevant information or evidence that is permitted at trial that constitutes an overt act. The overt act does not have to be alleged on the indictment, and we certainly don't, that list that is contained within count 1 has never been represented as an exhaustive list of overt acts. And the overt acts that we introduce at trial don't have to be included in count 1. And if the jury finds, I mean, I understand what Mr. Steele is saying, and I'm not arguing with that last summation that the court gave. But my point is that I understood him to be saying something akin to, I want a special verdict form that includes the overt acts that are listed on the indictment. And I want them to say if they found this one, this one, this one. And if the ones that they find occurred prior to 5 years before the indictment, then they cannot find the defendant guilty of that count 1.
If only the ones they find occurred more than 5 years prior.
Right. That's
Then
what
they
I
can't
understood
find
him to
them
be
guilty.
saying. Yes. So
We're all on the same page then.
So as long as we're not talking about listing out the 191,
Oh,
because
we
if-
might be talking about listing out the 191, because how can I know whether they found one within the statute unless they say yes or no as to each of them?
well, they could state, they don't have to, the reason that I would object to putting 191 is that it would limit them to consideration of 191. And if evidence of one that happened, for instance, during the course of this trial
Yeah.
is not on the indictment.
It's not, and they can, I mean, we haven't gotten to that, but I would think they can consider that potentially. But if the only thing they find is an overt act is something that occurred post-indictment in the jail, and that's the only thing they find, they can't be convicted because you
yes.
haven't indicted them for that.
Oh, Your Honor, yes, you can, and I will get that case law for the court.
Okay, well,
But
I'll
definitely
be
you can.
interested in seeing how they can get convicted of something they weren't indicted for, but okay. I have so much exciting case law to look forward to.
Yes, Your Honor, the court does. They were indicted for conspiracy to commit
to violate the Georgia Racketeer Influenced and Corrupt Organizations Act. The overt act, that's count one. The overt acts that are listed in the indictment it's
So, okay, they were indicted for conspiracy and
for,
A and B?
no, they were indicted for conspiracy.
Okay.
And so all the jury needs to find, after they find that there's an enterprise, that there's conspiracy, that people participated in it, only one person has to commit one overt act for the jury to find them guilty of count one. And not by them, I mean all of the people that they
As long as
determined
they
were
were
part of
all
the
in the
enterprise.
conspiracy.
Right. So if they find and believe that during the course of this trial, an act that is considered that can constitute an overt act was committed by either one of the defendants, then they have what the law requires to convict each of the defendants that they find participated in or conducted this conspiracy guilty of count one. So the notion that you enumerate 1 through 191 overt acts, and that you limit the jury's consideration to whether or not the overt act that they find the one person committed is within these 191 acts is not an accurate statement.
All right, well,
of
give me the law on that. That really wasn't what I was trying to address anyway. What I was trying, but I mean, we're going to have to deal with that as well.
She's digging a hole for herself. Do y'all see that? And real quick, I have her up on the screen. I really want to shout out Danielle. She is fantastic. Danielle, if you're looking for a researcher job, I'm about to hire you. I mean, Danielle is fantastic. She did put this on my radar a few days ago and mentioned how explosive this interaction was. In fact, she did a little bit of case research as well. Danielle's not a lawyer, but really, really enjoys researching. Can y'all do me a favor and just type Danielle in the chat? There are just so many valuable people in this community, and she is one of them. So Danielle, thank you so much for doing the research and sending all of that over. You're such a sweetheart for that. Thank you so much.
What I was trying to figure out is whether Mr. Steele was arguing that if it was outside of the 5-year statute, those overt acts either couldn't be considered, which he's not arguing, or couldn't be found, which he's also not arguing. He's just arguing they can't be convicted unless at least one of them is within the statute, which we all agree
If
to.
that's all he's
Okay.
arguing, then I don't have.
That's all he's arguing, but I'm going to need to know, because you're going to be arguing against that kind of a jury verdict,
The form.
and that they could find an overt act that occurred subsequent to the indictment and is therefore not contained within the indictment could form the sole basis for them being found guilty. And I'm going to need to know the law on that.
And to be clear, just to make sure that the court understands my position, not just that happened since the indictment. If there's an overt act that's not listed on the indictment that they find did occur, even if it happened pre-indictment,
Okay.
because we did not and do not have to include all of the overt acts committed in furtherance of this conspiracy.
Mm.
So that's the reason I would object to that.
You don't have to object to it. I'm not making a decision right now. I'm just saying I'm going to need the law on that.
Yes, Your Honor.
Okay. That an overt act not listed at all can be the sole basis for the conviction.
Assuming all the other elements are met, yes. That
Okay.
overt act,
All right.
yes.
And then I'll find on your Bruton thing, on your Bruton assertions, have you been able to get with the state to see if y'all can work out something redacted?
No, I was going to put it in writing first.
And then
And then,
get with them? Okay, that's fine.
well, I wasn't going to get with them, but
Get with someone from the state?
yes.
That's fine. I'm not gonna order you to get with Miss Love on anything.
You know, I have an interesting issue on it. If I can just
I know, but he minds getting with you, so,
make a statement, if it'll be in the motion,
okay.
But I find it interesting. So Bruton and then the newest Supreme Court precedent, all this will be in the motion for everyone to see. But as just discussed, the RICO conspiracy in count one,
Mhm.
I can't find a case yet, Your Honor. I will try to make it over the weekend. As soon as I get it, I'll send it to everyone. If I
Okay.
don't have it, though, I invite everybody. But it's the RICO conspiracy, and the Bruton then is not just like I eliminate everything Mr. Williams that Mr. Kendrick said. Anything inculpatory about Mr. Williams, I assume I can't cross-examine Mr. Kendrick, so I put that down the timestamp. I did the same for Mr. Stillwell. We did it together. So it's coming just easy for one motion.
Okay.
But he talks about Mr. Copeland, Mr. Arnold, all these people are supposed co-conspirators.
Right.
Well, according to the law of RICO, I assume, conspiracy, then Mr. Williams could be cleared of everything, but if he's found part of the conspiracy, then the act of Mr. Copeland is a act of Mr. Williams. So I'm having a struggle here. I don't want to, and I put it in here, I don't want to limit my redaction to just Mr. Williams, which I typically would do.
Right.
Okay, so I just want to highlight that.
Okay, well, that'll also be interesting. And that actually is an interesting issue. I'm not being facetious about that, which I kind of was about some of the other ones. Okay, well, to the extent that any of y'all can get your filings made, not that I want to spend my weekend reading it, but I'd rather be prepared for court on Monday than not. So if you get it done before, the middle of the night on Sunday night, please file it and get it to Miss Hurstfield so that she can get it to me so that I can start reading and digesting and considering it. So I like to be prepared. Okay, so where's the Mondo board?
Your Honor, that's what we're getting, and I keep
Okay.
pausing.
No, I didn't know you had to be the one in charge of getting it. I hope somebody else is wheeling it over.
Someone else is securing it for me.
All right. All right. So y'all always come up with new things. Is there anything new that we need to talk about in our time that we unexpectedly have this afternoon?
There is another issue, and I've thought about this recently, and it's going to come up, I believe. And that is previously in this trial, individuals who have pled, their plea agreements have been coming into evidence.
Right.
That was over objection.
Mhm.
I'm not sure why that was happening. I don't believe that's proper. And I've got to research it some more.
So you raised that a little bit before, and I thought I had basically said there's going to have to be a reason that something from the plea agreement becomes relevant. Like they're now saying that was not a voluntary plea, and then we could go through that.
Okay.
Are there other?
Well,
I mean, no, they should not wholesale. Are you talking about the transcript of the whole colloquy and everything, or the fact that they pled the conviction?
No, I'm not articulating well. The state, when they had each of these gentlemen plead
Okay.
guilty, they presented them with a plea agreement, which had certain terms and also certain acknowledgements.
Oh, like their deal.
Their deal,
Okay.
but then it lists certain factual acknowledgements
Okay.
that they acknowledge as true, and they
Okay.
initial them.
Sure.
And all this was prepared by the state and then initialed by the accused who pled guilty.
All right. And they were all counseled, right?
And they were all counseled.
Okay.
And those were previously Mr. Walter Murphy. There's been others
Okay.
have testified after entering a plea, and those have come in. Trontavious Stevens was another one.
Okay.
And their plea agreements are actually in evidence. Mr. Sledge has a plea agreement with these factual acknowledgements.
Uh-huh.
I don't believe, there's two things. just wholesale, I don't believe it's appropriate that those agreements prepared by the state and initialed by the defendants would necessarily come into evidence. It seems to me it would be the same as a police report coming into evidence. You got live testimony. Why would a written document that summarizes the live testimony come into evidence? So that would be A. But then also, specifically with Mr. Sledge, there's one acknowledgement that he makes, which I don't have it right in front of me, but I'm summarizing. He
Okay.
essentially says he either he believes or he has knowledge that people associated with the YSL are responsible for the killing of Donovan Thomas. My understanding is that is not based on anything other than hearsay and what he's heard, as opposed to being a witness or hearing anyone confess to it. That's my understanding from working hard on this case and interviewing witnesses. So I would object if these acknowledgements, if we let the acknowledgements in, if we do that, I would object to I would ask that anything be redacted that's not based on firsthand knowledge, because that's just an end around to hearsay.
Unless he's a co-conspirator and it comes in under the co-conspirator exception.
I'll just put it like this. I have no reason to believe that he received
it
any
would make
co-conspirator
that.
statements, and I have no reason to believe he has firsthand knowledge.
Okay.
So two things, Your Honor, regarding the
Hold on. Stop the show, guys. Hold on. Look at this. Shout out to Miss DC, who has given you guys 50 memberships. DC, thank you so much. She has been incredibly generous all week, guys. Like even on Friday, she gifted something like 100 memberships. Today, she's giving you another 50. I'm always surprised and baffled at y'all's generosity with each other. DC, thank you so much. If y'all just received one from DC, you know, a lot of you guys are waiting to get your memberships every day. We're like, it's like the lottery. And I can't believe how incredibly generous she has been. DC, thank you so much. Like on behalf of this chat, thank you. Seriously. And those of you that have received a membership, again, like I see you guys thanking her. Some of y'all are waiting for it. YouTube distributes these randomly. There's 4,000 people in the chat right now. So 50 people, 50 lucky people have received a very special membership from DC. I always love when, you know, women support other women. You know, in this sector, what we're doing, and I was thinking about this yesterday, what Lyin and I do in this sector is not always done. You know, shout out to Emily D. Baker. She has an enormous following of trial watch folks, but there's not a lot of people that look like me and Lyin doing this work. And people like DC, people like the little gaming channel, people like Edgar, so many of you guys that are funding the work that Lyin and I do, y'all have no idea what it means. There are days, like last week I was dragging. There were days where I would wake up and I'm like, oh, I got a trial stream or, oh, I got to do this video. But it's people like DC, it's people like so many of y'all that make it worth it and make it fun. And, you know, for those of you that really enjoyed this morning's discussion with the expert witness, and I'm like, how can I get better? How can I level up? How can I make this production better for them? When I see things like this, DC, it's like, keep going, girl. Keep going, sis. Don't give up. So DC, thank you. You have no idea what you're funding and definitely gonna make you proud. So thank you. And if you guys received it, please say thank you to her. She does not have to do this, but she did. So thank you so much, DC. You have no idea how much you mean to me as a creator and to this chat. Seriously. So quick update, guys. I wanted to stop the show really quickly to tell you what we're doing. We're just watching a clip from Friday. I am waiting for the courtroom. I do have that feed up. They were supposed to start at 12. It's 12:30. So as soon as the court starts, we will jump into today and see what they have going on. And then as a backup, I actually have the feed where Lyin and I were watching Brian Steele's opening argument. So worst case scenario, during our breaks, we will try to chip away at that so y'all can see our original reactions. But it's always great to see some of the opening arguments because Brian does go back to that pretty often. And you know what's so crazy? Lyin and I did that in November. Tell me why that stream has 17,000 views. Like nobody knew that we were covering this case, but now you know. So I think it would be really fun if we can revisit that. But let's go back to Love's debauchery here and her overt acts and what she's talking about. But again, if you received a membership from DC, she is giving you the key. She's giving you the key to cut the line. So thank you so much, DC. You are an amazing person, an amazing sister, and a completely generous human. So thank you so much for being so generous and so nice.
The comparison of the plea agreements to a police report, I would believe is inaccurate. We consistently, if I were to compare it to anything, that would be more applicable, it would seem to be a certified, perhaps copy of a conviction along with a transcript of the plea colloquy. In this particular case, the defendants that have pled have, with the advice of counsel and with the benefit of telling the state what they don't understand, having the state actually go through and change things as we have had to do on that factual acknowledgement form so that it is completely accurate. The defendants who've pled are now in a position to either say what they've acknowledged previously under oath on the stand or be impeached by it. And that partly is part of the reason that we've had to introduce
Is
those.
that the way they've been coming in, as prior inconsistent statements or evidence of prior inconsistent statements?
Right. So what we have done generally is we have asked them questions that pertain to maybe one or two. Like we're going down the list of questions. And all of a sudden our memory gets fuzzy.
Right.
And all of a sudden we don't know that 3 means not you. It means 3 different people. And so at that point where we see that, you know, a person is attempting to conceal information, we bring out the plea colloquy and we ask them to read.
Okay, so you give it to them to offer to refresh their recollection?
No, Your Honor, we believe that that plea colloquy is admissible evidence. It is relevant evidence. There's nothing under 403 that would permit its exclusion. So we offer the factual acknowledgments that are a part of the plea agreement that they have signed as substantive evidence, as tangible, as evidence in this case.
Okay, I think it could be substantive evidence if they basically
get amnesia,
disavow all of those things. But if there are 11, say, factual acknowledgments that they've made and they disavow one of them, then the whole thing shouldn't come in necessarily. And it sounds like maybe that's what you've been doing.
No,
I don't know.
that's not what we've been doing. Just have them disavow one. What has been happening is insinuations that I wasn't exactly clear. I didn't know what I was reading. I didn't know what I was doing. I didn't understand the meaning of the word is. Things like that have been made on the stand under oath by the defendants who've pled. And
did y'all take down and record or transcribe or in any way memorialize the back and forth that led to each of these, where they were able to say, I don't understand this, if they didn't understand something?
In some instances, they were actually captured on camera, and not in all instances, but their lawyer was present, and the lawyer served as the go-between to say to us, and we could have, you know, if counsel for any of them needed to come in and proffer as officers of the court how that took place outside the presence of the jury, we could do that. But in each case, the lawyers, every one of them, have come back and said, he doesn't agree to this, he agrees to this. So that occurred. And again, is in some instances on camera, where we were reading through the
Mhm.
factual acknowledgments, or we were reading through the plea agreement as it was taken, we've been stopped by the defendant at the table.
So I would think that if they are now saying, I didn't understand it, and you have something that shows that they had every opportunity to ask questions, get clarification, and then they, after that, go ahead and sign it, that's the way you impeach their statement on the stand that they don't understand it. Yeah,
Judge,
well,
I am not representing to this court that the only basis for our tendering that exhibit is the fact that they said they didn't understand it. That was one piece of.
All right, guys, I'm seeing some movement in the courtroom. So we are going to switch from DA Love shenanigans to these shenanigans. Let me share this.
Notice to us back in November of last year.
Right,
concerning
we're
item
alive, guys.
43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, and give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When
So,
was that?
that would have been in 2000. It was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming
that
in.
was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agreed, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic. I do think that it somehow meets one of those thresholds.
Right.
Then the court will go to the next step of whether or not there should be a 403 analysis
Sure.
to determine whether it comes in. So with that being said, in Hines versus the state that I previously cited,
Mhm.
there was an intrinsic act, and the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant
I was talking on mute. What I meant to say, quick interruption, huge shout out to Here Comes Drama. If you got a membership from her, she just gave out 10. Please say thank you. We are starting the day a little bit late. Court started at about 5-10 minutes ago at this point. So we started our day with a few other things. We are looking at Attorney Matthews, the Silver Fox here for the ladies that are commenting on this gentleman. He is the attorney for Huey. And he is starting the day with an argument really centered on one thing. Yesterday, DA Love tried to tack on additional crimes. With his particular defendant, there is a police chase that she's trying to bring in. He is arguing against bringing that in because that is detrimental to his client. But remember what a lot of the key themes we've been talking about. A lot of the key themes we've been talking about is this. What is on the original indictment, right? And what are the overt acts that are specific to each person? If we go to Huey, I think he's right here, Marcavius Huey, aka Quay. He has a lot. So Matthews has a lot to defend. He has count 1, 3, 4, 5, 6, 7, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 44, 45, and 46. So DA Love, if you are going to try to tack another one on when Matthews has to defend all of this, it's not particularly helpful. Now, what Matthews is looking at, remember, I showed you guys this yesterday. This is Rule 404, right? Under the federal rules of evidence. There are things you can bring in for character evidence, right? But when it comes to other crimes and wrongs and acts, you can bring them in to show someone's character, but you should not be bringing them in to add additional charges. That's what we're seeing him argue right now. Just wanted to give you guys some context. We have a little bit of TiVo time, but really we're about a minute behind the live feed. So thank you everyone who shared that the feed was up and running. But that is what we're watching right now. And it is likely we're going to see some of the other defense attorneys talk about their clients specifically and what they don't want coming in. Yesterday, we saw Shard argue for Stillwell. Why are we bringing in Shannon having a shank and, you know, things that happen in jail? We saw that for another defendant yesterday as well, Angela's client. You know, he got involved with the drugs or whatever. Same thing, Jeffrey Williams. Someone gave him Percocets, but now you're trying to add additional charges for things that happened after this indictment. That's not okay. And that's what these defense attorneys are going to continue to argue against today. Let's go back in.
There was a word that was used that she maltreated or injured or harmed her children, and the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character. It's going to go to propensity. And it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that that video could be played without the audio?
I imagine they could potentially play it without the audio. But there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those 3 items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by a preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge observed her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
he was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And
Mhm.
so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And
do you have evidence that he knew that? Such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they talking about.
All right, what? Okay, so, and the chase is November 30th, so this is several weeks before then.
Correct.
Okay.
And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least was going to, had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th of 2021. So that's all the evidence that I would have.
All right,
outside.
well, I mean, given that he says, yeah, they might lock me up, maybe they won't, I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But yeah,
Yay.
I would just argue that he's fleeing from the armed robbery.
I
that
know
he's-
you're arguing that, but it's my ruling, so.
Wow, guys, look at that. And shout out to all of you that are talking about the audio. Of course, the courtroom audio is all over the place. Simone is not speaking into the mic right now. So that's part of the problem. The judge is, I am. I have to press pause in between so that way I don't blow y'all's ears out. But it looks like Attorney Matthews was just successful in getting this out. So they cannot use that. And I was just over here doing a little bit of research. The reason why is whenever there is evidence that comes in, there's this rule, it's called Rule 401, and there's a test for relevant evidence. The evidence is relevant if it could do two things. One, it has a tendency to make any fact more or less probable than it would be without the evidence. So that means it needs to be really important. And then two, it's a fact of consequence in determining the action. The judge did not believe that what Simone was arguing was relevant. You know, just because you have this police chase doesn't mean that it is proving anything that Huey is doing with regard to Rico. The answer here is no. It's an unrelated matter. If you're not bringing it in for character, you don't need it. So you can even see after the judge made her ruling, Simone still tried to come back. She's like, I guess I understand that you're arguing it, but guess what? No. So shout out to the judge actually giving the defense a slight win, and shout out to Matthews. He did an excellent job. What do you guys think about Matthews there? I think he did a great job, you know, explaining why it should stay out to the judge. He was prepared. He had case law. He was ready. He was referencing the rules, the rule that I just showed you guys. Matthews is doing well. His son is his, you know, he's an attorney, and his son works with him at his firm, as well as his daughter. And I believe his son is in the courtroom right now. You could see them just behind Simone back here on the right-hand side of your screen. So again, guys, we do have some audio considerations. I'm going to do my best to make it as comfortable for you as possible, and we'll go from there. So Simone did not win that one. Let's hit play and let's go back in.
Thank you.
All right. All right, and with regard to the two kind of post-indictment intrinsic acts or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet. I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet in any of the three requirements for intrinsic evidence. And then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling yet, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
May we offer some case law for the court?
Sure.
We'd offer to the court an 11th Circuit case decided June 20th, 2024, United States versus Harding, Harding. The site being 2024 US app Lexus 14995.
Okay, and what does it say?
Your Honor.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it.
Okay.
And it's just standing for the proposition, generally that an act that occurs after the indictment can be included.
Yeah, okay. No, I've found my own cases that say that. Yeah, that's clear. It's not, post-indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right. I mean, I
Voice is
got
just
it.
floating.
It's just,
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would support to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I'll look at I don't know if I really need to look at the Harding case because we've already kind of established that issue is not really an issue.
right.
But I'll be happy to look for some additional case law. and
Okay,
send it to
thank
the
you.
court.
Appreciate it.
Your Honor, you had
Yes.
asked the
She's
same,
talking
I'm
now.
sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay.
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia 178.
And what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, US v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
Okay. And the last one is Hughes versus State, 312 Georgia 149. And we too will present to the court a more coherent sort of overall arching.
All right, appreciate it.
argument.
Okay. All right, so where do we want to turn now? What are y'all ready to talk about?
So Judge, if the court likes, we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Bruton motion redactions. So I'll let counsel for defendant Williams speak to them, because this is Mr. Kendrick's statement that is already in. There are portions that he is arguing are inadmissible because of Bruton. Our position overall is that Bruton specifically requires that that a defendant be directly inculpated, and at these various points, I'll let them explain why they feel like someone is directly inculpated so that I can respond, but we've reviewed them and whenever the courts.
All right, so
Okay, so here's what's happening now, guys. We just went through the Matthews team getting a win for Huey, so that was good. We decided that they, both the Williams team, so Young Thug's team, they are not yet ready to have the argument about the Percocets, but if the judge is ruling in Matthews' favor, then it's likely that we're going to be pretty good on those arguments as well. So we're going to get to that one. And then that other woman, you guys didn't recognize her. She is the defense attorney. It was the white woman who spoke for a little bit. The thing is with her, she has an argument as well for her client for one of the intrinsic acts that happened after the fact. She's not ready either. So hopefully we'll get answers on those two. Where we are shifting right now is going to be an interesting argument. I'm excited about this one. Here's what we're going to see. So yesterday, Brian Steele had an issue with Diamante Kendrick's, one of his interviews or something along those lines. Remember, we were talking about severing him as a defendant. It sounds like the judge does not want to do that, but there are some statements that he made that the prosecution wants to keep in. Brian does not want in at all. And there was a big focus on one particular case. It was called Bruton. Okay, I'll see if I can pull it up for you guys. So in between breaks, we can look at that case and see what it stands for, what it means. Brian really doesn't want this in. So we're now going to look at the defense teams, what their arguments are to keep it out. And of course, DA Love, her arguments to keep it in. So that's what we're watching right now. Let's see how this shakes out.
So is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Bruton?
No, there's one enumerated time area.
Which one is that?
And they have it enumerated as.
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement?
Yeah, that's the one at issue right now. Yes. And maybe you did. Obviously, I'm getting lots of emails through Miss Persifield from all of y'all, but I don't recall seeing it. Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay,
Mr.
so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004. So that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr.
Okay.
Stillwell telling detectives who they say
All right,
killed.
that's 8. But, okay, and you agree that that should be excised?
Partially, because what happens is that this is the part that we would ask, that we specifically would argue is not inculcating anyone.
Okay.
What Mr. Kendrick says is they say our crew.
Uh-huh.
And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And they specifically say, who within your crew?
Uh-huh.
And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on
Okay.
this sheet of paper. So they say Shannon, we would agree comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr. Kendrick identifies as his crew, or, in acknowledging that there's a crew, we would argue that part, we would agree, concede that part definitely comes out.
Okay, so you're saying that they say our crew isn't Bruton, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
Can be
I would say that
redacted.
specifically it's
Okay.
Shannon comes
Shannon.
out.
they
Yes.
s- Okay. All right, and every other one we're gonna need to look at.
And yes, I believe we should look
Okay.
at the rest of them.
And has anybody come up with any case law about kind of the interplay between Bruton and a RICO or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that. Uh-huh.
If the state, if I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not ask the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video
In
by-
toto.
right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And
Okay.
generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of
Okay.
Bruton.
All right, well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
Yeah, sure. So just let them know which of the portions, but okay, let's go through all of these if we need to, which it sounds like we need to. So do you want me to be, is there a transcript for this statement or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can. I don't know how they're gonna do this. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time and they.
Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay,
Yeah.
sure.
Can I just bring up another concern on this
Uh-huh.
subject? The concerns aren't limited to Bruton. I still like, we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying
Yeah,
that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Relev's going to say we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Bruton is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally speaking, what?
Look at Weinstein's
Let me ask you
face.
this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick?
Hold on, let's go back. Even Doug is looking at her like, lady, if you don't sit down and tighten up this argument. Look at Doug. Doug didn't even have his glasses on. Now he's about to put them on. And Diamante is sitting right next to him. Doug is really paying attention to this because this is in regards to his client, right? Let's see what her very strong argument should be. Look at Doug.
Generally speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think XYZ is relevant. The relevant part is his acknowledgement that
Our crew
was beefing with them.
Okay.
There was a us and a them that was in conflict.
Okay, so then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay,
Thank you for actually.
all right, so when we're going through any of these other ones, if there's something similar, just kind of let us know that, okay?
And Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So, no, I don't think so, but if we're gonna go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele? Okay. Okay.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Bruton.
Right. Sure. Yeah, oh, that just took me out. All right, what are we on? Let's skip ahead. Any other little discrete items we can deal with while we're waiting? Nope. Is she looking for something? Is that what we're waiting for? Oh. Yeah, somebody said get the crickets for the soundboard. I think I'm gonna do that tonight.
Yeah, we could look at the operation planner's policy, or that might be too long.
I mean, we're certainly gonna have to do that. I guess we can get started on that. Unless we're really close. 1 minute away. All right, we'll just hold for a minute. Or so, or so.
Well, we have.
Come on, Mr. Kokobo. No pressure. Mr. Steele, how'd your oral argument go this morning?
Oh, tell us, Brian.
The argument was good, but no one remembers the argument, so we'll see what the opinion is.
Okay. Yeah, sure. I mean, we might as well fill our time some way.
So it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, waives formal reading, et cetera. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an accusation. So the Supreme Court was very lively. I mean,
Interesting.
it was an interesting case. And then it got so narrow. I was being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So
Yeah.
that's what I said. But it was fascinating. It was intellectually stimulating.
Interesting.
And thank you for letting me attend.
Absolutely.
So, Your Honor, this should have, if I'm using
Okay.
time space, please correct me somebody, but this is 50. I just want to.
This is October 12th.
No, that's 46.
We spent all that time on the.
Well, since we have time, Shatika, let's go.
But it was deep. So, so was ethics.
How'd your oral argument go this morning?
Oh, guys, you see her face? When she asked Brian that question, look at Love's face on the bottom left-hand corner. That is worth a screen grab. She's just like, oh, who cares about his oral argument? Well, you over here fumbling around, so we might as well. So that was a nice layup by the judge. We do have some TiVo time, so I'm gonna skip ahead. Apparently, we're waiting on something from the state. They're looking for something. It's about a minute away. I don't know if it's lunchtime or whatever the case may be. But yes, this look on Love's face is priceless. A shout out to Shatika, who suggested that we go back and look at it.
Start making our way through that unless, are we ready now on the right one? Okay. So we want October 6th, is that right? Okay.
Ah, okay. They're trying to play a video. That's what it is. Okay, well, I got TiVo time, so let's see if we can skip ahead.
A AV issue at this point.
Oh, they talking about me?
This is a lawyer issue, not a AV issue at this point.
Oh, listen, that should be on the soundboard. This is a lawyer issue, not an AV issue. I love my initials. That was amazing. Could y'all type, shout out to me, type AV in the chat.
Okay.
But this is I hate to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay.
Geez, they still don't have it up yet. Pause. Jesus, all of this for a video.
Stamps were somewhat off, but can you get close?
We don't have it up. Can we get close?
Maybe we just go that way, since this seems to be taking longer than we had anticipated.
Come on, get it up. You can do it. Y'all can get it up. Can we get close? Jeez. Still nothing. Okay, here we go. We got it up, guys. We got it up.
The defense thinks they've got it and the state thinks they've got it. So the defense has got it. All right, let's do it. Yes.
Just to avoid the inevitable confusion, the numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer. Correct?
Okay. All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
Do you want this marked? I assume we have to have this marked somehow, we can put on thumb drive.
What we're playing now?
Yeah, but in case God forbid there's an appeal, do you want just to know what we were looking at since we're saying 50 and we could do that?
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Bruton motion.
Can we call the exhibit that?
Yeah. Yes. So this will just be Defense Exhibit 1 to the Williams Bruton motion concerning Mr. Kendrick's statements.
And we'll have that thumb drive today.
Thank you.
No, thank you.
Oh, thank you, Mr. Ham.
Like, I think of other people you associate with. Probably. Anybody you can think of? Oh, yeah, man, of course, there ain't no question, but it ain't like, it's not some whole other shit. Like, it's like my rep pump. Like, we do shows, he help me out. He said, like, he bring me on to his show, just help me, just stay above. So,
Yes, guys, this is Yak Gotti. This is his interrogation with police, and I think he's in custody.
Okay.
And it should be Detective Gaither saying, third, is that the possible reason that people went after that meeting in retaliation? That's what it should be. So it's the detective asking the question. That's why I don't know if it's going to be needed because of the question, but that's the first.
All right, and it's, give me just a little bit more general idea of what they're talking about at this point in time.
Okay.
Yes.
Detective Dennis is in here, Detective Gaither's in here. Detective Gaither's a female, Detective
Yeah.
Dennis is a male. And the gentleman in custody is Mr. Kendrick.
Yeah.
And Detective Dennis at 48, 41 is bringing up that Mr. Arnold, the co-indictee, pled guilty. He also goes by Duke. Regarding the incident where Mr. Kendrick was tased, he was actually chased by police and tased.
Okay.
And Mr. Kendrick then mentions Duke or Mr. Arnold about the involvement in that, and he challenged that, but I don't think that's a proven issue. And then Detective Gaither talking about Duke, and then going right into whether Thug is a reason that people went after them, meaning that there was this.
Why, whatever that incident was,
Yes.
occurred. Okay.
So, to me, I'm doing, I think, what the court wants, but this will never come up on a question answer. because no one's going to say to Detective Gaither, I would hope, did you ask about Jeffrey Williams to Mr. Kendrick? It wouldn't happen like that, but that's the first one.
Okay, well then, maybe we can nip that one in the bud.
So there's, if Mr. Steele would not mind just letting that part play from 49
Okay.
so that we could.
Don't want to bust you, but them is 40 over here. When I got tased on Bankhead over here, when I got on Collins Boulevard, that hell, man, I was leaving my little boy from born, so I had that. He was in the car. It's like, man, y'all see all this shit going on. You got it to me. I try to keep one then with that one, cause it's like this shit go down anytime. Like, man, he can have he been on some hang, jealousy. So why they coming at? I ain't talking about Duke. I ain't talking about what folks roll. Why they coming at you? They thinking like I'm bad at it. They think I think I'm bad. Cause I used to carry myself. Like I see because of other people you associate with. Probably. Anybody you can think of? Oh, of course, that ain't no question, but that ain't like that's on some whole lot of like that's like my rep pump. Like, we do shows, he help me out. He said like he bring me on to his show, just help me just sell both. So I don't know why Coin, would you feel like I took your part, your spot? A lot of people feel like Bloody J. A lot of people feel like I took their spot. You know what I'm saying? But it's not. I don't get around on them try to take on niggas. I'm grown.
Okay, so some of you guys are asking for a translation. We know that these videos are extremely hard to listen to. I did kind of jot down what Brian Steele was saying as well. What we are watching is an interrogation piece of footage with Yak Gotti, Diamante Kendrick, one of the defendants in the case. He's sitting up front with Doug Weinstein. This is his client. Now, Brian has an issue with this footage because there are some things that he says that, you know, when he refers to Young Thug, he talks about our crew, things that elicit that YSL is a gang. And of course, you know, Brian Steele does not want that type of evidence in. Okay. He says things about what other people are saying. And right now we're in the middle of a Bruton, which is the case that we're using to argue. We have a Bruton argument happening on both sides right now. This tape is really important footage with that. You see Detective Gaither, she's not visible. You also see Detective Dennis in the room and they're asking him questions, right? So this is Yak Gotti. Now, he's talking about Young Thug. I did hear him say that they do shows together, things like that. Pay attention to the fact that he is not wearing handcuffs. So it's unclear whether or not he's in custody, but it does look like he is wearing a jumpsuit. But this is around the time that he was discussing his plea deal. Okay, so that's what's going on. I'm going to try to take notes and let you guys hear it. Of course, we know that the captions are not the best, but that is what's going on with this piece of footage. And after we see this, Love is going to make her arguments on why something like this should stay in.
Oh man, I got whatever I got going on. He was just grown, bro. Got smacked. Grown man, man. So like, but then somebody had to tell me like, bro, you know these folks like they spot. Right. I had to think about it, look at it from other people's perspective. Okay, that may be what it is. Yeah, but everybody.
Okay, so Your Honor, there's no part that I hear Mr. Williams' name mentioned in there. I didn't hear Thug or Mr. Williams' name mentioned, so I don't.
Okay, well, let's just ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this interview?
He's right there in front of you. To the left.
Oh, okay. I thought you had said Dennis and Gaither.
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to his
also
right.
in there.
He
Okay,
is.
all right.
There are three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why
No.
Okay, so
absolutely
that
not.
would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether defendant Williams was
All right, well, let's
whatever.
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay? That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Bruton is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed, though. If, you know, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about whoever they is, wanting to take my spot.
Yes.
Okay.
They
And
are
that I
back.
contend is not Bruton.
That would not be Bruton. Okay. Next.
So interesting. They are back. And also the judge did coach her there. You guys are asking about that. Why did the judge coach her? She coached her to give her shorter answers. Okay. So instead of all this long glitching, scrambling and scraping, all of that, she can simplify that to one sentence. Judge, it should stay in because we don't intend to use the full part. That's it. That's it. There are parts we're not going to use. Simple argument. One sentence long, not scrambling and scraping, not glitching, not that, you know, like it's not, she's trying to help her save some time and save everybody some time. So, you know, that is coaching, but at the same time, it's really to move things along, right? Let's get back to this footage.
5239, and it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay. And then you know, you wouldn't be able to mention Mr. Stillwell. Is there some part of this little
So
bit? Go ahead.
I'm sorry.
Go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Bruton does not prohibit the mentioning of.
All right, let me just hear it. I see this is the way it's going to go.
Playing from 5214.
And this is before buying the gun for what? What are we talking about here?
Oh, I'm sorry.
Anybody?
So one of he was stopped with a gun in October and one on January 28th. And they're talking about the guns that he had in those situations. January 28th, of 2015.
All right, and these are overt acts, or are they?
Yes. One is an intrinsic, January 28th.
Okay. All right, go ahead.
Why not just bring it? True. But I mean, like, my first man like fuck these big ass guns, but the second man like I got to ride with someone to check myself. Yeah, like right. How long had you had it? Like a couple days. A couple days. Yeah.
Did you buy it after you spoke with Shannon?
I bought like before all this stuff happened.
I don't think you, that's, you can
But
stop it. That seems pretty inculpatory of another defendant. Did you buy it after you talked to this person? As if, no. Don't,
Leave that part out.
that
Got
one's
it.
out. Okay. Next.
It's right after that, but it's the same thing, Your Honor. Now it's Mr. Kendrick speaking about Mr. Stillwell. He includes Mr. Arnold as well to clarify what Detective Dennis just said about the gun. And that's at 52:51.
Hey, Judge, just to go back just a bit, he wasn't saying that Shannon told him to buy the gun. He was orienting Mr. Kendrick as to a conversation with Shannon. It wasn't saying that Shannon tell you to buy the gun. So it wasn't inculpating Shannon. I think that it may be helpful to hear before the part that they started on. It's like, did you talk to Miss Hilton? Yes. Did you buy the gun after you talked to Miss Hilton? Yes. But it has nothing to do with Miss Hilton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants? Okay. Just seems too brutish to me to permit. And the state ought to want to try a clean case.
We do.
So
That's fine. We don't
that
have to
would not
keep
be
that
clean.
in. Okay.
All right, so that's a win for the defense. That part's coming out. And guys, real quick, we got a tweet from Thugger Daily, the latest and clarification. And this is for the record. Shout out to Yak Gotti. For the record, Yak Gotti never cooperated, but the state wants to use this portion of his 2015 interview. That's why I was trying to figure out if he was in custody. It does look like he's wearing the jail uniform. Okay. So I don't think that he cooperated, and I trust Thugger Daily as a source. So let's remember, we're not putting Yak Gotti in the same bucket as Woody. He's one of the defendants, but there is that statement that was looking like it implicated someone, and what that means is that it indicates that one of the other defendants is guilty. And what we're talking about is that statement about the gun that the judge just ruled against. That statement is not coming in. So another big win. That's a win for Brian Steele and Thug on that one.
Go ahead. Next one.
This is 52:50. You should back it up. This should be Mr. Kendrick. Mr. Kendrick bringing up Mr. Stillwell and Mr. Arnold about clarifying the answer that you were just discussing, although I think that's out, actually. So it's really 54 minutes we can go to, and that should be Mr. Kendrick. And he mentions Mr. Copeland, Duke, or Mr. Arnold, and Rich Homie Kwan, Mr. Lamar, and Mr. Stillwell. And he doesn't want to be associated with them. So we ask that Mr. Stillwell's name be redacted.
All right, well, I'll listen to it. Okay, give me enough so that I can hear the context of why he said it.
Wait. See, that's why I be a man. That's why I fuck up it. I be on more of a defense. It's like, if I wouldn't got that call, I would stay asleep. Right. It show you that though, like I'm so much of a good partner and friend, that way it hurt me. You know what I'm saying? Yeah. Well, I'm in shit. This like it. And he get to go with it, like he get out before me and all that and this shit. Yeah. So it's like, God damn, bro. Like, see it, and that's why I feel back from the people who y'all just saying, which was my original crew member, like the people I was rocking with. That's why I feel back. So it's like I ain't get 100% from none of them. So it's like y'all ain't gonna be getting my 100%.
Who are you speaking of when you said that?
From Shannon Wood, whoever, dude, it's just everybody here, going, like everybody, cause all of us have been together at once, like all of us now rock, joke on all of us. So it's like, once I figured out, I was like, I don't want no part of it, you feel like, so it's like, what are you gonna?
All right, I mean, he says some about being regular crew members and not getting 100% from them and then saying them by name. I think that's a brutal issue. So, would you understand if you do intend to ask about this?
Not having to mention Shannon's name.
Correct. Okay. All right.
Your honors, should be around 58:10, and of course, they'll announce the time to orient, but this is now Detective Dennis's voice, who's mentioned Mr. Stillwell swung first outside of Club Crucial. That's the fight that you've been hearing about on the 6th day of January, 2015.
Uh-oh.
And it goes on to that event. And
So is this just because Mr. Williams' studio is mentioned?
Another update from Thugger Daily. He says a majority of this interview was already thrown out by Glanville because police illegally continued to question Yak Gotti after he asked for a lawyer. The first portion, under 2 hours of the interview, can only be used against Yak Gotti himself and no one else, as he is a non-testifying co-defendant. Any parts that may be directly incriminating to a co-defendant are under dispute in a Bruton motion by Steele and Sharp right now. Okay, and for those that are asking, a Bruton motion, also known as a Bruton motion or a Ronda Bruton motion, is a request filed by a criminal defense attorney or a public defender to prevent co-defendant's damaging statement from being presented to a jury during a joint criminal trial. The motion is based on the idea that the statement would violate the defendant's constitutional right to confrontation, which includes the right to cross-examine the witness. So as you guys can see, what they're trying to get out is the names where one defendant is dropping the name of another defendant. So we heard him say Shannon's name. Brian is trying to get the statements where he says Jeffrey Williams' name excluded. So far, the judge is playing ball with them. She's telling DA Love, okay, if we play this, guess what? Anytime that he is saying someone else's name, we're not going to use it. So far, I think we've seen about 2 or 3 strikes of the names, and Brian is going in on the next one. And remember, guys, the names must be named, but in this scenario, the names are not going to be named.
Well,
To orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where, actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that event. And that is, it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's Girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first time hearing about it, so I wanted that excluded.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references him
His
as,
girl being a victim.
right.
Okay, yeah, I mean, I don't think it's a brutal.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it, so we're now
Right.
just using
So
the
now we have
question.
a relevance objection. No, we'll do all at the same time, so
So,
we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108, 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing. with
our crew were beefing with
them.
the other group. But not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be one. It's really the same flow, but it's 108:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We
So
don't have any intent to bring that out.
Any of that?
Right.
Okay.
Okay, the next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay. The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asked, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did. It was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug being mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And it's up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a brutal violation if you ask or get an answer that talks about the Infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, NARD, and DUWOP, DUWOP, where they are now. And Mr. Kendrick explains he's almost questionably locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd
My-
like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay. The next one,
The part about Mr. Stillwell being locked up, the other
Right.
part, yeah.
Yeah.
the next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody. And then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says, yes. He says, yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out, the picture and the pointing.
Well,
This is just him saying, here's who all went to Miami.
Yes, immediately after
Doesn't
the killing.
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Bruton violation.
Okay, we're just raising objections then, if that's okay. When I say okay, I'm not waiving anything.
I understand.
Okay, I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah, so I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay, so the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included,
That
I
doesn't-
skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that, because I didn't count that as inculpating, because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just
because
hear that part because I'm not sure what it says. And
Started about 1:22:40, if you can, Mr.
Okay.
Kokomo. And what it should say is, it should be Detective Dennis
Okay.
asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So y'all started to get worried, and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Stillwell was probably getting calls.
all right, let's just hear.
Why no conversation?
Everybody just sitting there like,
I was just stoned with it. Like, I get my own strong heart.
right, but what I'm saying is, the ride down had to be some type of,
I don't know. I didn't
because
know
it's
anything.
just like you just said, when Duke got jumped on.
All right, we're going up to the next piece, but guys, listen, Thugger Daily is a brother to this channel, so we're not gonna talk about it anymore. We're gonna move on, okay? But we're going back to these discussions. I do have the particular crimes that Yak Gotti was charged with himself, and these discussions are about himself, and that's what we're looking at. We're trying to see if these other defendants are going to be pulled into this conversation. And right now, the judge is saying no, that they should not be pulled into this discussion and implicated in his stuff. The only person that should get charged with Yak Gotti's crimes is Yak Gotti, right? So we're gonna leave it alone there and then just continue. But huge shout out to Thugger Daily. That's a brother to the channel, and he's supported what I've been doing for months. So if y'all could just be respectful about it, you're entitled to your opinion. All good, all good. We have tons of videos on snitching over here, so you could check those out and keep the discussion over there. But let's keep it positive and keep going.
People start hitting your line. What's going down? So y'all had to start getting word that these names are out there. As Nut just got killed.
Yeah, but they're like, they probably got again, like calls and saying shit, like they think it was them, but it wasn't no matter country or folk want to call me, like, yeah, you know what I'm saying? They want.
But if they your people, it's almost like you guilty by association to an extent where if this happens.
We wouldn't have any problem taking that whole last 2 or 3 sentences out. Like they were probably getting calls thinking it was them. And then Dennis saying it was your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes,
Okay.
yes.
Okay,
Excuse me, Your Honor, can we take 5 minutes before we continue down the list?
sure. Yeah, that's fine. Let's take a quick break.
All right. Sure. First break of the day, bringing us up to speed. We are now absolutely live. I'm going to keep us over here. Let's read some super chats while we're on break. I had about 4 minutes of TiVo time, so they should be back any moment. Where do we leave off with supers earlier? I think we were somewhere around, we got Scotty, we got Carl. Carl says this is why he drives an old truck. And this is when I had my expert witness on, guys. If you want to keep track of that conversation, skip to the very beginning of this video. You can just rewind it. I had a great conversation with an expert witness that talked about some of the cell phone data that's going to be coming in on this particular case. Shout out to Deshonda, who became a member. Welcome, sis. You're going to love it here. Shout out to Chris with the 199. She says, I wonder how training went yesterday. So listen, training for the district attorney's office on Brady evidence took place yesterday from 9 a.m. to 12 p.m. And that's why we started court late, because the judge mandated that this district attorney's office needs to understand what Brady material is, and they need to learn how to turn it over to the defense. Now, a lot of people are saying that that was a slap on the wrist and not a proper way to handle it. They know better. If you have something that says, if they have a statement from Little Woody saying that he killed Nut, then we're kind of wasting everybody's time here by trying these people for crimes that they did not commit, things like that. So thank you so much, Chris. Shout out to your main man, Mush. He always gets me with this long name. $2 says, damn, Love's rump is rumping. My goodness. Okay, listen, some of y'all older brothers in the chat, shout out to Mike. They're like, I want to see it. Let me see it. Y'all are too funny. Shout out to Emmanuel with the $5. Says super shout out to AV. Only the platform owner can authenticate posts on social media. The state loses on this issue as to overt acts. Yes, we were going back to that. The expert kind of talked about that earlier when we were having that discussion. But we also went back to Friday when she was trying to bring some of these foolish things in. Shout out to King Brown with the $5. Says, I searched ChatGPT and found out the color purple is connected to Black girls. I was curious to why so much purple, Miss Love. Oh, the fact that she uses purple and she has purple fingernails today. That's interesting. You went down a ChatGPT rabbit hole. Thank you so much, King. Shout out to Audrey with 499 says, just wondering how much the state has spent on this case to date. Girl, I mean, it's got to be over $1 million. We were also talking to the expert about that, because just Little Woody's testimony alone, if they had to go and validate everything he said using his digital fingerprints, everything he did back in 2015, whether to prove if he was lying or not, that's a job in itself. So thank you so much, Audrey. Shout out to the Little Gaming channel, TLGC, one of the pillars on this channel. He says, I will never understand how you can hold people in jail this long without them being convicted and without reasonable bail. You are guilty until proven innocent. And what about a speedy trial? Nothing about this is speedy. 100% agree. half of these gentlemen cannot get bond. So even if they wanted to bail out, they can't. They're stuck in there. They're stuck in there until this trial is over. And the projection right now is in Q1 of next year. So really, really tough. But thank you so much, Little Gaming Channel, for the for the 19.99. I believe it was the stream, one of the stream sponsors yesterday. So thank you so much. DC gifted y'all 50 memberships. Great sister. That was amazingly nice of her. And we covered that earlier. Little White Dog with 199 says, love is a hot mess. Totally agree. Jeff J says, and Jeff, you left a few of these, so thank you for that. He says, how can the judge allow the prosecution to dump a ton of evidence on the defense and say, good luck guessing what we might use? Ambush trial. And that's what she's trying to prevent all of this week. You know, this week, it's like, all right, you can't just bring in whatever you want. Now we're going to look at everything you're bringing in. Let's look at your witness list. Who are you bringing this stuff through? Who is it coming in through? Right? So an example of that, the video we were just watching before break, that's coming in through Detective Thorpe, right? So they are looking at the remaining witness list, and we're preparing for that. Last week, we prepared for Antonio Sledge, Moontunk. So yesterday, we were talking about the money phone, some of these crazy meme texts and all that stuff. Good thing the judge did that. Imagine if that happened on the spot in front of the jury, trying to bring in a meme. What does that have to do with anything? So it's crazy, but it's good that we are taking the time to do this, because otherwise, Jeff is right here. It would be an ambush trial. Shout out to Here Comes Drama, who gifted some memberships as well. She is amazing. Jeff is back, and he says, we intend to present the entire internet. Good luck with your very specific objections, defense. Horrible. Correct. And Jeff has some sarcasm here, but he's right. It's just like they're just throwing anything at the wall to see what sticks, like throwing spaghetti at the wall to see if it sticks. And that's just not how you conduct yourself as a prosecutor in a very thorough trial. And now that I'm thinking about it, guys, I want to see if I could get some of my friends that are prosecutors on here to see, you know, what they think of this. Like, is this how you prepare for your trials? But at the same time, this trial is so big. It's so big. It's massive. How did they prepare for it? So I'm really, really curious about that. Shout out to Vita, who became a new member. Rob became a new member. Sunnyside became a new member. Thank you so much, sis. Jeff is back with another question, another comment, $4.99. He says, prosecution's case. Someone in Georgia did something wrong at some time. Prove us wrong. Jeff is funny, but he's not wrong. I mean, with the sarcasm here, you know, like, look at how much of a blanket statement it is. Someone did something wrong at some time. Prove us wrong. Like, that's not very specific. It doesn't tell you exactly what these people did. It doesn't show you. It doesn't tie to these specific overt acts. Look at Act 56 with Diamante Kendrick, right? He was driving in a territory of a rival gang with the intent to cause the death of another human being with an AK-47 and a 40 cal handgun, right? Like, show me the evidence for that. Show me the money for that. Right? Don't just say it, state. You have to prove it beyond a reasonable doubt. So thank you so much, Jeff. Really appreciate you. 80s Baby became a member. Welcome to the squad. Your main man Mush dropped another 5, says this prosecution is so stereotypically embarrassing that it cannot be unburdened by what has already been. It's a good point. I mean, it's a good point. Shout out to Red Bunny Classic with the 5 Canadian bucks, says hashtag AV issue. Yeah, I'm adding that to the soundboard. You know, usually I jot down ideas as we go. You guys thought the cricket sound would be nice to have as well. Because, you know, I got some of the lead sounds, you know, and I got the Rick Ross laugh. Those are nice. I like my Law and Order joint, but I have 2 sounds that could be replaced. So we will absolutely, we would put Max on my soundboard. Like, that's an AV issue. That was a universe knowing that we're watching. Shout out to, I'm going to call you AA because I don't want to mess up your name. AA drops a $1.99 and says she can coach her back to the drawing board. That's right. She needs to be back at the drawing board. And we're referring to Miss Love when you guys are pointing out that the judge is absolutely coaching her, you know? So super, super interesting. Shout out to Don, who dropped the $5 super sticker. Thank you so much, Donald. Really appreciate you. Shout out to Me Bless with $1.99. No comment, no question. Pure love of the game. Thank you so much. And if those are your kids, beautiful family. Thank you. Me Bless came back with $1.99. It says the DA is horrible and they got no case. I mean, y'all know, like we did a poll and some of y'all hit yes by accident. And the question in the poll was, do you trust DA Love? She has been sneaky, trying to sneak things in, trying to cut corners, not doing stuff the right way, showing up unprepared. And, you know, the week that Simone was up here in Boston, like, you know, she was on her own. We saw a lot of scrambling and scraping. That joke comes from Diddy, but honestly, like, we're seeing the glitching, we're seeing all of that happen. For the biggest case in Georgia history, we're seeing all of that happen. And meanwhile, these defendants are paying their lawyers. Some of them have public defenders, but imagine what Brian Steele's retainer is for Young Thug. He's got to be getting paid millions on this case. You know, so while they're unprepared, guess who's paying hourly fees? Defendants. So not necessarily the best look or thing that they're doing here. Shout out to Ray with the $5 says, I love this screen when it shows how far off the scales of justice are in the courtroom. I mean, they're gone. Essentially, they're gone. It's crazy. It really is crazy. Let me come back to Cash Apps. A few of you guys sent some this morning. So let me scroll down to the bottom. Shout out to Full Drinking and Half Thinking with the $20 Cash App. Thank you so much for hitting me on this side. And of course, he sends me the coffee emoji. Thank you so much, Full Drinking and Half Thinking. I think that's all I have for Cash Apps today. You guys are in the chat, ripping and running and doing your thing. Shout out to, just saw another one come in. Shout out to Unique Maine with $4.99. He says, am I the only one who thinks this YSL RICO is being placed front and center to get everyone's attention to distract people from elections and World War III, essentially? You know, that's a good point. You know, we started this year with a lot of focus on the upcoming elections. You guys know Donald Trump is running against Kamala Harris right now. At first, we were all really concerned with DUJO. You know, it was time to sit down. It was time to stop, you know, being out there. We were all really concerned, like Democrats, is this what we're doing? Is this what we're doing? I don't know what's going on. Joe don't look like he has a lot of gas left. Like, give this man a break, you know? So the Democrats really had to look at who their nominee was going to be. And I think the DNC took place yesterday, and there's all types of protests and shenanigans. I mean, it is a distraction. I have not paid attention myself to politics all year because I've been distracted here. But that's me as a creator, you know? So it's a good point, Unique Man. It really is. So we'll see. I mean, we had a lot of things that were distracting, you know, like the assassination attempt that took place last month, right? And don't forget that there's another RICO case in Georgia, and that's against Donald Trump himself. You know, we saw a lot of lawfare take place where, you know, all these lawsuits were kind of taking place and people were using this as political weapons, right? That is something that's always happened. We've seen it in the 2000s, but that is interesting. I mean, as far as your comments on war, yeah, there's a lot going on in the world. There's a lot going on in the world. You guys remember what was happening in the Ukraine, and shout out to all the veterans that are in the chat and law enforcement that usually hang out in these chats as well. You know, thank you guys for what you do, but like, those are not easy topics to talk about, you know, and it could get super divisive. Like, I've noticed, you know, for a while, I did have a huge red wave in my chats for a while. And of course, you know, like, we try not to get too political, but like, at the end of the day, like, I've seen that change. People come and go. Idealism changes. I mean, can we all agree that there is some shenanigans happening in Fulton County right now? 100% yes. Doesn't matter what side of the aisle you're on. 100% yes. You see it from DAs. You see it from prosecutors. You know, you see it from judges. If this was not being televised, would you ever know? Would you ever know what's happening in these courtrooms? So it is important, and it's happening, you know, in courtrooms all the time. We don't shed light on it. You know, before this trial, at one point I was covering the Keffe D thing and the Tupac thing, right? Like, that's another pending case that's coming soon. Looks like we have some movement in the courtroom. All right, looks like we are back. I'm gonna make myself small. We don't have audio yet. Skip ahead, see if she's talking. She's speaking, but We have no audio. While we get that, let me get one more. Shout out to Nurse Janice in the UK with the €2. I believe. She says, hi, AV in chat. AV, you're amazing. And it's 7:18 p.m. I always ask her what time it is over there. But it's 7:18 p.m. across the pond. Shout out to the UK. We had a little bit of folklore in the courtroom yesterday with King Arthur references, Knights of the Round Table, Excalibur, Guinevere, Merlin. Shout out to the UK. I saw a lot of people from Scotland that have been joining. Ireland in the house. UK representing. So it's good to have y'all.
The next one, Your Honor.
It's
we are
pound.
going to,
Pound. Thanks.
I believe it's included in your honorable court's ruling. It's approximately 1:2539. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and he answers a couple of weeks. So I assume that your court said that that's not inculpatory. So I'm moving on.
All right.
The next one is, it's a visual. So if they're
Okay.
not showing the video at this, it won't matter.
All right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action. And they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it, but we would object to that.
You're not going to use that. All right. States agrees. Well, they don't agree it's prudent, but they're not going to be using it.
Okay. The next one is Detective Thorpe. It's at 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that that's not prudent, but that's what I flagged.
All right. Do you think I need to hear it, or is it pretty much?
That's pretty much it.
Okay. Yep. That would not be prudent.
The next one is at approximately 1:43:20. And I'm not so sure this is covered by Bruton, but Detective Gaither asked Mr. Stillwell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that, but that's what is said.
Okay. And this is just, does Mr. Stillwell or his nickname drive a Volkswagen? Yeah.
Yes. The next one is 1:47:18. Detective Gaither asks what was in its, I say Mr. Williams, but Thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick says he cannot speak on that. So I assume that that's not under this honorable court's ruling. Anything we deal with Bruton. So I'm moving on.
Okay.
And if I'm waiving something,
No,
you
you
say
are,
no.
you are correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing.
Yeah, real quick, guys. I see you guys, and shout out to Defense Lawyer Explains. I think she was asking where y'all are all from. So all of you guys that are popping in, letting us know your city, let us know where you're popping in from. I know a lot of people in Atlanta and Georgia watch me, a ton, a ton. Let me know where you guys are from in the chat.
And you didn't meet up with Mr. Williams, and then ask the same for Mr. Stillwell based upon your honorable court's ruling. I believe that then we're going to skip. And if I'm wrong, please tell me I'm wrong, but
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what it, we would probably be
Asking that. Okay. Well, yeah. I mean, I think that would be okay.
and then the next one is well, it's really the same, Your Honor. It's clarifying the same thing. It didn't meet up with Mr. Williams or Thug and Mr. Stillwell. So
Okay.
that's it.
Yeah,
That would
same.
cover the entirety. Now that's just for Bruton, but again, I will send to this honorable court, and there are cases on a RICO conspiracy, a conspiracy, and Bruton.
Okay. I'll be on the lookout for that and the state's position on that also. All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
The PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No.
in-
it would come
Okay,
after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
Easily run through it.
Yep.
And Your Honor, if I may just turn my back. You will get the thumb drive. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you've provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I don't know that it needs to be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that sent it over and open it up and look at the slides on our personal computers or laptops.
Sunday at 9:15 p.m. It was sent Sunday at 9:15.
Right. And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay, right. Okay. All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide one, I don't see how the state could possibly need that slide.
No, that's not, no, I mean, it's not. No.
Okay. Slide one's out. Slide two, this is just sort of,
These are identifiers that identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
I mean, it-
Just to make sure we're all on the same page, what you're referring to is slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking
right.
at the title page. And then
Okay.
we're on the same page,
All right.
literally.
Okay, good. All right. Slide number 3. What's
Uh-oh.
y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this.
What's
too.
happening with the?
So we can take out, well, we can take out all the language.
Mhm.
We can take out all the language.
Okay.
Can you take that? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So
Thank you.
y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would.
All right, so who are I see we've got
Defendant Williams.
Mr. Williams, Rich Homie Kwan.
Bermian.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
Yes.
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is.
So right now, guys, the state is going through a PowerPoint presentation that they intend to bring in with Mr. Sprinkle. I believe it's Sprinkle or someone else from their office. They have a PowerPoint presentation. What they're doing right now, Simone sent it to everybody Sunday night. So all of them are going through, and you could see everyone's computer looking the same. They're going through slide by slide to make sure that everything makes sense before the jury sees it. So with the judge right now, she's like, take this out, take this out. You already have a picture of Donovan Thomas, take that out. You know, they're looking at unnecessary fluff. You want to slim it down so we make this as efficient as possible. So that's what we're looking at right now. And we're going through each one of those slides. It's a shame we can't see it, but if you look at their laptops, you can get a glimpse.
Is Defendant Williams. And as
Shout out to the Mondo.
the gang, pre the dispute, the war,
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on one second, Your Honor. We have videos of the groups of
All right, so
persons
you could do a
together.
still from a video.
We
Okay.
can.
All right, how about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's.
Is there a picture of Mr. Watts in evidence?
Yes,
But
there
they're
is.
Does it look kind of similar to this?
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the indictment.
Are they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's going to be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonist.
talk about that without this, and if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that.
Do we have pictures already in evidence of that?
No.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Okay.
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video
All
introduced
right,
of him.
well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June, However, that was after 3 o'clock.
All right, this is getting a little boring, so we're gonna play a game, guys. We're gonna follow along with them. This is slide 6. What's on slide 6? It's a picture of little Woody with money at the club, at Club Crucial. If you want it in, put 6 and then in. If you want it out, put 6 and then out. Let's do this.
And so we did not enter it
Ah.
again
Okay.
this time around. So I do not believe the video was in evidence. I'll double check,
Okay.
but I believe that was after
All
3
right.
o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Shout out to the ends.
Can
Y'all got it
can I
right.
inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean,
Yes, no?
the flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes,
Is this the night of,
it's,
or is this just?
you say the night of, not
The
Donovan
night-
Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar, good
It's-
word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody James punched out.
But this is a picture from the night that, it all got shot up or
I'll-
something?
I'll confirm, but that's what
After-
my understanding, that is January the 6th.
I don't know it's January 6th. Where does that date?
I don't know. I don't know, maybe they know what he was wearing to the club
The
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just.
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low
Yeah.
bar, and the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more info.
Okay, so she didn't rule on it yet. But it sounds like it's
All
out.
right, slide 7.
All right, 7 guys. Here's what we got for 7.
This just shows a couple of the, I mean, the Metro, but there's been testimony about the Metropolitan, right?
TIG studios that
Right.
Mr. Copeland is alleged to have shot up, or believed to have shot up.
We've had a number of crime scene photos of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him
and
from showing it to the jury.
TIG is who's?
Think It's a Game
Right,
is the company that Rich Homie Quan was under, that think it's a game studios is inside
Right.
that building right
Okay.
there.
This one's fine.
Shout out to the guys that got
All right.
ends.
Moving on to slide 8.
7 ends. Y'all won. What are we doing with 8? What is 8?
So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial Will Always Remember You part of that.
Okay.
And, you know, the language about whether he's a high-ranking member of a rival gang, I mean, that's,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes. it can-
fact, and
it-
that's for the jury to determine.
Yes, John.
Shout out to the outs. Y'all got it.
I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, those 3 pictures basically of Mr. Thomas and some of his
Brothers, family.
Well,
whomever.
I would object to the pictures of,
Agreed.
well, the pictures period. I mean, I don't know what the relevance is and what a jury would need or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay. So they won't use that one.
Okay, so 9 is out. Good job, guys.
All right, slide 9.
Oh, sorry, we were still on 8. Now we're on 9. If y'all said out on the last one, you were right. Now we're on 9. What is 9?
So slide 9 shows just the type of
Are these actual posts already in evidence?
Social media.
no, we
posts.
did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that. But
Okay.
otherwise, he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Those 9's got it.
Yeah.
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that.
Okay.
It would
and
be hearsay.
because- And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is part of, is the evidence itself, not that it's true. This death to the big homie sent the word
What-
out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes. There were public threats, social media posts, and the like. And these would be them.
Okay, well, that would. Okay, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
So it slides out.
Slides out. All right, slide 10.
Okay, that was 9. Y'all jumping ahead to 10. Okay. What is 10? What is it a picture of? What does it have on it?
Tell me, I guess, what I'm looking at and why he's going to be using this.
So it looks like a stomach. What is that?
We can take this out. I think that this picture is already in any
Okay.
event.
All right.
Okay, 10, we don't even need to rule
Slide
on.
11.
11, what is 11? Y'all just want everything out.
There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
The funeral?
It's a good question.
Victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
So, okay, so this is the funeral. What do y'all think?
Um,
This is 11, in or out? Nuts funeral.
Judge, if I may come back to the court on that, I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
He's very loved. One of the
And
top
maybe it
three,
is, I don't know.
one of the top 3 bloods in Atlanta is very
All right,
loved.
slide 12.
All right, 12, y'all. Y'all ready? What is it?
So how about slide 12?
That. It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. and-
Okay,
Okay.
thank you.
Y'all don't need to rule on 12. Let's go to 13. Y'all want to like burn it all. Not sure, lab rat. And they're not showing us the picture, so you guys are kind of.
Is the picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be
Okay.
admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
His
And
statement.
the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay,
A lot of this is coming out.
all right. So then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo, then he can testify to that.
Okay. 13's
Okay.
out.
Number 14.
What is it? What is 14?
So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay,
We would, yeah, as opposed to using it as a demonstrative.
okay.
This
And
is
I mean, if they're
photographs.
already in, then obviously if he needs to testify to them, he can. And if they're not in, you need to be able to, obviously you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
All right, so that's coming out. 14's out, y'all. And now she's realizing that her own stuff is coming out.
I mean, presumably this shows everybody's, the relation, in a relation of these 3 people.
It does, he
15.
testified about that.
Group pictures 15.
But this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier, so
Okay.
it would be referring back to something that's already.
I'd be objecting,
Then,
Your Honor, the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So definitely the parents, the mother and the father.
Donovan
I think
Thomas,
we-
family
it's just
pictures.
Repetitive.
Okay, sounds like she doesn't intend to use this anyway upon further reflection.
All right.
So 15 is out. Y'all are right.
Slide 16.
What is it? What is 16?
We still have a current intent to use this slide.
We have,
Cannot use,
all right, guys, we have the PowerPoint. I'm going to try to do something really creative and follow along with y'all. So as they're talking, I'll see if I can share the tab, but we are on about 16 right now. Let me pull it up, but this is fun. I like this. This is a lot of fun, but let's keep going. I think we're on 16. So as I pull that up, just listen along.
we cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so what, I think that what we'll do is just take some of the pictures, photographs that we've already admitted
Okay.
and use those as exhibits rather than trying
Okay.
to introduce whole hog. this
Sounds
PowerPoint.
reasonable. So 18, y'all still want to be using that?
No, we cannot.
Okay.
We cannot.
All right.
Well, except that
Oh, some of
I
these have
think
guns in them.
that the photograph in the bottom right corner
Yeah.
were guns that were recovered. But I'll confirm with this. I won't need the,
Quick flash. That's what we're looking at.
slide. So if there's anything in this picture, certainly not the top three,
Okay.
but if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
from an alleged rival gang.
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This is the one that was collected from the.
Here we go. Another quick flash. In or out, in or out.
I could anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is from
well,
the
we'll
other
see.
side. This is
We'll
the
see
guns
what the
from
strategy is.
from the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
19, we have not yet introduced that photograph, but I think that we've.
The one on the bottom, or
Quick flash. Little Woody, quick flash.
Interview with Mr. Copeland that has been shown to the jury so far. So we definitely take out the words, we'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was going to say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're going to use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or that we tender through him.
Okay. All right. And so that'll be true for the rest of this.
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, she's just saying it's going to be easier not to. Because I mean, I would imagine he's probably kind of like, press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there's some if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor,
Yeah.
wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand.
Okay, that's actually much easier, guys. So instead, and I have the PDF right here. We'll look at it together and just briefly go through the pages so y'all can see what we were looking at. And that was a little bit of a fun activity to keep us up, right? But here's what we're looking at. So this is the PowerPoint presentation. They just decided to just take the whole damn thing out for right now. And thank you to all those people that were saying that at the beginning. I'm just going to briefly go through it so you could see what's in here. And for those that are sensitive to guns and all that, just know that that is what we're going to be looking at. I am curious, so I want to look at what's coming in. So this is the PowerPoint. It says YSL 30 Deep versus Inglewood Family Bloods. Okay, so this is what their presentation is. And I'm going to take you down for Always, Forever, for Life, just so we can all look at it real quick out of curiosity. So this is coming in through one of the detectives, and these are just pictures that they're using. So they have Young Slime Life on one side, right? They have this tattoo, and then they have If Gang on the other side. They're using this PowerPoint to help tell a picture or to tell a story. This is 2. Here's 3. So they have, pictures of Young Thug calling him King Slime. They have Birdman on here. They have Rich Homie Quan on here. As you can see, they put this little collage together themselves. I think what's his name? Nut is on the right-hand side, the lower right-hand side of the screen. And let me just zoom in a little bit so y'all can see it a little bit better. So you see all these people together in these photos. You have a picture of Little Woody. And then you have a picture of Shell Kell here, Little Woody looking really young in this PowerPoint presentation. Next one, it says to the APD gang unit knowledge, one of the first documented incidents occurred at the gambling house. So apparently this is the gambling house. It looks a little run down. Then we have another picture of Little Woody. This is the day that he was at Club Crucial, and that is the money phone, right? So we see that. This is the Metropolitan recording studio, and Little Woody was talking about it. I don't know what this TIG is. Think it's a game entertainment. So you see how they're like kind of piecing together. They wanted to put this in front of the jury, and the judge just said no. If you want to introduce some of these photos as evidence, you can do that. But when you put something like this in front of a jury, guys, the jury's going to pay attention to pictures. This is the first time they're seeing something like this. It's very different from the actual talking and those things. When you're using a PowerPoint, you're using it as a demonstrative tool to demonstrate some things, but this is what they were just trying to bring in. Let me bring myself smaller. This is a photo of Nut, right? And, this is when they were trying to talk about how loved he was, right? You're seeing all of that in these photos here. These are some, social media posts where people saying, RIP Nut, things like that. You're seeing other group photos, right? I don't know what the relevance is of this. This is photos of the funeral. This is how many people showed up at the funeral, things like that. Apparently there were over 2,000 people at the funeral. More, group photos of Nut and his family, I believe, or If Gang members. They made direct threats towards Little Woody. Wow. So If Gang was they were making threats against Little Woody. Oh, this is interesting. The plot thickens. Immediately after the murder of Nutt, there were 8 drive-bys directed towards YSL and their families. Police recovered over 300 shell casings. Wow. This is interesting. Matter of fact, maybe this should have came in. All right. And then initially it was believed that if gang shooting at YSL would be soon learned that it was an all-out war if the members began to target if gang members and their family as well. Wow, this is crazy. All right, so here's Nutt, a picture of him on the left. We have Marquavius Curtis on the right, Greedy. Greedy has the same, I guess this is his brother. Interesting. We have Shell Kell. So Nutt and Shell Kell were half brothers, it looks like. All right, so we have some more group photos here. Group photos, not sure how that's relevant. Now we talk about Lucci for a little bit. One of the first shootings was at Lucci's mother's house. So YFN Lucci is a rap artist that Nutt has managed. Wow. So Nutt funded this, it looks like, and Lucci's rap career was able to take illegal money and turn it into a business. This actually does not look good for Nutt. This does not look good because basically it's showing that he invested in Lucci but was using drug funds to do that. Oh my goodness. All right, so it looks like there was, this is what Love was just talking about. Apparently they were, these 3 gentlemen, Jamal, Kelvin, and Jermaine, were found with some guns. Here they are on the screen. We're going to scroll down. This is where we probably left off. This is Little Woody. I did flash this to you guys. According to Woody, he felt it was safe to go out and he believed Kelvin was in jail, not knowing that he'd be bonded out. Little Woody and his brother were followed by a car as they left a hotel, and shots were fired into their vehicle. The next morning, an Instagram post confirmed that Haiti Gang, which is a subset of the Inglewood family, carried out the shooting. So do people do this? Like, do you carry out a crime and then post it like that? I mean, I don't know. I don't know much about this life, so I'm just commentating here. These are some photos from the shooting, things like that. Lucci's mother and her boyfriend were shot. Wow. Okay, Trevante Turner was shot here, and he is an associate of YSL, allegedly. This is a woman. This is Antravia Smith. Okay, we learned about this. So apparently Shell Kell and Munk Tunk were both dating Antravia here. Okay, so she was dating both of these dudes at the same time, and apparently Little Woody had an issue with it, and I do remember this coming up, so that is interesting. Oh man, we see some blood action. Sorry guys, literally I can't show that on YouTube, but we see some gunshots and we saw a wound, so I can't show that for too long. Okay, so Shell Kell was shot. That's what we just saw. We saw Shell Kell wounded. And then we have some social media posts here. These guys are serious. Next, we have another shooting. Little Woody, his girlfriend, and their infant were victims of a drive-by. This is where it took place. That is a gun that was thrown. I think, that's not Little Woody's gun. I don't know whose gun that is. These people had pled guilty to probation. I don't know. All are documented if gang members. What does this have to do with YSL? I don't know. U.S. Marshals executed an arrest warrant for these 2 guys. A search warrant was executed, but this is if gang. This is not YSL. There's another murder here. It says his murder still unsolved. Nard. Oh man, where's Lead? This is a picture of Demise, Nard, awaiting trial right now. Oh man, I can't show y'all that. Half somebody's head was missing. This is Lil Wayne's tour bus. These are pictures of Birdman and Young Thug. Rap dispute between Lil Wayne and Birdman spilled into Atlanta. I mean, none of these pictures are relevant. I get that. Okay. 3 YSL members were charged with indictments. This is Little D in the middle. And then this is the other Little D, Demikion. So there's 2 Little Ds. And then there's Moontunk, which is going to be testifying after Little Woody. All right, here's Little Woody. This is the chopper that they found Little Woody with in the H&M bag. So we know about that. He was playing basketball, got arrested. There is a picture of the H&M bag on the left-hand side. We have Quandarius Little D. Zachary, who was arrested for weapons possession. It shows that the ballistics shows the weapon matches the drive-by. Okay, I mean, something like that might be relevant. Here's a Little Tick, and with Little Tick, looks like they just have a social media post on him. All right, we have some ATF search warrants of a studio, 10 pounds of pot, $43K in cash, 2 handguns, rapper Rico Richie arrested. Okay, so we see some arrests happening there. I can't believe they were going to go through this full thing. U.S. Marshals execute an arrest warrant for Young Thug at his home in Sandy Springs. He was arrested for weapons and drug possessions. They got 2 assault rifles, 1 handgun, suspected cocaine, and liquid promethazine recovered. So that was Young Thug's house. Yeah, and Yak Gotti, apparently photo, he posted this, and there's he's not holding it, but somebody else has it at their feet. More drive-by shootings. How long is this? Yeah, I cannot believe she wanted to put this in front of the jury. They wanted to use this all for one detective's testimony. This is a young woman that passed away. I don't think the If Gang stuff should come up, but we see more pictures of Shell Kell. Something happened at Magic City. Duke was assaulted by Shell Kell. This is Duke, and he is a part of YSL, allegedly. Okay, here's Yak Gotti and Duke. After Duke was assaulted, he called Yak Gotti to help. It looks like. I'm not sure who these 2 guys are. Anywho, you have this big document, which shows, if you look at the top, this is who they think is involved with YSL, and look at the bottom part of this document, that's who they think is involved with If Gang. So they think that Little Woody is involved with YSL. They think Roscoe's involved with YSL. Little D. They think Young Thug, Shannon Stillwell. They think OG Bentley's involved. Yak Gotti, DK, Slug, Doo-Wop, Duke, Nard, Demise, Demise, Moontunk. You have Demikion, the other Little D, and then Rico Richie. So if you look at this, they have been planning this for quite some time, but this is a copy of it again. All right, so all of those slides, what do y'all think? I mean, wow. I hope that I don't get demonetized for showing all of that violence, but it's just interesting. And I was curious. I wanted to see exactly what they were talking about. It did buy us a little bit of TiVo time. So we are going to go back to sharing over there and see what we missed. I think it's right over here. Let's keep going.
Fine.
So
Thank
can-
you.
Can I just make an observation
Sure.
or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay. And the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness. And I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Nguyen, Nguyen, F, that's wrong. 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it, so I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled, and now we're going exhibit by exhibit and rulings. But my point to the court is, if you can just, I'm not asking for an advisory opinion, but this is going to be, there's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Dennis already testified as to the alleged back and forth. He already said all this.
Okay.
So did Detective Gaither. It's all over objection, but I would object that it comes in now again.
All right, and what would be, what's he gonna be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were
Okay.
talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting. He touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the
Guys, Brian Steele is actually making an excellent argument right now. And for those that are interested in the PowerPoint, I did post the link. Thugger Daily posted it. I just pinned it to the chat. So if you're interested in looking at it, you could click there. I couldn't show it for too long because YouTube has very strict guidelines when it comes to guns and things of the like. So I had to skim through it. If you're curious though, you can click on that link and look at it as we go. But it is super interesting. Shout out to Danielle, who also sent me Brian Steele's recorded session this morning. You are the best. But Brian is making an excellent argument. He is saying usually you are allowed to use things like this in a closing argument, which is the norm. However, they're trying to show it to you. They're trying to show it to the jury right now in the middle of somebody's testimony. That's not how you do it. And that's what Brian's argument is. Let's see how this shakes out.
Court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain when Mr. Steele says, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, the theory is that all of this came about because it was the culmination of, some gang wars, basically.
We've already
That's already been covered, so he should not be testifying to that again.
Right. We don't need to, but specific, like the April 28th shooting, the Hill, like we haven't put up all the evidence in some of
Okay.
them.
Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overacts. Some of them are overacts that are listed in the indictment. If that's what the court is saying, the answer is yes.
Okay, so I may be thinking of the Hill Street shooting as something other than what it really
The
is.
Hill Street is not. The Hill Street is not.
Right, that's when Woody and his girlfriend get shot at, right? Or no? Okay, all right, sorry. There are a lot of shootings that I haven't been in this case the whole time, so. All right, so, but I guess, so let's take, for example, that one. I mean, we're not gonna need to get into the nitty gritty of that one, because that one, all that we need, all for the jury to know for that is it happened, some people believed it was a rival gang, it, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom.
Oh,
And so
Well, that
he's-
was another one, but.
So the overacts connect that shooting with the ballistics from that
Okay,
shooting.
Okay, so for that reason, that might be relevant. but-
And Lucci's a central sort of
Right.
opposition figure
Okay,
in the whole.
well, I guess I'll just have to take them as they come, but we do not need a whole entire crime lab. Here is, what you would put in if you were the state prosecuting that shooting, when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything
Okay.
in the indictment, even like we were saying yesterday with the Rodelius Ryan murder.
Okay.
We've scaled everything down.
Okay.
Like that, so
All right.
as not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. To me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and put in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there was no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause and it's all coming in as a
Man, shout out to Brian. He said the state is so unprepared, right? I don't know who to hit back. Like it feels like I have a bag over my head and I'm getting hit with a baseball bat. I don't know who to strike back. I don't have any witness statements. I don't know who I'm talking to. This is you're disarming me, Judge. And this is going on when Glanville was here. You're disarming me. Shout out to Brian. Can y'all put YSL Steel in the chat? That was actually a fun. He's cooking right now.
Undo it through some quote expert. And it comes through many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Is that continue? And y'all were gonna circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been
For
conducted?
police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't. But we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
Okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes, and
And that
you
produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over,
All
because
right.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Oh no, she just got caught in a lie. Did y'all see that? Simone's like, hold on. What are you talking about? Do y'all see Simone's face on the bottom right-hand corner? She's like, wait, what are you talking about? Love is sitting here trying to explain to her what happened. She just got caught lying, y'all. If you saw what I saw, type lies in the chat. Type lies in the chat, Lyin love. I think she just got caught. Wow. Okay, before I say that, let me run it back, because you can see Simone's confusion. And generally, I know Simone goes through her stuff, but I really do think that she tries to be a good prosecutor. But look at that face. That face tells you a lot. All right, let's go back.
In the police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't. But we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
Okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes, and
that
you
produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over,
All
because
right.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else, but anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no,
I'm
sorry.
sorry. Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes,
Yes.
we don't have anything extra. We will go back again, because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I
and
know,
that's
but
what-
then I ordered you to, so did you do it again?
Okay, so
Because I ordered you to.
Violating court orders.
we have not inquired a second time, and I apologize to the court.
That
We're gonna do it
is-
again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Atkins, you could have done it.
Well,
Yes, Your Honor. I'll go make a phone call now.
Okay.
What?
And can I mention something? It came out during trial.
No, they did not just send this boy to go make a phone call to get something done. No, it should have been done. Done means on time by deadline. There's 3 of y'all. There's 3 of you guys. Even though he reminded CDA Love, he reminded her it could have got done. And the judge just gave them an out. This keeps happening. And it's so frustrating. It is so frustrating that she does not lay the hammer on these people. I mean, so Simone looked like she was out of the, like in the dark with this one. But between Atkins and CDA Love, they could have worked something out that should have been done on time. But again, she's letting them get away with all of these shenanigans and waste people's time. Oh my gosh, it's so frustrating.
During a motions hearing, that there is a, what I'm going to call a black book. And it's all the gang information and
Yeah.
AP. Okay, you seem like you know about it.
I've
Well,
heard about this before.
okay, well,
Yeah.
I don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gator said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer, where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There's a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member.
Oh.
It's self-admission. It's somebody else who's reliable, which say that they're in a gang.
Okay.
They hang out with somebody. All that's in this supposed book. I don't.
Okay, that's entirely different.
Okay,
because-
so you now do know what he's talking about?
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked
Mhm.
about how they identify gang members
Okay.
and what criteria they use.
All
It
right,
was
is
not
that
true
something that is in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
I think that the criteria,
Okay.
those criteria that they use, that is something that is a written sort of criteria.
Okay.
And I'll get
All right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided, if they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 p.m. on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
I will, and we will also check to make sure that we've not already given them standard operating procedures as it relates to
Okay.
gang unit.
Well,
and gang
obviously, if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It sounds like what Mr. Steele's talking about is the sort of policy that you just mentioned, that are the guidelines, the criteria.
I actually want the specifics of who they spoke with. They're talking about.
All right. Well, they may or may not have anything like that in writing.
Well,
And
if
you
we-
can always just interview the detectives
Well,
to ask them those things.
well, I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. Then they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street, and that would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said,
have to
I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right,
what.
I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way I'll. Been provided to the state as well, because if it's clear law, then they can just redact those portions of CAD reports, which might need to come out as hearsay. Okay.
Simone is not having a good day, guys. She is pissed. Look at her.
So I have KAMUSOKO versus state.
I'm sorry, start over. I just didn't get that at all.
KAMUSOKO
Okay.
versus state 362 Georgia Appeal 276 footnote 3.
And what does it say?
868 Southeast 2D 252 2022. Says Camusoko makes no distinction between any particular statements and declarations, and therefore has abandoned any challenges he may have regarding particular statements or declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although Camusoko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read
Okay.
from footnote 3.
All right. So, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal. You didn't raise it below. We're not going to deal with it.
But it's right. But the CAD
So,
report
okay,
could be
maybe you could come up with one that instead of saying this is a potential issue, says, all right, here's the issue, and in addressing it, the law on that. Can you try to do that? Thank you. All right. Okay.
in this case in Division 2A,
All right.
where the footnote 3 is.
Okay.
And what the court said was it's admissible under an excited utterance hearsay. It's
Yeah.
hearsay with an exception.
Right.
So
Okay.
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
Okay. Well, then you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times. I just thought y'all had some kind of blanket, this part of a CAD report is always out. And that is not what we have.
Right. It's like a
Okay.
911 call. It just
Yeah,
depends
no,
on
I'm clear now with what you're saying. All right. So we've done the PowerPoint. So I am going to give us another quick break, but I'm going to say, and I'm going to say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again have to take a break because now you can't hold it anymore. Okay? All right.
Wow.
So we'll have a little recess.
That is interesting. Let us see if they are still on break, and they are. Shout out to TiVo time. About 16 minutes went by. They were supposed to take a 5-minute bathroom break, so I will a small, but Child, it is getting hot in this courtroom today. Simone and In Love, they're going at it. You can see that they're going at it. Simone did not appreciate that Love just lied. I think she knows that Love just lied to the judge. I think she knows. But look at that. Shout out to TiVo time. It looks like we are back. I'm going to give us a little bit more TiVo time just so I could catch some super chats real quick. There's about 5 or 6 of them. So I just want to make sure y'all are acknowledged. Shout out to Michael with $5 says, when did having a large amount of money become a crime? Fulton DAs are pulling at straws here. They totally are, Michael J. Like, I don't know what they're doing. Thank you so much for your super. Love curly hair. 99 says, AV, shout out to you for coming up with the game. Yeah, I mean, like to keep you guys entertained, but at the same time, want to make sure that you're having a good time watching this. So many of you guys will watch us while you're at work, doing things, doing chores, all types of stuff. We want to make sure that you are engaged and enjoy your time here. I know you can go anywhere on this platform and watch it with anybody, but the fact that you're here, we're going to have a good time. So thank you so much. Shout out to King Jiggy with $9.99 says Doug is the new meme. I mean, did y'all see Doug's face earlier? That was hilarious. Jeff J with $4.99 says, I hope the jurors are getting $10K a month to put up with this mess. Jeff, they are not. They are getting $25 a day, $3 an hour. Shout out to Fulton County. Red Money Classic with the Californian bucks, $2, or Canadian bucks, $2, $2 Canadian. She says, Hilton be like, big sis, I know you lying. And that's the thing. She knows. She's giving her that look. A lot of the women were picking up on that body language. When we don't want to deal with y'all, we ain't looking at y'all. All right. You're going to get the side of the hand. The side of the hand. Ladies, you know what I'm talking about? You know what I'm talking about? The side hand. That's what's happening. You guys picked up on that. Shout out to Darius with the $4.99 says, it really seems like the state will get away with everything. How is this fair to the defense? It's not. And that's the point. I think Brian's being very, very vocal today. He's challenging Whittaker a lot. He's just like, okay, respectfully, Judge, I disagree. Here's why. Right now, we're talking about a CAD report, right? Now, that's what we're talking about right now. He's pushing back a little bit, and it's good because Glanville wouldn't even allow these guys to push back. Shout out to Jeff J again, says prosecution and Witt are trying to make a career out of this one trial. Completely unfair to those that are incarcerated and a waste of time to everybody that's watching, you know? And like I said, the longer they stay in there, the more expensive this becomes. Shout out to AA with $1.99 says liability love. That's a good one. That is a good one. Thank you so much. Mush is back with 10 says the prosecutor is not trying to comply with the judge's order or litigate by the book. They are so used to getting their way and getting help from the judge that they don't seem to remember the book anymore. Where's the book? Where is it? Where is it? Thank you so much, Mush. Shout out to Double Thought Show with $10 says, did the judge really just give them bathroom instructions? Yes, you saw that correctly. She did. She said, if you need to hold it, which is serious. Like she seriously just gave them those instructions. Shout out to Dirty Jesus who hits me on the Venmo. He says, none of the answers for your poll worked for me. I'm from Baltimore and we had a series of DVDs on snitching. Snitching is never kosher. Yes, that's when we were talking about that a little bit earlier. And if you guys haven't seen it, we just put out a video on the whole debate on whether Little Woody is saving himself or is he snitching. So if you're interested in that conversation or that topic, we just put it out, I think like 2 days ago. So check it out. Dirty Jesus is back. He says, even if it's the ops, never snitch, just get your lick back. As far as Thug, if you're not willing to feed a ninja, they shouldn't be around you. You never save starving around wolves. Shouldn't let the man keep the money. Thank you so much, Dirty Jesus. And yes, guys, I'm on Venmo too. And Venmo does give you more characters. So thank you so much, Dirty Jesus. Really appreciate you. And I think you told me that it's not Dirty Jesus. It's Jesus. It is Jesus. Jesus has spoken. All right, guys, let's jump back in. They are back from their bathroom break. We have about a minute or two of TiVo time. So, you know, I'll be hooking y'all up with the TiVo time. Let's go back in. And of course, we don't have audio. So let me go.
Task on our task list. Open suggestions or I'll pick one. I know we still have to do the excerpts from the wiretap evidence. So that might be a good thing to turn to next. Yeah.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until investigator Viverito
Mhm.
testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up.
No talking. No potties and no talking. Shout out to Georgia Jan. Let me see if I can skip through this.
Booting, so thought you might have something that was not something we needed to take down. Okay.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Mr. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow, if that's okay with the court. And Mr. Williams said that's okay with him. He could speak for himself, and Ms. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements or alleged co-conspirator statements that are not part of the wiretap. And I'm just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would it allow us just to go in order of the witnesses that are coming up and deal with the.
Simone is pissed. Look at if looks could kill. Look at Simone, man. I don't think I've ever seen her that angry.
Buckets of
Yeah,
exhibits.
that's fine. And I think that's kind of what defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about co-conspirator statements now and tackle the ones that are coming up soon. That's great. Or if we want to go witness by witness through, here's the evidence that's going to come in with this witness. I think either way makes sense, but let's do one or the other. So yes, it sounds like maybe there are some other co-conspirators or alleged co-conspirator statements that are going to come in soon.
Not any that are coming up soon. Not soon.
Not soon.
The witness buckets would be the most. The next, Jamari Holmes is the next time that we'll have co-conspirator.
Can y'all all
statements.
hear her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and
Okay.
Mr. Williams and Ms. Sabasi.
Okay.
So the co-conspirator,
That's a little ways away.
yes.
Does that answer your question?
I'm fine with that answer. as long as nothing sprung on us at the last second with these witnesses coming up, I'm fine with that answer.
Okay, so they do have what those co-conspirator statements are, right? We don't need to litigate it right now.
I'm sorry, I missed what the court.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And have been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
This is not looking good. Discovery pack. I believe it's a discovery dump. Shout out to Max. Yes, Miss Hillary. Let me see if I can skip through them talking. A little bit of confusion in the courtroom. Looks like the court reporter's having a problem with her computer.
Co-conspirator statements in them. Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right. I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified. Is that okay?
My expectations are correct in line with the courts. The state is going to specifically identify those alleged co-conspirator statements. I mean, there's thousands of jail calls from probably, I'm underestimating, well, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket, the jail calls that we're using.
All right. So jail calls y'all intend to use are all in the Mike Sprinkle folder.
The ones that we, yes, the ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay. So the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls,
okay, well. then-
15 minutes each. So it's
Wow.
50 hours of.
Okay, which I presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through my,
She literally snapped at them. She said, "Hey, state, look here." Oh my God, this is such a shit show.
Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce. Please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right. And do you know what portions of those calls yeah. All right. But whether you've broken them out or not. Do you know what those are?
Yes, that's why we put those 14.
Okay, so if you can, if, that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm gonna use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that, one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay. And similarly,
They are fighting.
do that for everything else. All right.
They are fighting, y'all.
So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, you know, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be, and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that.
They don't even know what's going on because they're in the middle of an argument.
Why do I hear
It is easy.
Dropbox link we were working from yesterday? That is the Dropbox link of the first 30 witnesses. So if everybody can find that again. Bless you.
Let's see if I can skip.
It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed.
Mr. Atkins,
I'm pretty sure. That's right, right?
Yes, Your Honor. It says 30 witnesses and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there.
I keep skipping ahead, y'all.
Everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the, Kendrick has the folder.
Okay,
I don't know about it.
great, thank you. All right, I've heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it? All right, who else? Are you ready, Mr. Sharp? Okay, Mr. Adams or Mr. Steele? Okay, all right, here's the one we're waiting on. Okay, you will catch you, okay. All right, I think that we yesterday had gotten, other than Mr. Sprinkle, through, there was nothing with regard to any of the phone custodians, right? Sure.
We're all out of TiVo time, guys.
Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those three cell company custodians.
Your Honor, if they would like to stipulate, we can, as to those records, we can just bring in the records themselves and save that time, but
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not gonna happen. All right, well, so we'll have three more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those? Thank you. Okay, then James Burney is the next witness listed.
Ooh, this is good.
Do we need to look at anything with him?
So this is my expert this morning, Spencer, who was here earlier. He had talked about James Burney. I believe he is doing what Spencer does, and he is a forensic expert. So let's see what they talk about when it comes to Burney.
Expert from the FBI phone records.
Okay.
And this is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a, a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the bus, tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Burney.
All right.
And Your Honor,
Yeah.
per the court's guidance, this April 26, 2015, we are not discussing with Special Agent Burney. This, when he speaks on specifically the January 10, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to right now. He does analysts or analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
calling him for that purpose.
Correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th.
Okay, so again, a shout out to Spencer. If y'all could do me a huge favor, and if you were here earlier when Spencer joined us, he is our expert. That is now a new friend to the channel, and anytime we talk about that, and I would love to invite him back when Agent Burney testifies from the FBI about the cell phone records of all of the defendants the day of. And shout out to these ladies who are still going at it. They are literally behind Atkins's ass having a discussion right now. I don't know if they realize how close this camera is and the angles that are happening, but there is a discussion around Atkins's ass. And it's like, all right, guys, come on, be mindful.
2015.
2015. Okay. Anybody else? Nope. I hear. All right. Not hearing, but I'm seeing nods. No. Okay. All right. Great. We'll move on to the next witness folder. All right. GBI Firearms Voss in Wheatsoul or Whitesole. Any issues on those?
my understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Mr. Voss is not going to be called pursuant to the information we sent to you all a few weeks, 2 weeks ago, maybe. Mr. Weitzel is going to be called. I believe there's on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Weitzel?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
No. Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right. I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously, if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to the same
All right.
conclusion.
So she will be testifying to her own conclusions, not to his conclusions.
Right, hers match his, and he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Miss Kelly. If maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention and state's attention that my understanding is we don't have a report from Miss Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Do y'all have that yet from her?
No, I spoke with the GBI last week and I'll follow up this week.
Okay. Let them know that this is an ongoing trial and they need to
I will.
provide it ASAP and then provide that over ASAP to the defense.
Again.
Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe that rather than having him testify 2 different dates for those, for the incident here and the incident in April would be obviated by the fact that he's gonna not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before? Week before last, right.
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. Really, the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Bernie to do the analysis, because he can talk specifically about what side of the towers the phone was on at a particular time.
All right. Which phone?
This was, so it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel.
Okay.
And then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Not.
I can't get this to go back to.
You like it, Natasha? I'm like them. You see me all moving around and stuff. We have any more TiVo time? Yeah.
Hang on.
Oh, sorry.
Keep going.
All right, go ahead.
Only phone that he analyzed from these defendants here will be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from and we may, but tell me why we need to hear from Mr. Bernie about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy, and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time of the, but it has not come in yet.
Okay, all right. So then with regard to that incident, Mr. Bernie's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what,
Correct.
Okay,
Yes.
so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay,
Yes.
that works. All right, so moving back
to,
Does that- Can I ask you a question?
yeah,
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was
but-
testified
but-
to.
In the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it, but I think it's a part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that shouldn't need to come up again. Right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we think it's important that at least the jurors know he didn't.
Yeah, I
didn't
mean,
come with the same-
yeah, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't. So you,
Brian.
Okay.
The mic.
all right. That is what I said. Okay, so back to the two firearms examiners who are going to be Kelly and Weitzel, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa. Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about
Okay.
earlier.
Any issues with this?
And you're right.
Mm-hmm.
I think it's actually Officer Z Atha.
Oh.
Yes.
Okay,
And-
there's
and
no
I
space
changed it,
between
yeah,
those
and
two.
and
Officer Alpha. Okay, thanks.
Okay, we're still going through their.
Any
witness
issues on those photos, images?
YSL Luna has broken into our den.
Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses. I have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's more information that we're supposed to get.
we have the police report, Your Honor, that we've provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim,
Hey, Chet.
which is the victim in the
How y'all
case. And
doing?
so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I was.
Statements are reflected in the report that, to the extent that she gave on site.
I doubt if they can hear her, that y'all is gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear. My understanding is that the allegation is her home was shot up multiple times. And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about taped statements, written statements.
Your Honor, we'll double check, but the answer be no. Whatever her statements is contained with what she told the responding officer and he put in his report.
Okay. And this was way back before body cam was
Yes.
typical, so
Exactly.
that wouldn't be unusual. All right.
If y'all find something else, obviously provide it, but no, that to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Okay, thank you. All right, next is Sanders. I'm not sure what CST stands for, but Crime Scene Tech Sanders. Very good. Also lots of pictures and images of their walking through the crime scene and documenting it. And then the report. Any issues? All right, thank you. All right, moving on to Antrevia Smith. What is that, a video? Okay, any issue on that? Oops. It's a short video, so even if you're watching it for the first time now.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All right, hang on, and nobody can hear across the courtroom if we don't talk into the mics. I know it's annoying, but
We have it coming in through Mr. Sledge. That's why we were just pausing, because it's already been an exhibit that's identified
Okay.
as coming in through Mr. Sledge, but it was Ms. Smith who gave it to the police following the shooting of her apartment to show the antagonism that existed between Mr. Sledge and YSL and Mr. Watts, whom she was also seeing. So that's the reason that it's in both folders.
I would hope the questions are not articulated that way in trial, because it's Mr. Sledge arguing with another man over a girl. I don't know YSL how that fit in, but
I see. Kevin.
okay, well, that may be, it probably will. And if it's presented that way, then y'all will have some good subject matter for your cross-examination.
That there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh, no, it wasn't over a girl. We
Okay,
weren't beefing over a girl.
all right, well, they'll say whatever they're gonna say, and y'all can examine accordingly. All right, Sharon Latner's. These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any of those, y'all think might be excludable as hearsay without an exception. All right, we are moving now, at least theoretically, to a different overt act, I think, right? So now we've got Crime Scene Tech Turner. And that folder is empty, at least for me.
Wow. Does it not surprise y'all that there's an empty folder in the Dropbox with all their stuff in it? Wow. Let's see what they have to say about this one.
Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be something in that folder?
I'm gonna check, I think that we may have already.
All right, we'll come back to that one. Y'all check on that tonight.
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
From the hack from whenever
Yes,
that was?
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that those were, it was Turner. It was Turner's
Okay.
photos that were those photos that we were trying to
Those
get.
were lost in that several year ago hack, it sounds like. So that's why
what-
that's empty.
That's what the photo lab
Okay.
told us.
All right, moving to Jenkins. And these are just crime scene photos. Look pretty standard. Any objection on those that y'all anticipate? Okay. All right, Tyrone Dennis. All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection?
You want to get down? Hold on, guys.
And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay,
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. But it shouldn't come in this form. This is not how Mr. Williams made a song.
okay.
So I would be objecting to the best evidence rule. And I don't know why, I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he
Okay.
when he was qualified, whether he spoke with anybody with the lyrics, how he makes the lyrics. He has no idea. He's just a listener.
Okay.
So those are all but those are, I raised those objections previously when we
Alright.
were arguing.
And, sorry, go ahead. And what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, then he will decide later if they come into evidence. That's
Okay.
pretty much how
Thank
it
you.
was.
All right, so the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is that we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
As a
what is being said.
demonstrative aid.
Yes, and as far as the objection as to the meaning behind certain words or lyrics, Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert, as to certain meanings or certain language. But if there isn't, if there's a different interpretation or if someone else intends it a different way, then we would submit as the area for cross-examination or a different testimony from the person who's seen.
All right. Well, I think that with regard to something being used as a demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, in my expertise, this might mean XYZ. Obviously, doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that, and all sorts of good things, I imagine.
I guess it depends on the lyric, but intention can never be discussed by an expert, a person's intention, because it's
Sure.
not beyond the
Agreed. I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. It's basically the same thing. This is just another set of lyrics. Okay.
Me
Your
too,
Honor,
Emily. I like
one other
her.
thing when we're talking about these lyrics that I think I need to bring up right now.
Okay.
I believe that we are going to be asking for a limiting instruction.
Okay.
I don't know how the performance of music. I mean, the state is fighting us tooth and nail, saying YSL is not music. So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting there.
Judge, I think that we've never made the contention that YSL members do not rap. We have repeatedly asserted that there's that aspect of the game. So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there is no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking at the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing on this matter.
Okay, well, y'all let me know about that. And if y'all want a limiting instruction, you can certainly propose one and I will take it under consideration.
Shout out to Wilfrey. This is serious right here. I love this comment. He says, is YSL a gang or a music group? That's exactly what this entire case is built upon. You're saying it's a gang. but we're using lyrics from songs. Hence, they are a music group, no? Guys, the math ain't mathin'. Shout out to Wilfrey with that comment. That's a good one.
And, you know, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exclusion and, I mean, one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we would just, we'll extract the ones that the words that we intend to introduce and make certain they're aware of those and
Okay.
tailor those to the order that has been entered in any order that rulings that the court makes.
This is a
Okay,
mess,
thank you.
Char. Lord.
Down through 79, also lyrics.
A lyric,
Okay,
79 is
so,
a video.
sorry, then 71 through 77 are all lyrics.
Yes.
Okay, so the ruling would be the same as to each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture, actually.
Okay,
I can share it, well,
okay, thank
want me to
you.
share it, Charm?
Sure. Why is it that it shows on yours and I don't on mine?
All right, so they're going through evidence, which is now lyrics. What's this? It looks like we have a picture.
Okay. Okay, it's already in.
But I don't think the caption's
I
there.
couldn't hear you. What'd you say?
We believe that's in already. We agree.
Okay, Mr. Steele, did you say something about Bruton?
That's what I'm reading, but no, I said the same thing as Miss Adams.
Okay.
I cannot be 100% sure, but I
But
believe
y'all, all
it's.
right, well, if several of you over there think it is, and y'all think it might be?
The
also?
caption may not be.
Okay, any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to. But I guess when we find the original.
All right, y'all can let us know on that one then.
Judge, did we reserve on, or some of the 71 through 77 because we were going to check the order, Judge Glanville's order? I want to reserve on 74.
Okay, yeah,
And-
we did. We're gonna
Okay,
get the order and then come back to that.
all right, thank you.
Thank you. Sorry, y'all, somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
Mr. C, nope, it's not normal.
I don't believe it's in. I believe we've discussed it regards to another witness
Okay.
previously. I don't have any problem with it.
I believe we talked about this
I
picture
think we've
yesterday.
already dealt with this. All right. States Exhibit 83, what is it, Lima LL? Not that up on my native phonetic alphabet.
Probably next week, Wes.
I got it right.
Monday.
Lima. What is, I mean, I know what this is, but what does this have anything to do with?
Your Honor, that is the, I believe that is the gun, yes. That is the gun that was found at the Dunbar Center with Mr. Copeland.
All
in
right,
the
any
H&M
issue
bag.
on this?
Not if there's an appropriate testimony to it. So no, I don't anticipate any issue.
Okay. So I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you. Okay, and then 84 Lima A. Any objection?
If this is this the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st overt act with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So okay, LL is just a different view. Okay. So, and then there's another 84 LL
LL and then 84 LLA.
and then another 84 LL. Maybe that's a still, I don't know.
Let me
Oh, no, that's a gun. Maybe
So, okay.
there's a mislabel.
There's a
maybe.
mislabel, Your Honor.
Okay. Okay, so whatever that gun is will need to be
A different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
Alright.
That's it.
Okay,
Quindarius Zachary.
then we've got,
That's so funny. They say I'm Lee Jr. Honestly, I learned when you spend 2.5 years learning how to live stream from a person and streaming with the person, I mean, you pick up on some of their habits. Where do you think he learned about Topo Chico from? This one.
85 through 90 LL. Any objection to any of those?
One of them, we've already. So 85 LL is the interview of Mr. Kendrick.
Okay,
Yeah, and we've already dealt with
All
the
right.
PowerPoint, which is 86.
all right.
87 as well.
We've dealt with 87 already.
Yes. 'cause
Okay.
that's-
Oh, yeah, that's, okay.
we've not dealt with 88.
88. Any objection to 88? Evidentiary objection?
sure we'll be objecting to the commentary on this posting.
Well, except for the ones by Mr. Stillwell, I suppose, because so. Yeah, okay. We wouldn't have any problem taking out anything that Mr. Stillwell doesn't post.
Okay, yeah, I mean, that's gonna be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right. Yeah,
If the state would educate me on the relevance of Mr. Stillwell's posting there,
okay.
what they
so-
think it means, because I mean,
All right.
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right. So, Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Day Paradise, on March 28, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor, I
the bar that it
misspoke.
is.
Hang on, don't interrupt.
I'm withdrawing.
Oh, okay.
I misspoke. I thought they were saying that someone replied to Mr. Stillwell, and I thought
Okay,
they were
no,
saying that was his
She's
post.
taking all that off.
Okay, all right, I'm good, thank you.
All right, thank you. I think that's 100%. Anyway, not a heart. Had to get my glasses out for that one, but
I
I think the argument would be the same. Okay, so that objection's withdrawn. Long as, yeah, you just need with all of these to take off the comments. Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL? Well, 90 LL is not a photo, it's a video.
Dogs tied to the side.
Any objection to either of those?
Your Honor, as long as they keep my client's comment on that exhibit as well, where he
Good.
sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say his client says dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown maybe? Because I don't see it on this.
Yeah, I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's
Okay.
the other person posting that she's beefing with him.
What's going on is
Mhm.
these comments are in dark blue on the black background, so I'm
Right.
only seeing the white. So I'm seeing my client commenting, we beefing, which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue that Okoya having her way posted that, so.
Yeah. Okay. All right, how about 90 LL?
We'd be objecting to 90. I don't see I don't know what the relevance is of
Okay.
90
All right, there's a relevance objection to 90 LL
and 403.
and 403.
Judge, I think it's best if we just play this
Okay.
one.
Big B, Lil B, Slime, YSL, Crip Killer.
I mean,
That's Mr. Williams's voice,
Based on?
directing,
Let's not interrupt each other, please.
directing this child to throw up these gang signs.
Okay.
So that's what we.
So are you gonna have some kind of either somebody familiar with Mr. Williams' voice to say that's him, or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
We have Mr. Stillwell, we're gonna ask for a limiting instruction, if that's admitted.
All right, provide, proposed one, please.
On behalf of Mr. Williams, Your Honor, what
Mhm.
is the import of this? So I understand
Seriously.
it's prejudicial because a person may think that a young child using what I would consider gang.
I co-sign whatever he's about to say, guys. This is ridiculous. This is ridiculous. Yesterday we saw memes. Now we're talking about evidence. I really didn't weigh in on that one, but I'm saying something for this one. So apparently that's Young Thug's son. That's Young Thug's child, allegedly. And in the picture, the child is doing gang signs. And they're trying to bring evidence of the person behind the camera being Young Thug. Not a voice expert, not a forensic expert, just someone that knows what Young Thug's voice sounds like. And Brian's like, I'm sorry. What's the point of this? What is this proving? It's a kid. You want to put this in front of a jury? So let's go back to Brian. I couldn't hold that one in.
Language with their hand signs
Mm-hmm.
may be inappropriate, but why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence, exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr. Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations. And Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child, throw up B, YSL, Crip Killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a facade or not someone hitting on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child hold up these gang signs and so forth and so on, what appears to be gang signs. And again, this is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, you know, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor, we're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick. And
Okay.
we echo the comments made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffrey Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case, that this gang recruits young children, and this is what it ends up being.
Judge, I think there's a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posting.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, I mean, I'd be happy to look at it again because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about, you know.
Well, that's one at least that immediately came to my memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that image, but it was certainly at the direction of an adult, and then the child was.
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the one of the two videos that you saw on yesterday, and when you listen to the sound, it's exactly the same thing. The child is being directed, and in fact, it's the same child.
Okay.
He says Big B, Little B. He doesn't say Crip Killer. He doesn't say YSL.
All right, that is not cumulative if that's the only one that y'all had in mind. So that's, I'm overruling those objections. Okay.
Wow. Well, can we just,
that takes,
let's bring it in, chat. Kumbaya for a second. So the state is hitting an all-time low. Shout out to all the mamas in the chat, all the grandmamas in the chat, all the aunties. Listen, the women in the chat were like, hell nah. The daddies in the chat, uncles, all of y'all were like, all right, why are we bringing in Young Thug's kids? Right? So you saw almost every defense attorney object to that. Shout out to Matthews. He's becoming one of my low-key favorites. He's just like, hey, this is extremely probative. Remember what I showed y'all. There is a test for relevance. Is this important? Why is it relevant? What is it going to prove? Does it make a fact more probable, less probable than it would be without the evidence? Is it a fact of consequence in determining the action, right? For some reason, Love thought something like that was extremely relevant. Why? Because she's saying that because Young Thug has given the direction to his child to do something, and he is the alleged leader of this gang, that it shows that they're recruiting children young. I don't know what you want me to do. Yesterday was bad. The end of today is just worse. And then let me just point out one other thing. You saw Doug Weinstein say that he wants to do a 104, 105 instruction. What does this mean? That means you limit evidence that is not admissible against other parties or for other purposes. They're trying to fight to keep this out. For what? What do we need it for? And she literally had the absolute nerve to bring a child into it and to say that they are recruiting children young. Crazy, 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 crazy. Let's keep going.
There would have to be a proper purpose for
The
the
one in the chat, if you can hear.
guilty plea, which there could be one, but I didn't.
Sorry
hear
about
it.
that.
All right, is there anything about the factual acknowledgements here? Like I know that last one y'all were saying,
Thank you,
I don't
guys.
think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay, so this wouldn't be relevant at all unless they say, no, I didn't, or no, I never asserted
like-
that fact, or
so-
this would be.
So right, or that he was forced or he didn't
Right.
know what he was doing.
Right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're
I
talking
mean,
about.
yeah, and you can certainly, I guess, tender that if you want to.
Yeah, but
No,
the
I
other,
mean-
information is only, as we said earlier, if someone isn't truthful on the stand.
Right, okay, thank you. All right, the next item in there, I can't open, so I don't know what that is, but if y'all can open it and you know what it is and don't have an objection, then it doesn't matter that I can't open it.
Your Honor, we're talking about the third one down?
I was talking about the second one down because I don't know what that is. the one labeled like NT Fulton CODA and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed that one. Or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay, and I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but.
It's not certified?
Okay.
You mean of the transcript?
Yeah.
It's not certified. It's just a.
It's a hallway conversation.
Say that again.
It's a hallway conversation. It's not-
Hallway
it's not in
conversation.
court.
It's a
not like it-
130-page transcript of a conversation.
Oh,
Interview.
it's not a transcript of the guilty plea.
Right, no, it's an
Okay,
interview.
Thank you.
It's an interview. That's what I was saying. It's an
Okay.
interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his
Impeach.
recollection or impeach him.
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to. To the extent that the state is ever planning on just playing I understand targeted impeachment, but and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant,
Okay.
prejudicial.
And yeah,
things.
and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem, needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Interview itself.
Ah, okay. I opened it up and it shows a musical note. I guess that's just my media player. Okay. And then this last thing is a picture.
Photograph, yes.
Any issues?
Shout out to the briefcase breakdown. That is number one, a wonderful name, but this is an excellent comment. He says the dangerous issue is if this case is successfully completed, it can be used as precedent in future cases. This would be bad for, some of these rulings to come in, for this case to be closed, and for people to be able to wiggle around the law like this in the future in the state of Georgia. So the briefcase breakdown is actually making a really good point there, guys. It is sad. I don't like the fact that they're bringing in minors into this to prove, and this is probably where I cut out, to prove that they're recruiting children young, even though it's Thug's child. I don't know. I agree with a lot of you guys. I think it was low for them to do that. And I think right when I cut out, I was showing y'all Rule 105, where Doug Weinstein wanted to limit that by any means necessary. So it's crazy. She overruled those, but that's still on my mind. We got Instagram, we got memes, we have lyrics, we have kids. I think it was Cowboy who said that. These are the pieces of evidence that the state has. And these are the big ones, allegedly.
On this one. No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. couple of crime scene reports. Any issues on those?
Don't anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We are almost to the bottom of this grouping of 30. This needs to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National
Okay.
Institute of Ballistics.
Okay.
Integration.
He is a ballistics expert with a
Ni-
particular.
NIBIN is different.
It's a
Yeah.
big time one,
It's
right?
it's the one right before. It's not the actual firearms examiner. So it's a step before. It's a comparison to see if if these have the same characteristics.
All right, anyway, anybody have an issue with the evidence that's going to come in with this person?
I'm sorry, what is this? This is under, I'm trying to find out specifically where it's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters
Okay.
NIBIN chart.
Okay, I can't open that one either, but
Yes, and that's a summary of
okay.
NIBIN matches that were.
I'm having trouble seeing it in detail, but
Yeah, maybe because the black on the blue is a little hard to read. And we're all old and have old eyes.
Old eyes.
So is the question just kind of like, what does that say?
what is that?
So those are the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular scene. The black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there is one more person that will be adding to that, but we'll let them know well before we.
All right, well, if they're going to say the same thing, we don't need them both.
We won't. We won't.
also
We won't
sounds-
have.
All right, so with regard to this kind of chart, I guess, now that you know what it is there an objection?
I have one. Oh. Well, here's the problem, Your Honor. And before you were involved.
Before we let Max start cooking, shout out to Edgar. If y'all could do me a huge favor, say hi to Edgar in the chat. He drops $49.99 and says, "Hey, AV, still not able to gift the membership." Yeah, it looks like Google they haven't fixed that yet. For those that are unfamiliar with Edgar and what he's talking about, there is a membership gifting option. I know that DC was able to gift a few earlier, but for some iOS users, there is a known issue across YouTube. It's not just on my channel. Every live streamer is going through the same thing. For some Apple devices, you are not able to see the join button to become a member. And when you go to Super Chat or participate in the chat, usually there's a membership gifting option. But for some devices, that is not functioning. Google's aware of it. I've talked to them. I think it was Saturday about it. And it's not just me. So that's just an update. But Edgar, thank you so much for your super chat. And thank you for following up on that as well. Let's go back to Max and see what he is cooking up here. And again, thank you, Edgar. And thank you guys for shouting him out.
This case, a lot of these prior incidents were Detective Dennis took the stand and the state brought out an easel and they wrote down all these different case numbers and they went through them real quick. On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that up. Okay. And in this, and as a gang investigator, I determined that that was part of this beef. Okay. We for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence. So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right, is
And
he,
violate the Confrontation Clause as
okay,
well.
is he going to be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this going to get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD or they're taken down to ATF to do that comparison. What Kilgore or the ATF NIBIN person would say is this shell casing here was consistent with or had the same general class characteristics as this shell casing over here that was found at this scene, and produce what we call a hit.
Right, so is Kilgore going to be able to testify that for each of those blue boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, or Kilgore or ATF did that initial NIBIN comparison. I'm not sure what the objection is. If we're not going to have him talking about something somebody else did. If that's
okay, so I think one of the objections is that thus far we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is going to have been laid in evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up, talking about what they collected.
So it sounds like by the time we get to this, that will have been done.
Be a two-way connection though. It can't just be, we collected, I'm using an example. We collected, certainly we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident. So we'll know what was collected, and it was sent to Kilgore and it was sent to NIBIN, and we get that. But if they're going to say, well, it matches another crime scene, the expert in the lab can't say that unless we know they can say, I guess, presumably it matched another bullet in the database or something like that. But unless there's a link to an individual crime scene, yes, we collected this and it matches up, that's still based on hearsay. Kilgore or whoever the expert in the lab would be testifying based on hearsay about where that other ballistic evidence was collected from, unless we hear from the person who collected the evidence.
And we would. So I don't know why, I don't know why we're arguing at this
We're
level.
we're not arguing, we're trying to clarify. So for instance, and I can't see them, but the very top two on there, you know, they apparently say, okay, this crime scene A and crime scene B. We will have, and this person, Kilgore, will be able to say, I did a comparison of bullets from crime scene A and bullets from crime scene B, and they're consistent with having been shot from the same gun or something similar. The question on the floor is, okay, will we have already heard not only the chain of custody for Kilgore getting the crime scene A bullets, but the chain of custody for Kilgore getting the crime scene B bullets?
Yes, so we would not have, yes, all of the foundation, I don't think chain of custody, like, specific, like every link in the chain would be necessary, considering we would have the crime scene technician who would have collected it. We would have the testimony that when the crime scene technician has collected it, it comes to my department, my being Kilgore. This is the case number 150261534. And I compared it to case number X.
Okay, so we will have both, just so I make sure I'm understanding you. We will have a crime scene tech from crime scene B say, I collected all of this and I gave it to the crime lab, or whom, I don't know if this is.
I put it in evidence.
I put it in the, box or whatever they do. And then we'll have Kilgore say, here's the way evidence gets to me, and this got to me that way.
Yes.
Okay, does
Yes.
that answer your question? I mean, I guess it's yet to be determined whether we will hear all of that evidence, but the objection is going to be, if we don't hear all of that evidence, he can't testify to this. So do you understand that?
I'm sorry, Judge. The objection is that
if we don't hear the foundation that is both crime scene A tech giving the evidence to Kilgore and crime scene B tech collecting and giving the evidence to Kilgore, and then Kilgore saying, I got them both in the regular course and I compared them, here's my conclusion, that there's going to be an objection that he can't testify about crime scene B.
And to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links included as
Sounds like
evidence.
that's going to have to happen. Now, it does not need to be, I don't think, a whole, as if this were the crime on trial.
It would just be,
It can just be, I'm a crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected
I
this
went
one.
to this crime scene at this date. I collected
Right.
this evidence. I gave it to whomever.
Right.
Which should take 10
minutes.
Okay. All right. She plans to now do all of that. Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore? All right. Then our witness number 30 on this list is Underwood. Is Underwood also a NIBIN expert?
She's not. She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one, she was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked.
Okay.
To have it tested over there.
Okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer, and she's going to be supposedly or potentially the same treadmill of information about YSL and IFGang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a
so she
gang
is,
expert?
That's what I
She
said.
may be
She's-
a gang expert,
Wow.
but is she gonna testify as a gang expert?
She,
Wow.
I don't anticipate getting into anything overlapping. And actually, we were, before this last conversation, thinking of not calling her at all.
Oh,
But-
my
Okay,
God.
so she would be chain of custody only?
Some chain of custody, and at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time as to their knowledge.
Okay.
Detective Underwood had an earlier knowledge of this particular.
You know what? Thank God Brian said something. I'm stopping her. I can't. Brian said something. He said, this is repetitive. You have 5 people that work for APD. They work together in the same office. Why do we need 5 gang experts? And the judge is asking her about that and just got her again because she was about to let it rock. She's like, oh, yeah, we were thinking about not having this person testify. Ma'am, it's too late for that. And then now she's trying to clean it up like, okay, all 5 of these people are going to testify to something different. You know, like just testify to something different. She's trying it. She's trying it. It is very sad that the judge keeps letting her get away with this crap.
Particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time.
Okay.
Detective Dennis and Gaither were 2 people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, you know, during the time of this
Right.
indictment and even after, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying. To have gang experts who have an expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlap.
Shout out to Sammy. She caught this. Sammy's like, look at Doug. Doug is like me. Doug's glasses are off. What she is saying makes 0 sense. Why do you need all these experts that do the same shit? Sorry for the moms. For the moms that are in the car with kids and people that have kids, mute it for like 10 seconds. The same shit over and over again. Thank God Brian just said something, because if no one said anything, she would have gotten that in. I can't believe this. This is an absolute nightmare.
Doesn't in any way make what they're testifying about so cumulative.
I understand. All right, so has this person already testified as a gang expert?
She's not. She's just been
Okay.
qualified as one.
Okay, so you do not anticipate having her testify in her gang expertise role, just as custodian of whatever this evidence and getting it from one place to another then, is that right?
At this point, like we said, at first we were, and then we were
Okay.
like,
All right, and I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor, as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of, or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN leads new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed
Okay.
that in the
I-
folder.
Yeah, I mean, they do, again, I don't know why, but I can't open a lot of these on this computer, but is that the same thing or is that something different?
It's a colorful picture showing like a flow chart involving the information that Kilgore has.
Generally the same.
It's all the same information.
Is
It's
this-
just presented
It's
in
more
a,
colorful?
yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
It is.
Okay, well, you can always switch the witnesses that you were going to use that for, but yeah, we don't want to see it twice, but okay. All right, that gets us through the first, our first 30 bucket.
We haven't
No, it
done Mr.
doesn't.
Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. All right. Trying to just look back through at things we need to revisit or visit for the first time.
Alabama Gigi, she letting too much in. I don't like that at all.
Okay, so I think this is a good place for us to stop today. And then, tomorrow, other than the potential hearsay and CAD reports, which we can take up, we can either move to the next 30 and do the same thing with regard to them, because they're going to have to be done at some point when the jury is out. Or y'all don't seem to want to reach the wiretap stuff yet, but as quickly as y'all can specifically identify that and get it to the defense, then we can get to that. I think it'll be easier once they actually have targeted information about that. Yes, sir.
Know why necessarily, but the state specifically identified jail calls for my client as they've stated, which is, I believe, 13 or 14. I've reviewed those.
We're right. Okay, so tomorrow we can tackle
right.
those. Okay.
And I'm just warning everyone, other people, not in a, I'll just say it affects.
Alerting everyone.
I'm alerting everyone that it affects more than just my client.
Okay, so everyone might want to take a close look at those before tomorrow. Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient tomorrow, anything like that?
Your Honor, it's State's Exhibit number 55W, which would target the child with the hand signals.
Okay,
If you can, it's 55W has been shown to the jury.
would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right. Is Mr. Kokomo going to play that for us, or is he, I don't see him anymore. I think the state's going to try to find it.
I don't remember yesterday's, I just don't remember that, but it's one that was played months ago. Yeah, you come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mhm.
Okay, so I believe that my concern about when it's dealing with the RICO conspiracy in Bruton, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed FED period APPX 739. It's in Division B as in Barry. And it's 11th Circuit 2015. And the 11th Circuit found that we reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Bruton. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Bruton's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the
Right.
crew, and I cannot find a case that supports that.
All right, I appreciate you bringing that to the court's attention. Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because
What just happened there, guys? So Brian, earlier, we had this whole debacle yesterday with Yak Gotti and some of his statements that were made, particularly about some of the other defendants and how they did not want those statements to come in. Brian is such a good attorney, guys, and we all have to abide by this. Even if you make a mistake, it's in the model rules of professional ethics. I show you guys that all the time. I had to take a test to pass that before I could even take the bar exam, right? Now, Brian made a mistake. He cited the law incorrectly, and he could not also find a case that was directly on point to support his argument. And what he just did is he found a case that shows that he was wrong, and he gave that case to the judge. And he said, I made, my argument was rejected. Here's another case to support that. I just want to make it right. And the judge is like, I appreciate your candor, because every attorney is supposed to do that. Even if you make a mistake, you're supposed to make the best effort and put your best foot forward to correct that and put it on record. So Brian was actually, that was great that he did that. Let's keep going.
I have to say, unfortunately, everybody doesn't do that. So thank you for doing that. Okay, do we have this ready to play? Oh, okay.
That's a successful lifestyle. Oh, yeah. Real sleep, aka bleed, nigga. Yeah. Man, but we do this every day. Kitchen, yeah. Fuck the kids. I thought you were gonna put on the camera. Go on the trench, man. Yeah.
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more. But I don't think that that shows the same thing as the other piece of evidence that we were talking about. So Thanks, but my ruling stands on that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
Yes.
one thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily, though.
Great. Dennis, number 74. Mr. Harvey, was that one of the lyrics issues or was that a different item?
Well, it's lyrics, but it's a video.
Okay,
Thank you.
thank you.
All right, I think that they are done for the day, guys. Let me just skip ahead. They are. Well, oh Lord. We made it. We have made it, guys. What a long, long day. And it was a half day. The day started with Brian Steele doing an oral argument in front of the Georgia Supreme Court on another case he's working on. So we started at 12 o'clock. In the meantime, if you guys are joining us just now, I'm just going to give you a quick recap, read some super chats, and your girl's going to go eat and then bring YSL Luna out for a walk. So check this out. Here's what happened. I bought a forensic data expert on today. We spoke for about an hour and a half. Chat had some amazing questions for him. You guys did so well. We had an excellent conversation. But what it did is it really shed some light on the different experts that are available in these types of cases. His name was Spencer. He was amazing. We had dropped his contact information in the description box because one of the other services that him and his team do, not only for defense attorneys that are out there trying to hire an expert witness, but for the everyday person. They do forensics, digital work. So if you have a loved one that passes away, you want to get into their phone or anything that's encrypted or locked out after they pass away, they do those type of services for the everyday person too. So we talked to Spencer. A lot of things that we talked about with Spencer today came up in court. So it was really nice to be able to do that. And that's also just something that I'm going to start focusing on. I know you guys could watch this stream wherever you want, but I want to bring value to you. So I am going to start bringing actual practicing attorneys that are my friends into this space so they can come and chat with y'all and give a different perspective, not from a YouTuber's perspective, but from an actual professional attorney's perspective, both on the ADA side and on the defense side. I'm going to start tapping into this network and bring these folks on. So this is going to be really, really, really cool. We watched a lot in court today, more shenanigans. We're looking at evidence that was either coming in or coming out. We saw Simone and, DA Love, CDA Love go back and forth. Again, not much has changed. Lots of moments of being unprepared. Lots of shenanigans coming in. The shocking moment today was them trying to bring in pieces of evidence, including Young Thug's kids. Young Thug's kids were throwing up gang signs, allegedly. But what we just saw at the tail end of the day was the child who looked to be about between 2 and 4 do that themselves. And it wasn't anything bad. I think he had just did the nose thing, right? So he did that and he did it himself. He was not directed to do it. The question became if Young Thug is recruiting children to be a part of a gang very early and starting them young. I think that is probably the most controversial thing that we saw today, unless you guys tell me otherwise. I mean, that was insane. I'm going to catch up on some supers and we're going to go ahead and call it a day. Tomorrow's schedule, it's likely that I'll break it up in the daytime. So we'll probably do 9 to 12 and then we'll take a little bit of a break and then we'll do a second stream from 12 to 5. I may bring a few of you up. I know, Edgar, if you're watching, I saw you send me a note yesterday seeing maybe we could revisit that snitching conversation. I think the chat would really, really appreciate that. But let me pick up where I left off. Shout out to Gavin with the 199 says, I'm confused why none of this is ready before trial. I mean, Gavin, that's the thing. The case is so big. They should have had all of this ready. The issue is when Glanville was in charge, I think they were just doing it as they go. That's why we're so behind. And that's why all of this stuff is happening. We had to take a week off because this can't happen in front of the jury. The jury's off this week. They're not watching this, but this is administrative stuff that absolutely should be done before trial. Great question. Shout out to Nurse Janice in the UK. She says, do you think they would do any of this after court? Never prepared, embarrassing, the shame. My boss would go mad if I carried on like this. AV doing great. Thank you so much, Nurse Janice. And you're right. Yeah. I mean, they do work. Someone else had another question like, do these attorneys sleep? This is tiring work because guess what? After court, from 5 to 7 or 5 to 8 or 5 to 9, they're preparing for the next day. So there's a lot of work to do on the state side. Mush is back with $5. He says, at this point, the DA needs to have its own merch. And why not start with the t-shirt that says, I'm not prepared for these crimes at all, ever. I co-signed that one. That would be really funny merch. Shout out to Sally Sunshine with the $5 super sticker. Appreciate you, Sally. You are the best. Thank you. Shout out to Audrey with $4.99. She says, how many days did the Baldwin case last? Like 2 or 3. With Brady evidence, all of that. And a few of you guys have been commenting on the Baldwin case. Like, just throw it out. I mean, at this point, like, just throw it out. But again, Fani's team has so much invested in this. The state has so much invested in this. Even the Georgia Fulton County legal system has so much invested in this. They've already spent taxpayer dollars. We're already this far in. That's why Whitaker is letting it ride. Interesting. Dirty Jesus is on this side with $1.99. Says posting crimes. Some new, it's new shit. And these little ninjas retarded. Yeah, I hear you. Shout out to Candy Yates, who joined us a little late with the $19.99. Says, hey, AV, it doesn't prove anything really to submit lyrics. The person performing may not have even written those lyrics. That's true because some rappers and artists have ghostwriters. And Brian still did bring this up. He's just like, hey, you have to think about it. It's not going towards intention, right? So that is interesting. And again, they're only bringing in certain pieces of lyrics that are describing crimes or describing Little Woody in the songs, things of the like. Shout out to California Grown. I like that name with $4.99 super sticker. Thank you so much, sis. Hope you are doing well over there in Cali. Go Roro. $4.99 says great commentary, professionalism, and dedication. Appreciation to the 100th power. Go AV, go. Thank you guys. You guys know I work really hard, still directing my team to do what they need to do. Those are my after hours, right? And also just kind of really thinking about how to educate y'all on the law, how it works, coordinating with other legal professionals to get them on here, scheduling those interviews, all of that. In my spare time, I help some of y'all that want to become content creators, people that want to go to law school, business advice. Your girl is always working. So I really love what I do, and I wouldn't do it if I didn't, right? So thank you so much, Roro. California Grown became a member. Welcome, sis. Welcome to our squad. You're going to love it here. I know you will. Jeff J drops $1.99. Thanks, Jeff. And thanks for all your comments today. You did really well. I loved the sarcasm, but you had some really, really good comments and questions. Dirty Jesus $1.99 says, we're going to call you co-counsel. Thank you. I appreciate that. Philly Chica, I did star this because this is a good question. She says, why can they mention Lil Wayne and Birdman without calling them to the stand? They did. The defense challenged them on this. I think it was last week or the week after. They can talk about the incidents, but they cannot. There's no statements or anything from those individuals. I don't even think that Lil Wayne and them actually filed charges. The state is bringing this in as an incident. So they can talk about it to an extent, but they can't go pretty far. Edgar, again, thank you. We try to get around that membership. I did see DC say that you could do it from a Mac. And I also saw a few others say that as well. So try that if you can. If not, we're just going to have to wait until YouTube fixes their problem. Shout out to Big Papa Zoe with the 5. Says, if we're going to call out the state for these BS evidences, we have to call out the judge for allowing in the BS too. These judges are biased for real. Like Big Papa Zoe, he's right on the money with that one. That's a really good comment as well. She is allowing a lot of it in. People have been asking me about my opinion with her, and I pulled her stats. I showed it to y'all probably about 2-3 weeks ago, right when she got on the case. And I was very curious about what her ruling data looks like. It was actually 50%. It's in the middle. Whitaker could go either way. But for you to let people bring in memes as evidence, like, you know, she did push back on the kid thing a little bit today. I think she could have pushed harder. I don't think she pushed hard enough. Like, I don't think that should have come in at all. But we'll see how the state proves that. So it's going to be interesting. Shout out to Deet with the 199. Says the state needs a mental health evaluation. I mean, Love was struggling today, and I don't know what her and Simone were going back and forth on, but you guys know infamous Miss Sylvia, who's in the courtroom almost every day. She says that they have a pattern of fighting each other all the time. All the time. Shout out to Red Bunny with 199. Thank you, Red Bunny. Says, can the parent object to them using a minor's image? I mean, Steele's objected because Dog's the dad. You know, I don't know about the mom, but the mom probably certainly can. But the issue is with the first video. I don't know if y'all remember seeing that video yesterday. Remember we saw a pregnant woman with a gun? Like it gets real in Atlanta. But yeah, there were too many people in that video for the consent. But somebody else said it would have been nice if they blurred the child's face. I think that would have been more appropriate because now the world has seen Young Thug's son. You know, so we have to really think about these kids when it comes to what is being broadcasted. And I don't think that the court and even just the broadcasters in the room realize that it's still a child, and we need to be thoughtful about that. So a little bit of an unfortunate thing that we saw today, but hopefully they think about this in the future. Shout out to Christian 199 says, how will Woody act during cross-examination? Well, we are waiting to see how he's going to act. I did do a poll with y'all recently to see if he was going to, if y'all thought he would cooperate with the defense lawyers. He is scheduled to come back on Monday. We have a little bit of time. So in the morning, we'll probably do a few more hours of the crazy videos. And then I think Brian Steele might go up first. We will check out how they're going to cross-examine him. But it's my opinion that he's probably going to do more of the same bullshit. Like, I don't recall, blah, 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 what you mean, whatever, all those things. But I think that these defense attorneys have had enough time to evaluate that, prepare for it. And they've had almost 3 months of time go by where they see what little Woody's doing. I thought it was remarkable that Brian Steele's team on Monday had already knew about Little Woody's interviews that he's doing all over on YouTube over the weekend. So they knew what the context of that was. They're prepared. I think that they've been doing their homework on him, and they are very, very ready and willing to jump in and ask him some questions. This is a good question. Breezy F Baby says, how would AV know how Woody would act? This is based off of past behavior. So to your point, does anyone actually know? The answer to that question would be no. But if we're basing it on prior behavior from courtroom analysis and behavioral science, that is my analysis from that point. So excellent point there. A few of you guys hit me on the Cash App, so let's go over to that side. We're going to take that down. Shout out to Danielle again for sending me. She's been super supportive all day. Shout out to Anita with $5. She says, doing a great job from music has a meaning on YouTube. It's a good point. It's a really good point. Anita, thank you so much. And then shout out to Liz, one of my faves. She hits me with $1. She says, this trial reminds me of 6ix9ine's trial. You guys have been talking about that a lot. Excellent analogy. Excellent analogy. Shout out to Akins who sees it. You see me working 7 hours. I'm going in, I'm grinding. So thank you guys so much for watching. I really want to thank DC, who is your stream sponsor. We've had many stream sponsors this week. Also, just as an accomplishment, you guys got us over 45,000 subs yesterday. So welcome to all the new people. Thank you guys for all of the support. We were number 10 as far as live streamers in the United States yesterday. I know Lead is not here today, but I would not be able to get any of this done, have this work ethic, know how to do this, hold it down for him if I had not learned from him. So we're going to end on a good note, but if y'all could do me a huge favor and type TLA in the chat, that is just my, spreading the love and appreciation for him, all that he's taught me. If you guys know, I came up under Lead. You could see it on his community tab. He's always supporting me and supporting this channel, and always, always, always sharing my streams when I go live. So thank you guys so much for typing TLA in the chat. Really want to appreciate all of you guys for being here today. We will see you tomorrow morning. Stay safe out there. I'll see you in the next one. Bye.